order of 5th of
150?
August, 155. It's the first matter under witness action. By your lordship, last order of 5th of August 2025. This matter was fixed at 2 p.m. today. But today, as I find, there is an appellate side list. If your lordship would be kind enough to fix some other day. It's an undefended suit where the plaintiff's witness should be examined.
Yes, because the appellate side, it has to
Yes, I understand. My witness has also come down. And unfortunately, I told him that we can't accommodate him today.
Item number 155. Though by an order dated 5th August 2025, this court fixed the matter today at 18 September 2025 at 2 p.m. for witness action, but due to determination of appellate side, the matter could not be taken up for witness action. Counsel for the plaintiff raised for fixing another date and time so that the plaintiff's witness can be examined. In view of the submission made by the counsel for the plaintiff, let the matter give the date for witness action. Not before that, कोई नहीं है.
If I get 1 day, at least for 1.5 hours, then I'll finish off the entire witness action. I was ready to complete it in a day.
डेट नहीं है. हाँ? अभी क्या डेट है? 23 फिर वही छुट्टी आ जाएगा. साढ़े 12 क्या है? कब है? 27 November 12:30
Very good.
for witness action.
Your Lordship, this is the partnership matter. Your Lordship took the notes yesterday and made it CAV. So in that order, Your Lordship, there's a wrong recording. So on the second page, it's written counsel for the defendant number 2 and 3 and counsel for the legal heirs for the deceased plaintiff number 1 have filed the written notes of argument. So defendant numbers 2 and 3, it will be plaintiff number 3, Your Lordship. I am plaintiff number 3. We filed our notes.
I am defendant number 2 and 3, Your Lordship. We have not filed it.
And counsel for the plaintiff number 2 and 3.
Plaintiff number 3.
Plaintiff number 3.
Plaintiff number 3 has mentioned the matter for correction in the order dated 17 September 2025 and submit that. क्या हुआ? Defendant number 2 and 3. It is a plaintiff number 2 and 3.
No. It will be in place of defendant numbers 2 and 3. It will be plaintiff number 3.
क्या बोला? Submit that in page number 2, paragraph 1, line number 1. It is recorded that counsel for the defendant number 2 and 3, but it should be recorded as a counsel for the plaintiff number 3.
Yes, Your Lordship.
Plaintiff number 3 instead of defendant number 2 and 3. In view of the submission made by the counsel for the plaintiff in the order dated 17 September 2025, page number 2, paragraph 1, it is recorded the counsel for the plaintiff number 3 instead of counsel for the defendant number 2 and 3. This order may be incorporated with the order dated 17 September 2025. Yes.
May Lordship's kindly.
Not mention the matter. Yes.
May Lordship's kind leave to mention one matter. Your Lordship was pleased to pass an order on 12th August 2025, Your Lordship, regarding the paper publication for substituted service. But Your Lordship, there is no returnable date. We have already made the publication. Any date, Your Lordship, may be given as a to be mentioned so that we can file, Your Lordship, the affidavit of compliance. We have complied, Your Lordship's order.
Counsel for the plaintiff mention the matter and submit that by an order dated 12th August 2025, this court allowed the plaintiff for publication the notice in the newspaper, but returnable date has not been given. In view of the above, in the order dated 12th August 2025, returned may be read as 23rd September 2025. 23rd September?
23rd. Yes, yes.
May I have
Let the matter appear on 23rd.
May I have a lordship's leave to mention item number?
Just Kalyan, यहाँ का date note कर लो 23rd September.
Lordship's leave to mention item number 43 of your lordship's commercial list, Manad, for extension of interim order which has expired yesterday. Manad, we missed it. But we are mentioning upon notice. Even yesterday we had served the mentioning notice, but Manad, I couldn't come at on time.
For the other side.
But Mr. Rajoshri Dotto and Asif Hussain is appearing. It's a Flint group matter, but they have not. But I've given notice. But I can again, ask them to be present.
Come before rising today.
But at 1:15, because the second half lordship has appeared. So grateful.
It's not I appear for the decree holder in this matter.
Yes, what has happened?
She's the main person.
6th November. In the warrant. The warrant issued. Issued. And what about who is the content number?
Actively participating. He's the only witness to the case. She's the CF.
Who is the contempt now?
No, this is an execution proceeding.
Yes, who is the?
I think, Malad, it is one of the whole-time directors of the judgment debtor company, Miss Malovika Shengupto, Malad, who had even been examined before your lordships on previous, before a coordinate bench, before the trial court. And Malad, the warrant has been issued. Malad, I think the difficulty is, Malad, what the department must have indicated is because whether a female or a woman, whether she can be arrested pursuant to a warrant of arrest initiated in an execution proceeding. There is a provision in the Code of Civil Procedure. There is section 56 of the Code of Civil Procedure. But there are certain exceptions. Because the section starts with the wording, notwithstanding anything contained in that part. So if I am able to satisfy your lordship that there is something contrary to the other part of the Code of Civil Procedure, then your lordship has been exactly correct in passing the order.
But what is the notwithstanding?
Yes, if lordship kindly takes order for order 21 rule 41.
CPC दो.
ठीक है एक छोड़ो एक बोलते हैं.
Order.
Yes, kindly see the first provision.
Order 41.
Order 21 rule 41. Because this is the provision where I can examine the judgment debtor regarding the property where the judgment debtor is a corporation.
Order 21.
Order 21 rule 41 kindly sees the head note examination of judgment debtor as to his property.
Correct.
Now kindly see rule 2 where a decree for the payment of money has remained unsatisfied for a period of 30 days, the court may, on the application of the decree holder and without prejudice to its power under sub rule 1, by order require the judgment debtor, or where the judgment debtor is a corporation, any officer thereof, to make an affidavit stating the particulars of the assets of the judgment debtor. But here, I can proceed with one of the officers of the corporation in terms of order 21 or rule 41 sub rule 2. This perhaps will be an exception to section 56, because if the affidavit of assets is not filed by a representative or an officer of the corporation,
there is a direction of affidavit of assets.
Yes,
Direct warrant, they are not appeared and warrant was issued.
yes, my kindly gives me.
I don't think so.
Warrant of arrest can issue.
They are not appeared and warrant was issued.
Oh, Malad, they were evading services. That is
Correct.
recorded in the order.
Correct, they are not-
First time service Nilo, when I moved.
But may I do this, Malad, may I come back, Malad? There are few provisions. I'm quite sure. I'll just.
But I am what I am going to do instead of warrant, I am recalling the warrant. A subpoena will be issued from the court. If they are appearing, it is okay. If they, in the subpoena also they are not appearing, automatic notwithstanding anything, then the warrant will be there. Subpoena will go. Let the
But
subpoena.
the only difficulty is that the execution application, Malad, will become redundant because this is the only person who is available.
She's the main.
She is the main person, whole-time director, and Malad, we have checked up the portal of the Ministry of Corporate Affairs. But this is we have downloaded today. But she is the only person. If Lordship kindly takes Malad, the next page, Malad, serial number 2, Malovika Sengupta, whole-time director. This is the Malad, difficulty. And Malad, it is Malovika Sengupta, Malad, who had come forward to depose on behalf of the defendant during the course of trial.
Absolutely, this is the deposition. Several.
Okay. So
But kindly keeps the warrant pending. Malad, I will try to demonstrate to your Lordship that perhaps, Malad, it will be permissible
many
to
persons
proceed
are-
against this woman.
against how many persons? So whether warrant has been issued to all, to lady also?
Subject to Lordship direction.
No, whether issued or not. No, it has been dispatched.
No.
Not dispatched. For all others also.
This is also prepared.
When is the returnable date? No. So I am keeping tomorrow. Let come tomorrow.
Tomorrow.
Come.
Grateful.
My lord, item number 2, my lord. It's presentation for plain, my lord. I'm humbly
Yes.
My lord, I'm humbly seeking leave under clause 12 of the letters patent, my lord. My lord, in this matter, the plaintiff's registered office is within the jurisdiction, but the defendant's residential address as well as the principal place of business is outside the jurisdiction, my lord. However, the cause of action has arisen partly within jurisdiction and partly outside jurisdiction.
How within the jurisdiction?
My lord would kindly take page number 15 of the plaint, my lord, paragraph 23. My lord, the registered office of the agreement between the parties was concluded in the registered office of the plaintiff, which is within jurisdiction, my lord. My lord, the purchase orders were placed on the plaintiff within the jurisdiction, my lord. The invoices were issued by the plaintiff within the jurisdiction, my lord.
When the last payment was made?
My lord, the last payment was made sometime around 3rd August 2024, my lord.
20?
To 3rd August 2024, my lord.
24.
My lord, even the part payments were received at the bank account within the jurisdiction, my lord, and the demand notices have also been issued by the plaintiff from within the jurisdiction.
The plaintiff has filed the present suit praying for decree for a sum of rupees 13,97,753 along with interest at the rate of 18% per annum. The plaintiff submit that the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of the court. He submitted the part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. He further submitted that before initiation of this, before filing of the suit, the plaintiff has initiated the pre-institution mediation, but it was ended as non-starter report, and the mediation center has provided non-starter report on 23rd July 2025, and accordingly the suit is filed. She prays for leave under clause 12 of the latest patent 1865. Had the learned counsel for the plaintiff peruse the materials on record, this court finds that the plaintiff has already initiated pre-institution mediation process before filing of the suit, and accordingly non-starter report has been provided by the mediation center due to failure of the mediation process. It is further found that the plaintiff is within the jurisdiction of this court and the defendant is outside jurisdiction of the court. Part cause of action arose within the jurisdiction of this court and part cause of action arose outside jurisdiction. Considering the above, leave under clause 12 of the latest patent is granted. Plaint is admitted, subject to scrutiny by the department.
Grateful, my lord. My lord, the last payment was made on 30th of August 2020. Grateful, my lord. Deeply obliged.
This is my application, my lord, for contempt. My lord, on the last occasion, your lordship would recollect, my lord, there was some issue. This is my application for contempt, my lord.
Yes.
On the last occasion, your lordship would recollect, my lord, they had, before the last occasion, the alleged contemptor appeared in person, went to the box, said that they would be making all the payments by the 14th of August. Thereafter, there has been nothing which has been forthcoming. And on the last occasion, I think my learned senior friend had appeared. There were some issues with regard to the Vakalatnama and all. But my lord, at the end of the day, my lord, we are yet to receive any money. So my lord, the violation of the order continues, the violation of the undertaking continues, everything continues.
My lord, I have already filed my Vakalatnama in this matter very recently.
Yes.
Led by Mr. Kushuk Chatterjee in this matter.
You are
My lord,
appearing for?
I'm appearing for the contemptor. My lord, I have already got the affidavits with me, which I'll served upon my learned friend, and I'd like to file it before the court. I've also my application is ready, where I have proposed to sell one plot of land as per the honorable plan, then pay the.
My lords, if I may, on the 13th of June, my lords, because there was a restraint order existing, on the 13th of June, after the contemners had pointed this out, that because there is a restraint order, they were unable to sell any of the properties and get the proceeds of the sale out. My lord had directed that if there is any such sale that has to be done, the party should approach the honorable court with a draft agreement of sale and with the proposed purchase. My lords, we have prepared that application. Unfortunately, it could not be filed on time, my lords. The application proposes there is a particular plot of land close to Chennai that has been identified. There is a purchaser that has been identified. And pursuant to negotiations, the figure has been settled at 5 crores, of which, my lords, 50 lakhs is something that I'm carrying today. I'm carrying a demand draft of 50 lakh rupees today. The purchaser has said the remaining 4.5 crores will be made directly over to the petitioner within a period of 120 days. So the outer limit is 120 days, within which the remaining 4.5 crore rupees will be made over to the petitioner directly. This is the sum and substance of the application, my lords. 3 affidavits, each for contemptors 1, 2, and 4. Again, my lords, we are carrying that. This is also the affidavits by the contemptors to say that this is the transaction that is being proposed, and subject to this honorable court granting that permission, my lords, the parties then effect the sale within 120 days period, and the remaining monies will be paid and the debt will be satisfied. So that is what.
By 120 days, let he be remain in the government house.
Beg your pardon?
Let he be remain in the government house for 120 days, and I will allow you to, whenever necessary, you go to the concerned authority, take the signature of the.
My lords, the only difficulty is that the purchaser that we have.
Because here, court has no faith on these persons. Either you file the affidavit or you give any
My lords,
security.
I understand that. My lords, I understand that the assurances have been given.
120 days is unimagination.
Because that is, to the best extent possible, my lords, this is the transaction, because given in the given circumstance.
Fifth counsel appearing today now along with the new advocate on record.
In the given circumstances, my lord,
because in the meantime, might have been gone through the record. What is the conduct of the contemptor? And you are also came to know from the bar what.
My lords, I have gone through the records. My lords, there is
how the court is proceeding with the contempt matters and the execution matter. This court is specifically.
My lords, I completely bow down to that, my lords. My only constraint today is that the company, which is the defendant in the civil suit, that is CIRP of that company is imminent. Given these proceedings, my lord, in the market, the marketability of the properties has severely gone down. So it is after an immense amount of effort that I have found this purchaser who is ready and willing to take this property. And any coercive action, my lords, respectfully, it will deeply impact and affect this transaction that we are proposing. So ultimately, my lords, what will happen is that the money that we are
2 months has passed. He has taken given undertaking that he is going to sell the land. 3 months has been
My
passed.
lords,
So again,
those-
you want the 120
those
days, 4
assurances,
months.
my lords, respectfully, they could have been overzealous, ambitious, but as of now,
He had no courtesy to appear before this court.
my lords, he's here today. My lords, he's here in person.
Not today is appeared person. I am taking the custody because the warrant is pending. How he is appearing without surrendering? I am taking the custody where there is a warrant, and you being the advocate, you bring that. I am taking the custody. There is a warrant. Where is the Sarif? Let he taken into custody.
My lords, my only humble request would be that if this, the only way to purge the contempt, my lords, is by paying this.
Sir,
5
first
crores.
of all, you satisfied me. There is a warrant and warrant has been served, but he has not surrendered.
He's surrendering today.
Where is the surrender? Where is the surrender?
My lords will allow me some time and we will get the process done. My lords, my only request is that, my lords, today my lord may not take any coercive step. My lord has been kind enough all these during the process of the contempt. Sincerely, my lords, this effort is being made. One last opportunity may be accorded so that at least this transaction can be.
After 120 days, another advocate, 40,000 advocates
my
are
lords,
there
because
in the Calcutta bar.
my bona fide,
Another
I'm placing my bona fides.
come and he will take 240
My lord, I'm
days.
placing my bona fides. I'm carrying with me a demand draft of 50 lakh rupees, which is a part payment out of that 5 crores already. So this is something that a third party investor has already paid. He's already out of pocket in that sense. So of course that transaction will be consummated, my lords. Because from a business efficacy sense, this does not make sense. Of course, the third party investor having paid 50 lakhs today, he would want to
let it be in Calcutta, and he will enjoy the Durga Puja of this in the meantime in the government house. He will know how the Durga Puja is
My lord,
celebrated in the West Bengal.
My only request with
He
folded
knows
hands, my lords, I can only make
he
that
knows
request.
with regard to the festival of South India. Let he know the festival of the West Bengal also. That is a big festival of the once in a year. Then he will enjoy in West Bengal by living in the government house. And I will allow you whatever the I will allow you to meet the person in the government house along with the proposed purchaser.
My lords, he will surrender to it. My lords, just allow me the time of during the course of
Yes,
the day.
Mr. Gupta, what is your contention?
But all I can say is with the agreed rate of interest as per the affidavit file, it is around 6 crores which is dividend payable. While Learned Junior is there with the calculation sheet with the agreed interest. I am not claiming interest as per the suit, nothing. Principal, we have already given a haircut. Principal outstanding is 4 crore. With the defaulted interest, it's 1 crore 92 lakhs. As per their affidavit.
Yes.
So this is playing fast and loose with the court on several occasions.
And my lord, the same with my lord, Mr. Gupta's leave, my lord, the same proposal was made from 13th of June with regard to sale of the property. 13th.
That's I'm telling. The 3 months is already passed.
13th
120 days is over. Now again 120 days. Now next time the other advocate will come and he will take the 240 days.
Respectfully, my lord, 13th of June, when
It's a contempt petition between the court and the contemptor. We are completely bound by what the court feels, because my lord, several occasions undertakings have been given and breached, timelines have been set, and thereafter no steps taken. Because on 13th they had found this particular investor and they were supposed to file an application. On 26th June, the order is recorded.
What is the affidavit you filed?
Respectfully, my lords, that is not the.
And my lord, 2 of the contemptors are not appearing.
Could I make one humble suggestion, my lord, subject to my lord's kind consideration?
Yes.
My lord, would it be your lordship's pleasure to direct the investor to appear online any day? Because this bogey of, my lord, an investor is being going on. So if the investor appears before your lordship, at least online, and indicates what is his intention, then my lord,
Just-
this would possibly put an end to this.
My lords, only to address my learned friend's concern, this is the first time that we have actually identified a proposed purchaser or an investor.
You are telling, you have given in affidavit that 5 crore rupees has been settled with regard to the sale price. And 50 lakhs has been given and you are going to 50 lakhs here. Where is the proposed agreement of the 50? Where is the proposed agreement entered between the parties?
My lord, this application I shall file it today, my lord. They have not been. I'll come up with an application annexing the agreement. That will be much better rather than.
So why you not come with an agreement? And how you are filing the affidavit without surrendering? All the 3 persons are under warrant.
With the application, none of it is signed, my lord. It is full of blanks.
No. My lords, the application.
No, where are the other contemners? Where
My lords,
2 and 4 is not.
contempt number 2, which is contempt number 1, my lords, is Pramila Sudalaganta. My lords, respectfully, she has some physical disability, my lords, after a hip replacement. What I am given to understand that even going to the bathroom, she needs some physical support and her son needs to stay with her. So it is not physically possible, my lords, to appear before my lords, but so there is some challenge on that count. As far as the application,
who has filed the affidavit?
it is contempt number 4. Jairam Sudalagunta, Jairam Chaudhary.
Huh?
Jairam Chaudhary.
All three.
No.
The affidavit has been filed by all 3, my lords, contemners number 1, 2, and 4. The application that we are proposing to file is by Jairam Chaudhary.
So, but how this court can accept this affidavit once the warrant is pending and they are not surrendered?
My lords,
Today he
Oh,
will.
tell me the point of law. Give the answer. If the warrant is pending, you are not surrendered. How the affidavit can be accepted?
my lords, he will surrender today, my lords.
What about the other 3? You bring the affidavit on record now.
One is past day. Another is past day.
1, 2, and 4.
Yes, where is your application?
The application is ready, my lord, but it has to be in proper Calcutta format. They have notarized from there. The annexures are not. I shall file the application by today within an hour, my lord. It's already ready.
How your purchaser is here? Purchaser is here.
Purchaser is not here,
No,
but he
then where
filed
is the
his
signature? Where is the signed agreement?
sign agreement.
Where is the signed agreement?
My lords, this is only the draft agreement.
Then how you have received the 50 lakhs without on the draft agreement? You are dealing with the 5 crore rupees draft agreement. You received the 50 lakhs.
My lords, only on the.
This is also creating doubt of your submissions.
It is basis the discussions that this draft was agreed, my lords.
How the basis of submission you have given the 50 lakh, 50 lakh, any person will nowadays at.
My lords, only because on the 13th of June, my lords have directed that the draft agreement be produced. It is only on that basis, my lords, that the draft agreement has been produced before, my lords. Unfortunately, we could not file it in the proper format on time. We will get it on record, my lord. We will definitely get these records on time.
Get the agreement signed by the.
ये फिक्स मैटर है क्या? कितनी बार है? Come at 12 with your petition.
Much obliged, my lord.
ये यहाँ तो अरे ऊपर पेपर यहाँ. Come at 12.
Grateful, my lord.
Reading for 5, 6, 7.
Pass over. Next.
Lord, my contempt application, your lordship.
For the alleged
On
contempt.
the last occasion, my lord, your lordship had passed a direction on 23rd July, my lord, that the alleged contemptor was to file a supplementary affidavit for bringing on record the removal of the name of the company from NSC and Ministry of Corporate Affairs. Now, my lord, I find that from NSC, from Ministry of Corporate Affairs, it is removed. And my lord, from NSC, my lord, I have taken the current printout from today, and will kindly take it, it's still appearing.
Yes.
Lordship, the name change has already been approved by the shareholders. The new name is Origro India Limited, your lordship. It will take some time to reflect it in the
Same thing which they
before the
carry on
NSC, lordship.
when the
Lordship,
matter is
I have
called.
a 14-page document, if your lordship
But I'm not carrying it with me right now, Lordship. I'll share it
No,
with
if
my
you-
learned friend.
If you say, then the court will go to your office of your client and will see the inspect the
Lordship,
document.
I have the document. Lordship.
My lord, I'm being led by Mr. Simon.
Yes. Why you persons are not filing affidavit and disclosing all documents? In the contempt you are taking so easy.
No, Lordship.
My lord, previously,
So what has happened to this request?
Lordship, two of them have already filed. One couldn't, Your Lordship, because of some personal difficulty, Your Lordship. One of them could not give the affidavit, Your Lordship, but the
You are
other two
practicing
have
in the Calcutta High Court.
Yes,
You are practicing in Calcutta High Court. You are practicing in Calcutta High Court. I am asking you, you are practicing in Calcutta High Court. This is the way, filing affidavit by punching. Whether the rule is changed.
Lordship, I'll give it in the correct format, Your Lordship.
so July, 23rd July.
Follow.
My lord,
Yes.
nothing has been served, and my lord, the document which was handed over by my learned friend just now, my lord, it's dated 11th July, and your lordship had passed the last order on 23rd July.
Correct.
And nothing has happened, my lord. And today on the NSC, it's still appearing. But I'll tell your lordship, the moment the personal appearance was dispensed with, this frivolous activity is being carried.
No, Your Lordship, our conduct has always been on the right side, Your Lordship.
All
We have
be
changed
present.
the
All be
name
present.
also.
All be present at 24th before this court. Either present in person or to delete the name, whatever it is.
My lord, previously, warrant of arrest.
Lordship, we'll ensure that the name gets deleted, Your Lordship. The
What
new
ensure on the last occasion, 3 months time was taken. July, 3 months is over.
3 weeks.
The name has been changed, Your Lordship. The name of the new company is Origro India Limited, Your Lordship.
Second?
Second?
Yes, then?
Lordship, it will get some time to get reflected in the NSC, Your Lordship.
Correct,
I
that's
think they are
why.
subject to some approval from the stock exchange themselves.
Give me one time when you will be able to delete the name. And
Takes around 2.5 3 months. Yes. SEBI listing regulations of 2016. Lordship, it will take around 2 to 3 months for the SEBI listing regulations and subject to all the approval.
when you submitted? When you submitted your request?
11 I do not have instructions.
11 July.
The letter.
11 July.
Yes, Your Lordship.
So 3 months, October. So I am fixing a first week of November. And make sure
Yes, Your Lordship.
I am passing a conditional. If it is not, then you have to appear in person.
Definitely, Your Lordship.
Yes. As per the request of the learned counsel for the alleged contemner, the case is adjourned. Let the matter appear on 6th of November 2025. It is made clear that by the date fixed, if the contemners fail to delete the name of the company from the website,
Well, at the NSC website.
Huh?
NSC website.
From the
National Stock
NSC
Exchange
website,
But we have also stopped the manufacturing in the name of
from
Bodhara.
the NSC website, comma, the petitioner, the contemners shall appear before this court in person on the date fixed. Let the matter appear on 6th November, na?
I'm grateful.
Grateful, Your Lordship.
Lordship, I am appearing for the petitioners, Your Lordship. This is with regard to the using of the word Solaris. Last occasion, Your Lordship will granted leave to my clients to file reply to the affidavits filed by the contemners and further to serve Amazon. Lordship, I was praying for some time to deal with the affidavits. Though we have served Amazon by mail, but we couldn't serve them by post or by courier. Lordship would kindly give some time. After vacation, maybe, Your Lordship.
You have complied with everything, Your Lordship. Your Lordship, may I?
We have.
I have
lot of
gotten
things.
India address of Amazon AWS.
They have.
I will share with my friend.
As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 13th November.
Obliged.
Your Lordship, I am appearing for respondent number 6, 8, and 9. Kindly, my attendance also be taken on record.
Yes, next.
Much obliged.
Item number 6, Your Lordship, I am appearing for the alleged.
My contempt application, my lord. But Lordship had been pleased to be that passed an order dated 1st of October 2024 ex parte, injuncting the respondent my lord, from carrying on business of selling my lord, under the trademark my lord, Poly Pankaj. Now, my lord, subsequently, in the month of March 2025, we have found a bill my lord, by which they are selling. They're still selling their products. So that's the contempt. My lord. Now, my lord, I should indicate my lord, subsequent to this my lord, and after I filed the contempt proceeding, during the order of subsistence I filed. Thereafter, my lord, this matter my lord, ultimately my lord, was heard on merits, my lord, and they had taken out an application for revocation of leave, which was allowed by the honorable single judge, taking IP division matters. And my lord, that 6th May 2025, and thereafter, my lord, we had preferred an appeal. Appeal hearing is concluded. It's CAB. So that's the judgment is reserved on 7th of July 2025. Order has not been delivered yet. So
I am fixing after vacation.
Your Lordship, let the matter be disposed of because on Your Lordship, let the application.
That's why I am fixing after vacation.
Your Lordship, I am ready to make submissions and it can be finished by today. Why I tell Your Lordship? Because this application is actually has baseless allegations. There is no contempt in fact. I'll take 10 minutes to apprise Your Lordship and they can respond. And kindly take your.
Let her apprise for 10 minutes. I'll respond in whenever. Lordship.
No, Your Lordship, we are the instance of them. If contempt is that serious, let it get heard.
Okay, let the appellate court, let the wait for the appellate court order. What is the, if it is not there, then.
Your Lordship, I'm not challenging the dismissal of the suit or connecting. This is a separate proceeding. It has to be dealt in a separate way. So this is a separate proceeding. Let it be heard separately.
Yes. Let her apprise for 10 minutes. Let her apprise for 10 minutes.
So you will complete?
I've indicated.
No, let him complete.
12th March, I'll show the 3 pages. First, let her apprise for 10 minutes, and page 330-22. There's 3 pages and nothing much.
Page
322.
322.
Yes. The 3rd volume.
Yes, the order.
That's the order passed by Your Lordship. This revocation order. They had asked for vacating of this order, but this was instead of this blood, the main suit was dismissed on the ground of 12. So this was not specific in the final order. It is recorded, but this is that application was not finally heard. 1st October 2024, Lordship would kindly come to the disposal. Kindly come to page number
327.
27.
Yes.
That is the operating part. Accordingly,
that paragraph.
Yes.
Yes.
But
Then
paragraph starts with that page 327 says Poly Pankaj. That is what the mark was in down. Now Miller kindly comes to annexure H of that very
page.
This was brought to their knowledge by several ways. I have disclosed that these notices, substitute service was also done. Newspaper publication was also done. Kindly see Miller. All 2 pages are there. Page 416, page 419 is the summons which was served upon them.
Yes.
Item delivered it records.
Yes.
In January.
Yes.
Now at page 420 is Poly Pankaj their product. It's being sold. Now that there are pleadings and
420,
421.
420, 421. Yes.
This is being sold in Kolkata. Polyponko Joshi could find the packagings. This is being sold in Kolkata, and 422 is the bill. Subsequent. 422 is the bill that one of the agents are selling this must be a distributor. Bhavani Enterprise. 12th March 2025 is the date of the bill. 422. And
Yes.
There, despite Polyponko, she would find the name in the product of the name in the bill itself.
Yes.
They are, despite the injunction, there. Now, this injunction was operative up to at least up to 6th May 2020.
6th May.
6th month of May 2025.
When the interim order was vacated.
Yes, on 6th May it was vacated, and before that, this interim order was not extended up after April 2025. So till month of April it was valid. Normally, the interim order, all the applications, they had also filed application for vacating of this order. They never preferred any appeal from this order, but they filed an application. That was not heard. What was heard was J number 6, which was the revocation application, what you could find from the order of 6th May. And there shall be, last line says, there shall be order in terms
Where
of...
is the 6th May order?
Yes, that I can hand over. Or she kindly comes to last page of this order, which is not annexed because it was passed subsequently. Opposition
Yes.
So last page it says only J number 6 was heard and allowed, and consequently all other. So they have not filed any appeal, or they did not succeed in the revocation per se, in the order vacating of this order per se. And finally we preferred an appeal, and appeal was not made. Hearing of concluded has been reserved.
Okay, that is
that is there. So this is the simple point. During the subsistence of the order, I had shown that January sale property, their products are lying at the shop, and March is the bill, and order was sustained till the month of April 2025 at least. So this is the only point I am urging. If now they say that it's not, and they point that they are, and the point that I should indicate to you, Roshi, the point that they are, the point that they are urging in their affidavit of opposition, there is no, they did not say that they have not sold this product, or they have not carried on business with this particular trademark after the order. They say that there is a blanket statement that we have not violated the order. That's all. But in order to justify this, what ought to have been disclosed is their records, accounts. From the moment account is disclosed, it would be evident what products were sold under which trademark at what point of time. If they at all not sold any product from October to April, or till the contempt was filed at that point of time, or other subsisting, if they can not show from their accounts that nothing was sold at that point of time during that period, they are true, but they have suppressed that document. They did not disclose it. What they said, I have not violated the order. That's the line. They have not basically withheld the document from where from it could be actually ascertained their contention, whether their contention is true and correct. That's the stand in the affidavit. Let her appraise for 10 minutes. And may I find my affidavit reply to that opposition?
Yes, ma'am.
Yes. Now, before I proceed, Your Lordship, kindly take Your Lordship's order passed on 9 June of 2025.
Yes.
Your Lordship, we had appeared and disclosed, Your Lordship, the order of 6th May of 2025.
Order dated?
9th June of 2025.
Of this court?
Yes, Your Lordship. It is related to the contempt application. I'm Yes. So, Your Lordship, I'm appearing for the alleged contemner. I had already shown Your Lordship the 6th May order, where the coordinate bench of this court, having the jurisdiction of the intellectual property matter, allowed GACOM 6, which is my order 7 rule 11, by revoking, etc. And then submits that for number 5, as on date, there is no suit in the eye of law, contempt is required to be dismissed. Then 6 is, Your Lordship, the ground taken by them is interim order passed by this court was in existence, and the alleged contemner has violated the order. This is what. Now let us come to, Your Lordship, the application, contempt application per se. Your Lordship, the 6th May,
Yes.
Yes, Your Lordship, the 6th May 2025 order that was shown, a submission was made that only adjudication of GA6 was made and GA5 nothing. Now, Your Lordship, kindly come to the last page.
Yes.
GA Com 6, which was our Lordship application under Order 7 Rule 11, stands allowed. There shall be an order in terms of prayer A and B, which means a dismissal of the suit. IP Com stands dismissed. All interim orders stand vacated. Consequently, the interlocutory applications GA4 and GA Com 1 are dismissed. Now, accordingly, Your Lordship, GA Com 5, which was my vacating application, is also rendered infructuous.
Correct.
Yes, Your Lordship, it was heard. Now, coming to the contempt point. The first point is, Your Lordship, this contempt application should have been filed before, Your Lordship, the court having the jurisdiction to hear intellectual property division matter. Your Lordship passed an ex parte suit, Your Lordship, was filed on 13th of September 2025. Ad ex parte, ad interim injunction order was obtained on 1st October 2025. Now, this was this was later on extended. Now, the extension, Your Lordship, let's focus on, Your Lordship, first, the validity or the time limit of the validity of the order passed by Your Lordship. They have, Your Lordship, disclosed the order at page number 322 of volume number 3.
Yes.
Now, Your Lordship, if Your Lordship takes page number 327.
Yes.
Last, third paragraph, last line, Your Lordship, that this order will be effective, the injunction order will be effective till 22nd November 2024.
Till?
Yes. Now, from 22nd November 2024, allow me to show Your Lordship the order dated 22nd November 2024. It was passed by Your Lordship, Honorable Justice Ravi Kapoor. And that's how the relevance of this order was kept alive by the Honorable Justice Ravi Kapoor. So this would have, that court would have been the right court for determining this particular application. Now kindly see the language of this order. It is unfortunate state of affairs that despite not being effective, plaintiff has taken no steps as contemplated under Code of Civil Procedure 1908 to effect substituted 21st. It is made clear that in the absence of effective steps, according to the law, interim order should be vacated. So till that day, there was no communication of the order. Now, allegation. Allegation, Your Lordship, has been made on 12th March of 2025. Further, Your Lordship, despite mid-department has failed to take any steps, as a last chance, the plaintiff is directed to take necessary steps for hearing of the suit.
Shall be vacated on returnable date.
Yes.
In the absence of the effective, yes. So,
Yes, till that day, Your Lordship, there was no communication.
what has happened after the 9th of December?
Yes, Your Lordship, after.
Because as per this order, the 9th till 9th of October, the stay is continuing.
Yes. Now, after 9th of October. Okay.
After
21st, yes, 9th of October.
On what has happened 9th of December?
9th of December, Your Lordship, the application of substituted service of summons, which is GA Com number 3, was taken up. And yes, and injunction order was extended because they did file an application. This is the order. Now this, it says that the applicant, that despite efforts, they have not been able to serve the respondent and an appropriate application has been taken out. That application, Your Lordship, was... That application was, Your Lordship, disposed on 19th
Okay,
of
whatever
December.
it is,
Yes, yes.
10 January 2025, the interim order was extended till.
Yes, yes. Now, we made the appearance on 17th February 2025. We filed our necessary applications.
Correct.
So my first point is, Your Lordship, if they want to maintain this at all maintainable, it would have been before the Court of Honorable Justice Ravi Kapoor with appropriate determination to hear this matter. Today, only this order is valid till 22nd November 2024. So the petitioner should have shown that the contempt has occurred from 1st October till 22nd November. There is no contempt. What is the case? What is the foundation of the case? Kindly take, Your Lordship, the prayers. It would be in the cost title itself, Your Lordship, from page number 2.
Yes.
Yes, not complying with the solemn order of 1st October 2024, wrongfully manufacturing, distributing, selling her products under the mark Polly Pankaj and thereby passing off. Number 3, using, selling, manufacturing, distributing, advertising the products under mark Polly Pankaj. 4, wrongfully manufacturing, distributing, selling her products under a mark which is identical and deceptively similar to the plaintiff's mark and therefore passing off. Using of the deceptive, similar and identical mark as that of the petitioner as the respondent's trademark being a part of it. So these are basically pairs of infringement and passing off. Now, the relevant portion, the pleading related to contempt, Your Lordship, kindly come to paragraph number 12 at page number 16.
Yes.
Your petitioner states and submits that even after passing of the solemn order dated 1st October 2024, the subsequent extensions, the products of the respondent contemnant are still being sold, both within and outside the jurisdiction. Photographs in relation to such sale and an invoice showing the sale of the contemner's products are annexed here too. So therefore, Your Lordship, I would have to straight take Your Lordship to page number 420, where the products are, pictures are there. And I'll kindly see the picture, page 40. About 420, Your Lordship, volume 3. Clearly 420 would be evident also from this. Your Lordship, whoever is sitting in the reception is staring straight into the camera, which can also be seen from page number 421 and 422. Let's pause here for a moment and focus on only one thing. Kindly see, Your Lordship, who has issued this particular invoice. Page number 423. Yeah, page number 422.
Yes.
Your Lordship, Ma Bhavani Enterprises Private Limited.
Yes.
Please focus on to this. This person has sold the products to Adyama Hardware and the product is, Your Lordship, Polly Pankaj. Date is 12th March. Great. Kindly see, Your Lordship, 421. The shop name is Ma Bhavani Enterprises. That's page 421.
Yes, Ma Bhavani Enterprises.
Now, this 3 pages are not new. What Your Lordship, the petitioner did, these 3 pages were disclosed by them in their affidavit opposition to my application for rejection of the plaint and my vacating application. That's why that point. In that opposition plays a very vital role here. Now, Your Lordship, we couldn't get, I don't have the physical copy. May I be allowed to give my tab? Because Your Lordship would be able to see what I'm trying to point out.
Allow this. He has filed an affidavit. Container has filed an affidavit subsequent to leave. None of these are either pleaded or disclosed.
Now, Your Lordship,
kindly don't allow this. Kindly don't allow this practice of enlarging the scope of an affidavit.
Yes.
Yes. Now, Your Lordship, the petitioner themselves also have craved leave to disclose the oppositions, which will be evident at paragraph number 26 of their contempt application. But anyway, if Your Lordship sees, now if you see, Your Lordship, the vacating application, I've definitely taken leave of it.
Which paragraph you are relying upon?
Yes. Kindly 1 second. Kindly come to paragraph number 14. Page number 14, Your Lordship. I think that's the one that I've...
Yes.
Page 14. It is material to state herein that even after passing of the order dated 1st October, then the subsequent extension, products of the defendant are still being sold within the jurisdiction of this Honorable Court. The photographs are enclosed and invoice. This is the submission. Now, Your Lordship remembers the date of the invoice was 12th March 2025. Kindly come to page number 18 of this affidavit. Kindly see the date of affirming.
Yes.
So the invoice was, let's assume, the invoice they got probably in the morning, took 1 day to draft 18 pages of affidavit in opposition, got it affirmed, signed. Clearly, it's manufactured. Now, second contention why it's manufactured, it will get further clear. Your Lordship, they have disclosed their application for injunction, their injunction application as annexure number A. Kindly come to, Your Lordship, paragraph 18 at page number 54, volume 1, being a part of their injunction application. It's a pleading of their injunction application.
Page of injunction application?
Yes, Your Lordship. Injunction application, the relevant portion is paragraph 18 at page.
Application will not find here.
No, Your Lordship, it's annexed as Annexure A of contempt application.
Page number?
Page number, Your Lordship, 58.
Yes.
Your Lordship, 54. I'm so sorry, Your Lordship, 54.
Yes.
Yes. The petitioner is operating his business under Pankaj Marks since 1976 in an uninterrupted and continuous manner. The products of the petitioners are sold to distributors.
Yes.
Kindly mark all this, please. Through distributors and dealers amongst farmers and laymen, and mostly belong from the rural India, and the customers of the petitioner purchase such products from the market for the purpose of using the same for cultivation since its inception from within and outside. Copies of the few bills and invoices of the petitioner, along with some other documents evidencing the long and continuous use of the product of the petitioner, are annexed hereto and collectively marked as K. So, selling is through distributors and dealers. So, which means that the invoices and the bills that will be produced, that are produced as Annexure K, are documents of the petitioners showing, so selling through dealers and distributors. These invoices are extremely crucial for determining that how that particular invoice and the pictures are all procured. It was staged to create a cause of action for contempt, just to harass and get orders that they were not being able to get in the court of Honorable Justice Ravi Kapoor. Kindly, Your Lordship, come to the certain pages that I would mention. These all form part of the Annexure K. Kindly come to volume 2, page number 224. Yes, Your Lordship, volume 2.
Yes.
Kindly see, Your Lordship, who is the dealer. Ma Bhavani Enterprise. This is not the first one. Kindly come to page number 230.
Yes.
230. Ma Bhavani Enterprise. 231.
Yes.
235. 243.
Yes.
So they have made their dealer look at the camera, manufacture an invoice for them on 12th March of 2025, taking some products or the other, or procuring it from wherever they are possible, because I don't have any business in Calcutta. And after procuring that particular invoice, on the very same day, an affidavit in opposition has been drafted, finalized, filed, and affirmed. And since that particular application got infructuous, which has happened later date, they have filed the contempt application. Your Lordship, there is no contempt. This is absolute and manufactured documents. The pleadings also, if they would have wanted to prove contempt, they could have shown invoices from someone else but their dealers.
Have you taken the plea in your affidavit in opposition? You are the dealer of the
Yes,
Pankaj
Your
Advaya?
Lordship. Yes.
Which paragraph? ये affidavit in opposition का है. Which paragraph you have taken the plea?
Yes, Your Lordship. Kindly come to Your Lordship, para 3B, 3C, 3B and 3C, Your Lordship. The purported photographs feature one Ma Bhavani Enterprise, and the purported invoice has also been issued by Ma Bhavani Enterprises, who is the distributor of the petitioner, as would be evident from the disclosures made in the plaint and the injunction application at the time of institution of the suit. Such act on the part of the petitioner exhibits malafide, on the sole ground of which contempt application should be rejected with exemplary costs.
Yes.
And also, kindly come to E. The purported pictures and the purported invoice marked as Annexure H in the frivolous contempt application have also been disclosed by the petitioner by way of its affidavit of opposition, affirmed on 4th April in the proceeding of Order 7, Rule 11. And it's being GA6, it is evident that the petitioner has attempted forum shopping. I crave leave to refer to and rely upon the affidavit of opposition of GA6. GA6 also in their application, Order 7, Rule 11, they have disclosed.
Yes.
And paragraph 18. Paragraph 26. Yes, Your Lordship, that's about it.
Yes.
That's all. My lord, at the time of argument, I'll just summing up her points. 3 points have been submitted so far. One is that lord, this proceeding ought to have filed before Justice Honorable Justice Kapoor, because when the act of contempt alleged, according to her alleged act of contempt took place, at that point of time, Justice Kapoor had the determination, and this court did not pass this extending orders. So, according to my learned junior friend, the order is this order, or the order I showed at page 420 was valid up to 22nd November 2024. That's first point. Point number 2 is that the bill that I show is a manufactured bill. That's oral submission. The word manufactured is absent in the affidavit of opposition. It's not there. So it's orally have been submitted that it's a manufactured bill, and the distributors is the distributor from where I have got this bill is also selling my products. That's second submission. And third submission is that no, that's not that, neither here nor there.
What is your contention with regard to he is your dealer?
Right. Well, a dealer cannot be exclusive. It cannot be I am selling. It cannot be a person, only one distributor is selling all my products.
You are not mentioned you are the dealer, and
when I showed the pleadings, that was
not with regard to the extent dealer has not been restrained. You have supplied to the dealer, and dealer is selling. How you can say that?
Yes, well, now that for that lordship has to comes to whether they will not have any business in this part of.
Admitted in your application.
I have yes, I'm just summing it up. I have filed an
Annexure H, you disclose that you are the dealer and you supply the materials to the Bhavani.
I am not the dealer. I am the manufacturer
You have
of my
supplied-
products. I send my products to the distributor who sells that to the public.
Correct.
Ma Bhavani is one such distributor. There are many others.
Correct.
I have given list and those documents which are disclosed. Ma Bhavani is one of my distributors. There are many others. That same Ma Bhavani is also distributing products of the defendant. And from that, I have found one bill where he is distributed one of their products. That's my case. Ma Bhavani is not my sole distributor.
No. The contempt application is filed only on the basis of the invoice and the photographs of the Ma Bhavani.
That is what I have got.
Correct.
I did not get any other thing.
It is the same.
Yes, that is what I have shown you.
Single instance.
Yes, I have shown
as
this.
per the annexure which you disclose in your application, annexure H, that is the Ma Bhavani is also a dealer for selling of this. Selling of the
Yes. I am saying that same Ma Bhavani, who is also my dealer, he's not my exclusive dealer, he's also my dealer and dealers of many others, including the defendant. And he's selling defendant's products as well.
Maybe.
Up to that date, he could. But after that order of injunction, that they could not have sold their products through Ma Bhavani or through anybody else.
Who cannot sold?
The defendant could not have sold their products through the distributor. But products are sold.
Who is the defendant?
Defendant is the one
who is the contemner?
It's the contemner. Defendant is the contemner.
Sole defendant, Your Lordship.
Amita, that is the same person. She is the contemner. And that when I sell a good, when I sell goods, I sell goods through distributors. And she also sells goods through distributors.
Correct.
She is saying that I am not selling. The distributor is selling. Now that is the stand. Because otherwise, if she is saying that two things. One, she is not my distributor, or this is not my product. That could be a justification.
contemner, you have made the contemner with regard to
Anita Anu, it's only one container. There is
correct,
no one else.
Anita.
Yes. She is the contemner.
Anita Anu.
Yes.
Carrying the business under the Vishnu Buddha.
Yes.
Where is the document that Vishnu Buddha is selling that property?
But she cannot sell. She is the manufacturer.
She is the manufacturer.
She will not manufacture.
Correct.
And the distributor will not sell. That is the order.
What is the injunction order?
My kindly see.
Kindly come to that.
So direction B. Prayer A and B lordship allowed.
কোথায়
Injunction application ওটা বার কর second volume আছে ওটা
এখন defendant or man agent son dealer
main agent everyone is stop.
Correct.
The agent distributor is who? Is an agent.
Correct.
So the agent is a stop.
No, but in your petition kindly come to the page 30 paragraph 34
of the contempt application. Paragraph 34 of the contempt application.
Contempt application.
Yes, sir. Page 25 of the contempt application. Lordship's order is very clear. It's been it's an attempt to mislead your lordship.
Can you come to page 54?
Page 54, yes.
Page 54.
Yes, that's my affidavit in opposition to their application for vacating of my order.
Whatever. Kindly come to the
24 minutes.
Yes.
The petitioners.
Page 18, paragraph 18.
Paragraph 18.
Page 54, paragraph 18 of your contempt application.
Yes. Paragraph 18. Yes. Now, Milord, this is my
injunction application.
Injunction application. What did I say? I am out myself. Petitioner is operating business under 1976. The products of petitioner are sold through distributors.
Correct.
And not dealers. I am not selling myself.
Correct.
I am manufacturing distributors. Dealers sell.
Distributors.
Amongst farmers and laymen and mostly belong from rural India, and the customers of the petitioner purchase such products from the market.
Correct.
Market as in from distributors and dealers. For the purpose of using the same for cultivation since its inception, both within and outside. The copies of few bills and invoices of the petitioner, none of these bills can be mine. I am giving to the distributors and dealers. These are their bills.
Correct.
Copies of the few bills and invoices of the petitioner, along with some other documents evidencing long and continuous use of the products of the petitioner, is annexure K. And Lordship would find the same Mahavani name in this list of documents.
Kindly come to 224.
224, yes. Page 224, volume 2, Milord.
224.
That's one of my bills. Now, Milord, this is being sold through this Mahavani, and it is what I am giving to Mahavani and Mahavani paying me. Correct. This is no third party involved in this.
If you have given to the Mahavani,
yes.
Mahavani is your dealer.
Is one of my dealers.
One of the dealers.
Yes.
So if he is selling the product, so where is the contempt?
But if Mahavani is also their dealer,
maybe their dealer, but you have relied upon the document which shows that the Mahavani is selling.
I am showing
document that the Mahavani is selling the product of your product.
In the contempt, I am saying Mahavani is selling their product. In the contempt, I am saying I have shown the document 422. Lordship is looking at
which paragraph? Which paragraph?
And page in the contempt application, page 422.
That is correct.
Yes.
That is the Mahavani selling the impugned material.
Right.
Correct.
Yes.
Which this court has passed an order. Where is your statement that product has been supplied by the defendant?
Yes.
Anita Anu.
That should be in my injunction, my contempt application for page
another point. Whatever submission that is being made, just indicating. My pleadings have your lordship seen by way of affidavit in opposition. We have gotten chance to affidavit in reply. The relevant paragraph, your lordship, is paragraph 5. Kindly see if at all any of this is being said.
I have denied everything that they said.
No,
I don't need to put across my case in the reply.
Where is your case?
Yes, kindly come to page paragraph number 12 of the contempt application. Page 16. In fact, my lord, yes, sir. Your petitioner section submits that even after passing the solemn order and the subsequent extension, products of respondents are still that is what I have said. Products of respondent contemner are still being sold both within and outside jurisdiction of this honorable court. Photographs in relation to such sale and an invoice showing sale of respondents' products are annexed. I have not said this is the document I have got. And this is the document I have not got to file contempt. I got it. I intimated them pre-hand. Lordship had read my affidavit in opposition to their application for vacating. I had used the same document. They knew about this. They in that affidavit they did not deal. Now, my lord, here they are saying. Now, my lord, the point number, that is one answer. Distributor is not exclusive. My distributor is distributor of many others. My dealer is distributor of many others. Lordship had seen my bills where I have sold products to my distributor, and my distributor would then in chain sell to the purchasers. I have not been able to disclose. I have not disclosed documents of my distributor selling products to my products to the customers. But here, when I do the contempt application, I have shown the products of the respondents being sold by a distributor who also happens to my distributor. So the allegation of manufactured document, oral submission of manufactured document, although the word manufactured is absent in the affidavit opposition, but the cases of manufactured document cannot subsist because she cannot deny and she cannot shy away from the facts that they are also doing business in Kolkata. Now, that I will show. They have that ought to have been shown to your lordship. Page number 313 of the contempt application. The submission have been made. Kindly be careful on the submission. Submission has been made that we don't sell anything in West Bengal. That is why it can't be my invoice. That is why my product can't be sold. That's the submission, Miller. 317. Kindly see page 317. Poly Pankaj. 319. Page 318. Poly Pankaj. Written in Bengali. Somebody who does not do business in West Bengal will not use the language Bengali to sell his products. We have shown these documents. Lordship remembers when Lordship was that was the case. Lordship also asked us that whether they are doing it business in Bengal or not. Unless they use it in Bengali, they can't. They would not have. Obviously, they do it in Bengal. And how do they do? Obviously, they do not have any direct presence. They do it through distributors. Who are the distributors? The same persons who sell same goods of different entities. I am Pankaj, he's selling mine. There are the defendant, there are many others who are selling similar products through the same distributor. Now, that second point is whether IP division, non-IP division, that point is now that is settled, and that point is I couldn't find that point from the affidavit in opposition of jurisdictional issue. I don't think they have really taken that point. An argument has been made, but I couldn't find that point in the IP division point is absent in the affidavit in opposition. Kindly ignore that point, whatever being submitted on that, because it's not taken. IP division point is not valid because the order when it was passed by your lordship, at that point of time, lordship had the determination. Subsequently, that order has been extended from time to time and up to month of April. And no fresh order of injunction has been passed. So, that if I file an application for contempt of the mother order, which has been extended from time to time, naturally, I would have to come to the court, which was in session when that order was passed.
And if this court is not having the determination without the assignment, how this matter can be taken?
Yes, lordship does not have determination anymore of these matters. Correct. But when lordship had passed that order, lordship had a determination. Now, a contempt cannot be treated by, if I file a contempt application of that order by Honorable Justice Kapoor, what would have been fate of that matter? Justice Kapoor would have laughed at me and said, please go to the bench who has determination, because obviously Justice Kapoor would not have taken the contempt application of an order which was passed by some other judge. And if the judge is in this high court, if he had transferred and something else, then otherwise not, this court is the only court which can take the contempt of its order, because it's about protection of the orders. And the last point, one last point that they had taken, IP division point I am not dealing with because it's not there, it's absent in the affidavit. It's been submitted orally. The other point, the only material point is the manufacturer that I have answered, and I have also shown that they have not disclosed in the affidavit in opposition as scrap of paper from where lordship can ascertain whether they have sold their products or not after the order. The order
375 affidavit of service order.
And the another attempt has been made to show your lordship that this order was not extended or that I had not caused service.
No, that is not.
Yes, so that was shown.
So
I have disclosed.
Yes, given the order that
yes.
On 3rd March there was
attempt was made to mislead, and subsequently
I don't think so. It's a misinterpretation of my argument.
They were not served.
It's over.
They say that
now, that kindly one last thing that I should show your lordship. কি বলছো?
ওরা বলছে না আমাদের সার্ভই করেনি।
আরে ওটা তো বলছে, এখন তো বলছে না ওটা, ঠিক আছে। And one last thing that I should show that the point IPD at the key point. Yes, the manufacturing bill that I have explained. Yes, the last point is that I have showed that they have not disclosed and withheld their accounts from where it can be understood whether they have sold anything or not. Kindly, Lordship's order I will once again read at page 322. Lordship had not restrained them from selling in West Bengal or anything. They have been sold, they have been restrained from doing anything with the product, with the trademark Polypankaj. Manufacturing, selling, anything and everything is restrained from doing it. Now, if accounts could come, if they had disclosed it, it would have solved the purpose.
Yes.
That making blanket statement from the bar, that is a manufactured document, not taking that point in the affidavit in opposition, that would not do. It's about the dignity and majesty of the court which has to be protected. So that is a blanket statement from the bar. Now, in the order in question, prayer A to A and C have been allowed. In the A and C, this is what was my prayer. Lordship would find my injunction application in the second volume of the contempt application. Prayers are there. I have sought for injunction on marketing, advertisement, distributing, selling, manufacturing, and dealing with the goods and services under the trademark Polypankaj. I have prima facie shown that their products are still being sold from a shop in Kolkata, and I have also disclosed the bill. That whether that person is his distributor or not can only be ascertained by this honorable court from them. I cannot confirm that. I cannot, but I have brought with a document which shows that yes, that person is selling their products. I cannot prove it. And the bill, so far as the bill is concerned, the person is not my exclusive. I have nowhere said that this is my only distributor, or this is my only dealer, this is the person who is only dealing with my products. This is my summons of submission. Kindly, therefore, and the interim order has been kindly not, it will not never end. She will supply reply in facts. I'll again reply.
No, Your Lordship, one more indication regarding the word manufacture, it has been used or not, because an allegation is
It's
made.
not used.
Okay, let me see that if I'm wrong.
Well, that should have been
Can I
shown.
see, Your Lordship, page number 12. I wouldn't know that your team doesn't read.
Page number 12 of?
Page number 12 of my affidavit in opposition.
Manufacturer and engineer document is
Yes, Your Lordship, 17th line.
Paragraph 12.
Yes, page number 12. The purported invoice has been manufactured and engineered by the petitioner through its own distributor.
Where it is?
Your Lordship, line number 17.
After the annexure H written, 3 lines thereafter.
The purported invoice has been manufactured and engineered by the petitioner through its own distributor for causing prejudice to the defendant by way of a frivolous contempt application.
It's a blanket statement. There is no counter.
Yes, any counter reply also doesn't have any blanket statement.
The plaintiff has filed the present contempt application on the allegation that the alleged contemnor has deliberate and willfully violated the order, violated the interim order passed by this court dated 1st of October 2024. The defendant and the plaintiff has relied upon page 420, 421 and 422. That is the photographs showing the materials, the product Polypankaj was stored in the shop, namely Ma Bhavani Enterprises Private Limited. Ma Bhavani Enterprises Private Limited or private? Ma Bhavani Enterprises. At 8, Canning Street,
Private
Limited. Situated at 8, Canning Street, first floor, room number 108A, Kolkata. Page number 421. The print, page 422 is the tax invoice issued by Ma Bhavani Enterprises Private Limited in favor of Adyam ADYAMA MAA Amya Enter Hardwares with regard to sale of polythene delivery pipe Polypankaj dated 12th of March 2025. Relying upon the said documents, the plaintiff submitted by an order dated 1st of October 2024. This court has restrained the defendant, her man, servant, agents, assigns, dealers, and distributors, or anyone claiming on behalf of the defendant from passing off the artistic representation of the plaintiff's registered trademark Pankaj invert comma caps me deceptively in the artistic manner by selling, manufacturing, marketing, advertising, or otherwise dealing any goods or services, under the impugned trademark invert Poly Pankaj or under the same label as that of the plaintiff or any other label or trade dress which is identical or deceptively similar or an obvious imitation of the artistic manner as that of the plaintiff's registered trademark Pankaj Flex, then Pankaj Flexi, and Pankaj involving the word Pankaj till 22nd November 2024. Learned counsel for the plaintiff submit that the interim order was extended from time to time and on 25th of March 2025, and 12th March 2025, the interim order was in existence, but the defendant has violated the order passed by this court by selling the product of the plaintiff. Okay. Per contra, an advocate appearing for the alleged contemner submits that though this court, while having the determination, has passed the order dated 1st of October 2024, but admittedly, subsequently, the determination of this court with regard to the intellectual property matter has been assigned to some other court, and thus the contempt application is not maintainable before this court. The learned counsel for the contemner further submits that the contemner has not violated any order passed by this court. He submits that C has relied upon the photographs and the invoices which the plaintiff has disclosed in the present contempt application by alleging that the alleged contemner has violated the order. C has referred to the paragraph of the injunction application of the plaintiff being J1 of 2025, wherein the plaintiff has stated that the products of the plaintiff are sold through the distributors or dealers, amongst farmers and laymen, and mostly belong from rural India, and the customers of the petitioner purchase such product from the market for the purpose of using the same for cultivation since its inception, both within outside the aforesaid jurisdiction. C has relied upon the annexes disclosed in paragraph 18 of the injunction application, which are marked as exhibit as annexer K, appearing at page number 224, 230, 231, 235, and 243, wherein it reveals that the plaintiff, namely Pankaj Plastic Industries, has supplied the materials to Ma Bhavani Enterprises Private Limited, who is the contemner herein. Relying upon the said document, learned counsel for the contemner submits that if the plaintiff, if it is the admitted case of the plaintiff that the plaintiff has supplied the materials to Ma Bhavani Enterprises Private Limited, and selling of the material by Ma Bhavani, there will be no contempt. There will be no contempt. Learned counsel for the alleged contemner further submits that the document which the defendant and which the plaintiff relied upon, alleging that the alleged contemners have violated the order, is a manufactured one, and the document is no way connected with the alleged contemner to prove that the contemner has sold the materials, material goods of the plaintiff in the market after the order passed by this court. But the learned counsel for the respective parties peruse the materials on record. This court, by an order dated 1st of October 2024, passed the ad interim order of injunction, which reads as follows. Page 327, third paragraph. It is not denied that the defendant is not having the knowledge of the said order. The specific defense taken by the alleged contemner in the contempt application is that the contemner has not violated any order passed by this court, and the contemner has not sold the materials of the plaintiff in the market after the interim order passed by this court. In paragraph 18 of the injunction application, the plaintiff has made the following statement. This page 54, paragraph 18 set out. Annexer K, which has relied upon by the plaintiff in the injunction application, that are the documents which are appearing at page number 4. (224), 230, 231, 235, and 243. This court has considered this said document and finds that the plaintiff has supplied the materials, namely having the trademark of Pankaj Superflex, Pankaj Flex, Pankaj Sakti Super Suction Pipe, Pankaj Flex Suction Pipe, and other materials to the two Messrs. Ma Bhavani Enterprises Private Limited. The case of the plaintiff is that the Ma Bhavani Enterprises sold the goods of the defendant having the trademark of the plaintiff, on which this court has passed an order of injunction. Considering the document which the plaintiff has relied upon and filed the present application for contempt, that does not reveals that the said materials slash good was supplied by the defendant by the contemptor to Ma Bhavani Enterprises Private Limited. The plaintiff has not disclosed any document to prove that the picture and the photographs and invoices which shows that Ma Bhavani Enterprises sold the goods after the order of injunction was supplied by the defendant to Mrs. Ma Bhavani Enterprises. Taking into consideration of the above aspect, this court did not find any material to say that the alleged contemptor has willful and deliberately violated the order passed by this court. As regard the point of jurisdiction raised by the alleged contemptor, this court finds that initially on 1st of October 2024, this court has passed the interim. Subsequently, the determination of this court was changed, but the interim order was extended from time to time. The plaintiff has filed the present contempt application before this court on the ground that the principal order is passed by this court. And after the change of determination, the learned court has only extended the parent order passed by this court dated 1st of October 2024. Considering this aspect, this court is of the view as the principal order passed by this court, and it is the specific allegation of the plaintiff that the parent order which was extended from time to time has been alleged to have been violated by the contemptor. Thus, this court is of the view that the contempt application filed by the petitioner and plaintiff is maintainable before this court. Considering the above, this court has already held that this court did not find any materials to say that the alleged contemptor has willful or deliberate violated the order passed by this court. Accordingly, CC number
1 of 2025.
IPD 1 of 2025 is dismissed.
Your Lordship, no costs. It's a frivolous application. Today, if a content would have been proved, we would have been given compensation. Some amount of responsibility, Your Lordship.
Yes. 12 बजे कहाँ बोलो?
My lord, he has already surrendered before the sheriff.
My lord, I have taken instructions from my junior in the matter, the advocate and also the client. My lord, the agreement which they are showing is neither signed. It is full of blanks, and it is really not a concrete agreement on the basis whereof this.
Where is our we've not been served as well.
I have just. But I want the leave in this application. I shall. The application contain the affidavits, my lord.
Yes.
Agreement.
Who has signed this? Only you signed. AB. Both the parties sign.
That's the purchaser, my lord.
Who is purchaser? Where is the seller? Seller has signed. Where is the purchaser's signature?
Purchaser has signed, my lord. The seller has not signed because he has.
Who is the purchaser?
Purchases this company, Mark AB Investments.
So where is Mr. Jairam Chaudhary? He has not signed.
He has not signed.
Then
My lord, he has already been by that time taken into custody.
where is the original?
Original is, I have the scanned copy. Original can be couriered, my lord.
How it can be?
And if we undertake to file the original by tomorrow latest, my lord.
So come tomorrow.
My lord, till that time, my lord, he is in custody, my
Let
lord.
it be for one day may remain in the custody. That will be better.
No, my
He
lord.
will understand the.
I understand, my lord.
Lord, kindly do not show any lenience to this person. Lord. This has been going on for last 2 years.
Leave may I submit, my lord? Two things, my lord. The other two contemners, their warrant is also there. They have not submitted. And my lord, the second issue is my lord has on several occasions granted them liberty. My lord, if on this occasion when they are now in custody, if my lord takes a strong stand, perhaps my lord, better results will be forthcoming, my lord.
For purging
Because
the contempt, I'm giving a 50 lakhs demand draft, my lord, instantly. And for just a 1 day's time, my lord, may be given, and he shall
this is
come
not the
again
first time,
tomorrow,
my lord.
for surrender.
This is not the first.
Be able to. We will produce the original by tomorrow.
Because my lord, I've asked them to post it. in
Now
urgent
within 24 hours you will get.
If they post it by today, we should get it by tomorrow morning, my lord.
I don't think so. Which post is? Please give the address so that I can also send all the documents within 24
My lord,
hours.
respectfully, just one submission that if I may be allowed. I completely bow down, my lords. There is no escaping from the fact that multiple times assurances have been given. This is.
But my conscience is not allowing by seeing the face of this person. This is not. This is the fifth time he has violated the order of the court.
This is the first time he's coming before a transaction.
No.
He has not come
Several proposals, several
Very first day when he has given the undertaking, I caution him. I know how these persons are doing in the other courts. I know. Ask him whether he is the member of. Ask him whether he is a member of the Agri-Gold. Ask him. I know each and every biodata of these persons. I don't want to open before this court. On the very first day when he has given an undertaking, kindly ask the petitioners. He will not come with this. He will not comply with the undertaking, and the same thing has happened. How many cases? How many things? Yes, then total biodata is with me, but I am waiting.
I am coming here with my bona fides with 50 lakh rupees, my lord.
Court is waiting here only for how he will delay the matter. And one day I will. Today I think that today is the auspicious day to pass an appropriate order.
My lords, this is the first time, at least, my lords. We are very close to at least consummating and concluding this transaction, my lords. 120 days is the outer limit that the investor has asked for. At best, my lords, I have spoken.
Give an undertaking tomorrow from the investor so that he can also brought on record. Give an undertaking before from the investor that he will pay within 120 days of rupees crore and he will deposit before this court, not to him. Let it come tomorrow. I will adjourn the matter. Not I am giving the on Tuesday. Let the investor file. I am not asking to come before this court. Let he file an affidavit. He will pay the 4.5 crore by 120 days, and that will be deposited not in the hand. It will be deposited in the court.
In the court, my lord.
Tell.
Very well, my lord. Tuesday.
If it will not come with the affidavit of the investor, what would be the result?
Don't give all this up. The undertaking on
Got instruction. I have dealt with.
My lord, 5 minutes may be given to him to take instruction, my lord. It is his client.
Record an order. By an order dated
25th August was the last order and the previous.
by an order dated 25th of August 2025, this court has issued warrant of arrest against the defendant number 2, 3, and 4.
My lord, 1, 2, and 4.
1, 2, and 4. Full stop. Against the one, full stop. The Deputy Sheriff of Calcutta has submitted the report stating that the contender number
4, my lord.
4, namely Sudalgunta Jairam Chaudhary, has voluntarily surrendered before him, and accordingly, the report has been submitted before this court. As regard the other contemners, no report has been received from the police authority whether the warrant has been executed or not. Police counsel for the alleged contemner submit that he had the alleged contemner number 4, namely Sudaluganta Jairam Chaudhary, had a negotiation with one proposed purchaser, namely Messrs. Mark AB Capital Investment India Private Limited, through its director, Mr. Atul Dave, for purchase of one of the property. 3 properties. Which property? Where is the schedule?
My lord, it is there in the.
The properties of the alleged contender number 4 for a total sum of rupees 5 crore, out of which 50 lakhs has been paid an advance amount of the total sale consideration, and the alleged contender is ready to pay the said 50 lakhs to the petitioner before this court today itself. Police counsel for the alleged contender prays for 3 months time, that is 120 days.
4 months.
4 months time. 4 months time, that is 120 days, to complete the negotiation between the alleged contender number 4 and the proposed purchaser, and to pay the remaining amount along with the interest accrued therein to the petitioner. Though the alleged contender has drafted an application along with the agreement for sale, but this court find that the agreement is sale has not been signed by the seller, that is the alleged contender. Accordingly, counsel for the petitioner prays for 2 days time to file appropriate application along with the copy of the agreement duly signed by the parties before the notary public. Full stop. In view of the above, full stop. Get it in. As the alleged contender has appeared as surrender before this court, accordingly he has been released on personal bond of rupees 5 lakhs. Full stop. With the condition that he will appear before this court on each and every date of hearing. In case to appear before this court on each and every date of hearing, the alleged contender shall pay rupees 5 lakhs before the registrar of this court. Full stop. Let the matter appear on 23rd of September 2025.
My lord, will also kindly record the chart we had handed over.
Which shows the counsel for the petitioner has handed over a chart
total
disclosing the principal amount along with the interest accrued therein. And as on 15th September 2025, the total due amount along with the interest is rupees 5,92,00,754.
My lord, instead of 23rd, can it be on 24th?
724. Full stop. The petition is directed to serve the copy of this chart to the counsel for the alleged contender, and the alleged contender is directed to make necessary arrangements so that on as per the undertaking given by the petitioner, shall be fulfilled
My lord, one more
By the
humble request,
respondent
my
or
lord.
by the
the
alleged
contemptor.
contender.
My lord, one more humble request. Instead of 5 lakhs, my lord, can it be little lesser?
Let the matter appear on 24th. Which for the time being, and as the alleged content number 1 has surrendered, the warrant issued against the alleged content number 1 is suspended for the time being.
Contemptor number 4.
Content number 4, huh? As regard the as regard the warrant of the other contemners, the police authorities of the Tirupati, what is the
50 lakhs.
what is the address?
50 lakhs.
No, the demand draft for 50 lakhs has not been handed over. What has been?
My lord, kindly it be recorded in the order that we are handing over the demand draft
Authority
of 50 lakhs.
Tiruchenur Police Station, Tirupati, Andhra Pradesh, as well as the Superintendent of Police, Tirupati, Andhra Pradesh, are directed to file the report with regard to execution of the warrant against the contender number.
Yes, no?
1 and 2.
Draft of 50 lakhs.
1 and 2 on 24th of September 2025. The petitioner is directed to communicate this order to the officer in charge, Tiruchenur Police Station, Tirupati, and the Superintendent of Police, Tirupati, for compliance.
My lord, the demand draft of rupees 50 lakhs we are handing over. That may be recorded, my lord.
The alleged content number 4 has handed over the demand draft of rupees 50 lakhs. Of which bank?
IDBI Bank.
Of IDBI Bank, dated
17 September 2025.
September 2025, in the name of
Overseas Bank.
in the name of the
In the name of the plaintiff.
plaintiff is handed over to the learned advocate on record of the petitioner in open court. Let the copy of the demand draft be kept with the record.
My lord,
The matter on 24th of September.
my lord, for alleged contender number 1 and 2.
No, that's it. Let them submit the report. Let them submit the report.
My lord, for alleged contempt number 1 and 2, my lord, the alleged contempt number 1 is having a hip replacement.
Let the report come. Let the report come. Yes. Yes.
8 and 9, Doctor.
Yes. Have you served the notice?
8 and 9 notice.
You are appearing for whom?
Item number 8 and 9, not 7. 7 has been called, but I think nobody is here.
आप किसका बोल रहा है? 7 नहीं है ना कोई? None. ठीक है, छोड़ दो. Not today. Yes, next.
8 and 9. 8 and 9. Lord, this is not for extension of time to file the written statement. Lord, within 120 days, pursuant to Lordship's leave, I have filed it in the department. Lord, I'll serve a copy as soon as the Lordship Lord, we have not explained, the delay. We are a pro forma respondent, at the first, there's no relief claimed against me. But for abundant precaution, we are filing this written
When you
statement.
receive the writ of summons?
On 15th of
17th
May, my lord.
17th May.
Yes, my lord. And the time was to expire on 12th, I have filed it before that. And we this is a HDFC Bank, the branch is at Hazaribagh. So there's some delay in getting the instructions, and thereafter we have explained
Have you filed the written statement?
Yes, but file the written statement in the department. Handy.
We leave it up to
In
your
course of the day, I'll serve him, Lord. I have filed it. When
you file the written statement?
Lord, I have 10th September.
Have you taken?
10th September. Yes, my lord, I have the 10th September. File filed on 10th September. No, the file could shut out.
The dependent number.
Lordship not granted leave note and it was filed in the department.
The dependent number.
Lord,
The performer dependent number
five.
Performer dependent number 5 has filed the present application being JA-Com 4 of 2025, praying for extension of time to file written statement. He submits that the defendant has received writ of summon on 17th of May 2025 by post and 20th June 2025 by post by through court. Police through court. Police. Counsel for the petitioner submitted the defendant office is situated at Hazaribagh, Jharkhand, and on receipt of the said on receipt of the writ of summon, the former defendant has contacted the present advocate on record, and subsequently the present advocate on record has given instruction for providing the documents so that the advocate on record can prepare the written statement. By that time to file written 30 days time to file written statement has expired. He submitted though the defendant could not file the written statement within the period of 30 days, but has filed the written statement on
not on 10th September.
On 10th of September 2025, that is within the outer period of 120 days. He prayed for acceptance of the written statement. Per contra, learned counsel for the plaintiff raised objection and submits that the defendant has received the writ of summon on 17 May 2025, but the defendant has not shown any reason why the defendant has not filed the written statement within the period of 30 days. And accordingly prays for dismissal of the application, rejection of the application. Had the learned counsel for the respective parties peruse the materials on record, this court find that the defendant number 5 is a pro forma defendant, and the writ of summon was served at Hazaribagh, Jharkhand. Admittedly, the address of the defendant number 5 is of Jharkhand. The defendant number 5 has categorically pleaded that the office of the defendant number 5 is at Jharkhand, and due to which within the prescribed time the document could not be procured, for which the written statement could not be filed within the period of 30 days. Considering the above, this court finds that the defendant number 5 has shown sufficient cause for non-filing of the written statement within the period of 30 days, but has filed the written statement within the outer period of 120 days. 20 days. Considering the above, this court is of the view that the written statement filed by the defendant number 5 may be accepted subject to payment of cost of rupees 5,000. Bank, they are taking the interest. 5,000 to the High Court Legal Service Authority. Within a week from date. Full stop. The department is directed to accept the written statement subject to scrutiny by the department, and the petitioner and the defendant number 5 is directed to show the proof of payment of cost to the London master within a week thereafter, within a week from date. Full stop. The defendant is directed to serve the copy of the written statement to the plaintiff. Today your supply?
Yes, but in course of today,
in course of the day. In course of the day, GA Com 4 of 2025 disposed of. Next.
Same order. The next one is same date for same parties.
Give them 9. 8 and 9.
8 and 9, my lord. G number is not 5, not G com is number 5.
ये 5 है बाकी सब वही आएगी. Who is he? He is also
the same lot, same bank, same parties. Great.
Disposed of 5,000.
Grateful.
Yes, next.
My application for extension of time to file written statement. I would like to file a short affidavit.
Aye.
The ground, because of the ground taken.
Ground.
This suit was pending in City Civil Court. They had to have filed written statement. Now they say that was lost, so they couldn't.
No, it's not that written statement. The written statement filed in his suit.
In my suit, they had already filed written statement.
Exactly.
Here they say that was lost, so they have to prepare a fresh written statement.
So,
and took time.
So okay, I am rejecting this application, and that written statement to be taken.
Yes, I'll be very happy.
then his amendment application should also go. Original plain note.
There are that difference will be in my benefit. Very short direction of it.
My lord, there's nothing. Lord, you can kindly see, my lord, the pleading is there.
How the court?
But
Ground taken, ground taken.
19th June, we have been served with the plaint.
But this was pending and it is already filed.
See, he is the plaintiff. He is delaying the matter. Why you are?
And my amendment is.
And my lord, we have filed it on 3rd
That is
September.
allowed. Then they will get an
What objection?
What is this objection?
I'll read out the explanation, Miller. I'll read out the explanation. If thereafter Lordship feels that I don't at least don't get a chance to Miller, file a short affidavit.
Yes, I have no problem. Let him please read out. Please read out.
Kindly.
Please read out.
Paragraph number. Kindly. Paragraph number.
Okay.
50 minutes. Just read.
Read this. He can't say what is his opposition.
Paragraph 13 he says he lost the
defendant has filed the present
full
application being CA Com 2 of 2025, praying for extension of time to file return statement. For the plaintiff prays for time to file affidavit in opposition. That affidavit in opposition we filed before vacation.
Okay. I want to file the written stay immediately, my lord. Let it be taken on record subject to, my lord, outcome of the application.
No getting the matter hard before vacation. That is not an issue.
No, when you file, because today is the 18th.
He filed it in
on 3rd September.
3rd September.
I filed the application on 3rd
AO,
September.
affidavit.
In 7 days I can file it. But
7 days takes us.
Then after vacation. Within a week. Comma reply there to file within a week thereafter. List the matter on 6th November.
Only one thing, my lord. My lordship grants me liberty to let the written statement be taken on record subject to outcome of the application. It is affirmed.
120 days is over.
No, it's not. Within 120.
File it.
I'll file it, my lord.
The defendant is given liberty to submit the written statement in the department in course of the day, subject to outcome of this application.
Grateful.
Copy has been served upon me. So
I will, of course. Once it's all.
If you accept, you take. Otherwise, you have to court.
No. Then I will not make that friend.
Very well.
You file in the department.
I'll file it in the department.
Yeah, उसको लिख के दे दो.
We'll probably not get this order, my lord.
Leave. Leave is granted to submit the written statement subject to outcome of GA Com number 2 of 2020. Yes, next.
My lords, I appear for the applicant in the matter. My lords, as directed on the last date, we've served a copy of the application on the decree holder. They yet to file a reply in the matter, my lords.
May I make one submission? If it's, I'm sure my learned friend won't object, but if this application can be taken up after Starlight's application is disposed of, then because it might save the time of the court if I succeed, and I'm hopeful to succeed, but if I succeed in my matter, then we might not actually have to argue out this application.
21 Rule 58. Now comes the 47. In apprehension that if Order 21 fails, then my lord 47.
No. It's not an apprehension. It is your objection was that I'm a third party and the judgment that.
Kindly give me affidavit direction and kindly keep the maintainability, the point of maintainability open.
File affidavit.
Yes.
Who has filed judgment debtor?
Judgment debtor.
Yes, my lord.
Judgment debtor has filed the present application being GA Com 2 of 2025. Praying for, what is your prayer?
Same prayer.
Same prayer, my
It
lord.
is a nullity.
Judgment debtor has filed GA Com of 225 under section 47 of the Code of Civil Procedure. The decree holder prays for time to file affidavit in opposition. That affidavit in opposition is filed within 2 weeks after Puja vacation.
Kindly give me 3 weeks, man.
Within 3 weeks after Puja vacation. Reply EP9 reply by?
My lord, 2 weeks, 3 weeks thereafter.
Thereafter. Let the matter appear on 17th December.
Deeply obliged.
Obliged, my lord.
Next.
12 Mala, I am for the decree holder. My learned friend, the
ready with the check, my lord. The total amount is, my lord, 70 lakh 63,000. My lord, I can forego for 63,000. Your lordship, on last occasion, my lord, it was say that 70 lakhs has to be paid, my lord, and they are ready to pay in installments, my lord. So they have come with a check of rupees 5 lakhs, my lord.
Today I can submit lordship 5 lakhs lordship, which can be encashed tomorrow. Bearer's check. I'm handing it to today itself, and maybe
Well,
10 to 15 installments lordship.
What is the total amount? 66 lakh 17,500.
Yes, and the interest part. lordship.
Interest part. Interest part, interest, my lord. Thereafter, my lord, up to 15th of September is, my lord, 3 lakhs 96,000. It comes
No,
to 70 lakhs.
no, as per your tabular statement, that is 66 17,500.
Yes, my lord.
Correct. So how much you want to pay now?
Today I'm paying lordship.
Now, what is the total you have settled?
70 lakhs.
70 lakhs.
70 lakhs, but 15.
They want installments.
15 installment.
Lordship.
Let it be 10 installments, my lord. Let it be 10.
Lordship, it can
They
be,
have
lordship.
paid.
Today I'm paying.
Let it be one is 12 installment every month. 10 installment every month. And every month the matter will be fixed. You pay the check. Get it done.
10 installment.
12 installment. 12 installment.
12. Wait. 12 installment and today.
The decree holder has filed the present execution application for execution of the decree passed by this court dated 17th January 2025 for realization of the decretal amount of decretal amount, full stop. Counsel for the decree holder submit that as on today, there is the total due of rupees
70 lakhs. 70 lakhs.
As on today, 70 lakhs
63,000.
63,000. 63,000. Full stop. He submit that now the defendant has the judgment debtor has come for a settlement, and accordingly it is settled between the parties that the judgment debtor will pay rupees 70 lakhs and the decree holder will not claim the further amount of rupees 63,000. 63,000. Okay. Counsel for the judgment debtor submit that the judgment debtor shall pay rupees 70 lakhs in 12 installment of each 12 installment. In 12 installment, full stop. In view of the above, full stop.
Today they are paying 5 lakhs rupees.
5 lakhs. Lordship to be encashed tomorrow.
The judgment debtor has handed over check. It is a check or
check.
The judgment debtor has handed over a check of rupees 5 lakhs of which bank?
Lordship, Bank of India.
Give it to me.
Bank of India, Bobazar. Amount to be.
Bank of India.
It will be amount will be.
Bobazar branch. Dated tomorrow.
Tomorrow.
Dated kalga date dated in the name of the plaintiff. In the name of the plaintiff. Full stop. Considering the circumstances, considering the above, the defendant is that the judgment debtor is directed to pay rupees 70 lakhs in 12 installment. In 12 installment, 70 lakh or 12 installment, kitna hoga?
Lordship, one humble submission. I just got to know it's not tomorrow, if Monday. Monday's date, Lordship.
Post dated.
70 lakh, hai na? 70 lakhs into 12 installment, how much?
70 lakhs, 10 lakhs, 5 lakhs, 5 lakhs they are paying, my lord, and 65 lakhs in 12 installments. And my lord, they are giving post-dated check.
Of rupees 5 lakh 5,83,334 of each installment, out of which the plaintiff and the judgment debtor has paid rupees 5 lakhs, has handed over the check of rupees 5 lakhs to the defendant, to the decree holder. The decree holder is directed to pay the remaining amount. In 7 and in 11 installment. In 11 installment of each month of rupees 5,83,000. Oh, yalla, 83, 583, 334 of each installment, and the 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 remaining amount of the first installment shall be paid by adjusting the said amount in the further installments. In the further full installment. Let the matter appear on
Lordship, one humble submission, Lordship. If the installments which your Lordship is deciding on every month for 12 installments, if it could be after 20th of every month. 20th of every month.
Okay, let the matter appear on 24th of November 2020.
Every installment.
Deeply.
The copy of the check, the decree, the judgment debtor is directed to serve. अरे भरा नहीं है वो. Fill the copy of the check will be the report. Yes, next.
Grateful, man. I'm grateful.
Only one thing, my lord, before your lordship takes up the fixed matter, item number 14, we have taken out an application in the nature of an order 21 rule 2 for recording satisfaction of, my lord, the decree. Lord,
I would
item number
14, my lord. I think he wants to use an affidavit, lordship, in
lordship.
direct filing of. There's no escape. Payment is admitted.
Like
Led by Mr. Mitra.
Want to give an affidavit, let them. This was my lord's decree where election debtors to be paid 1 crore something.
The deposit.
So we have paid the money here in bank transfer, the check, but by bank transfer, so ordered by Rule 1. So now he is not recording satisfaction, so I am making an application under order.
The counsel for the respondent, defendant prays for time to file affidavit in opposition in connection with GS7.
GS7.
Yes,
GS7
GS7 of 2025. Let affidavit in opposition be filed within 2 weeks after 2 weeks. 1 week.
Lordship, keep it after the vacation.
2 weeks after vacation.
No, 1 week after vacation.
1 week after vacation. Reply, if any, there to be filed within a week.
3-4 days.
Within a week thereafter. List the matter. On 27th November.
Great.
Yes. Next. Fixed matter.
Lordship may.
Lord, with leave of my learned senior, may I make one submission before Mr. Mukherjee commences? In case it doesn't finish today, I was praying, my Lord, that we be allowed to take at least 2 lakhs for the pujas. That's subject to, it was in the appeal court, it was without prejudice. 24 lakhs I was allowed to withdraw last year. That was October last year. So that has also gone. So I was praying, in case your lordship reserves the order, then at least that much can be given.
Yes, Mr. Mukherjee.
My lord, let me conclude and then I'll, my lord. So
Okay.
that, my lord. In 15 minutes. My lord, I'm sorry, my lord, I wasn't there, my lord, on the last occasion. Mr.
Yes, Mr.
Chaudhary, my
has
lord,
argued.
yes. Now, my lord, Mr. Ghosh's, my lord, arguments, my lord, as I understood, my lord, was that this cannot be a case of fraud. Only authorized acts have been undertaken, and a case of fraud has been built up on the basis of, my lord, authorized transactions, my lord, which is not permissible. Now, my lord, your lordships would recall, and Mr. Chaudhary has even in the rejoinder, my lord, dealt with this issue, that, my lord, the case is one of agency and fiduciary, my lord, duty, my lord. Here, my lord, section 88 principles and tracing, my lord, apply. And, my lord, here, my lord, I have trust and confidence. I do not expect anything to be done, my lord, to my detriment. I am, my lord, reposing, my lord, trust and confidence, my lord, on, my lord, somebody who's worked with me for over 12 years. My lord, I give, my lord, what we do, my lord, within a family maybe. My lord, we give, my lord, our mobile, my lord, password. We give, my lord, our bank account password. My lord, these are done usually, my lord, with someone whom you trust. Now, my lord, this particular gentleman, my lord, agency is admitted. My lord, even, my lord, in, my lord, the affidavit. Now, my lord, section 88, my lord, shows the nature of the relationships which give rise to, my lord, a fiduciary obligation. That being the position, my lord, this argument cannot stand at all. My lord, it's not, my lord, a case of, my lord, just, my lord, simply authority. My lord, it's much more than that. My lord, it's coupled with a fiduciary obligation and a fiduciary duty. And your lordship recalls the charts, my lord, how, my lord, money comes, immediately goes out, my lord. That is there in your lordship's order. So, my lord, this line of argument, my lord, is completely, my lord, without basis. Now, my lord, another argument has been made regarding section 60 of the Code of Civil Procedure. My lord, my lord, kindly take, my lord, the code. My lord, section 61. My lord, may I just place that, my lord? Section 60, subsection 1.
Yes.
The following property is liable to attachment and sale and execution of a decree, namely lands, houses, or other buildings, goods, money, banknotes, checks, etc., government securities, bonds, or other securities for money, debt, shares in a corporation, and save as hereinafter mentioned, all other saleable property, movable or immovable, belonging to the judgment debtor, or over which or the profits of which he has a disposing power, which he may exercise for his own benefit, whether the same be held in the name of the judgment debtor or by another person in trust for him or on his behalf. Now, my lord, my learned friend relies on, provided that the following particulars shall not be liable to such attachment or sale, namely, kindly come to KB, my lord.
Yes, KB.
All monies, kindly mark the words, my lord.
Policy and no insurance.
No, my lord. All monies, the operative word, my lord, is payable under a policy of insurance on the life of the judgment debtor.
Correct.
It's not paid. It is payable. Now, my lord, kindly have a look at explanation 1. The monies payable in relation to the matters mentioned in clauses G, H, I, IA, J, L, and O are exempt from the attachment or sale, whether before or after they are actually payable. And in the case of salary, the attachment portion thereof is liable to attachment, whether before or after it is actually payable. Now, my lord, the first submission, my lord, I make here is, my lord, I had cited cases to your lordship, my lord, saying, my lord, insurance money is, my lord, part of the estate of the deceased. Now, my lord, my learned friend, my lord, agrees, the only thing he agrees to, my lord, is with, my lord, that proposition, my lord, that it is part of the estate. Now, my lord, once that is paid, it can be subjected to, my lord, an attachment. Because, my lord, the estate acquires a disposing power over it. My learned friend has cited cases saying, my lord, that the insurance companies, my lord, could not have, my lord, been, my lord, restrained. My lord, apropos, my lord, this, my lord, insurance policy payable amounts. And, my lord, he has cited,
yes,
my lord, 3 cases. One minute. My lord, he cited, my lord, 3 cases. My lord, the first case he cited, my lord, on, my lord, the character of, my lord, money payable under a policy of insurance. My lord, once, my lord, the policy holder dies, it belongs to his estate. So he accepts, my lord, and I cited those cases as well. That's 1984, 1 Supreme Court cases, 424. My lord, that's my lord Sarbati Devi and another.
Citation, what is the citation?
My lord, 1984, 1 SCC 424. So I have, my lord, no problem here.
Yes.
Then, my lord, is, my lord, 2010 SCC online, Andhra Pradesh, 216. Then, my lord, All India Reporter 1986 Bombay, 101. 101, my lord.
Yes.
And then, my lord, 2002, 3 Log Weekly, my lord, 600.
Yes.
My lord, for the proposition, my lord, that, my lord, this money in the hands of the insurance, my lord, company, my lord, cannot, my lord, be attached. My lord, now, all these cases, my lord, have been dealt with, my lord, in, my lord, a decision of the Bombay High Court, my lord, reported in 2021 SCC Online Bombay 3970.
2021.
SCC Online Bombay 3970. Give Dhruva a copy. My lord, kindly, my lord, have a look at, my lord, the first paragraph. The short but important question that has arisen during the hearing of this interim application, IA, pertains to whether or not proceeds of an insurance policy on the life of a judgment debtor can be attached after maturity of the policy, or whether by virtue of section 61 KB of the Civil Procedure Code 1908, the proceeds continue to be protected against attached judgment debtors. Now, my lord, kindly come straight away to para 32. Yes, my lord. My lord, I'm sorry, my lord. I should show your lordship para 6 first, which will show, my lord, that all these cases which have been cited have been considered. My lord, paragraph 6. Lordship has that, my lord? Page 3. I have therefore heard the learned counsel for the parties on the limited aspect as to whether the proceeds of the aforesaid policy can be subjected to any restraint order at this stage. Mr. Charalwar submitted that the proceeds of the LIC policy cannot be attached in execution. He relied upon section 61 KB of the code and submitted that monies payable he submitted that monies payable under a policy of insurance on life of defend number 3 cannot be attached. In support of his contentions, he relied upon the following decisions. Then, my lord, the submissions are recorded. And then, my lord, Rebello submissions, my lord, are, my lord, referred to from paragraph 9 onwards, my lord. And then, my lord, kindly come to, my lord, paragraph 13, where section 60 is set out. And, my lord, the cases, my lord, are, my lord, considered.
Yes.
My lord, which, my lord, I will not trouble your lordships, my lord, with. Kindly come to, my lord, para 30. My lord, I am starting with, my lord, para 32. My lord, print page 15.
Yes.
Kindly see. My lord, the court has in Federal Bank considered the aspect where the money is payable under a policy of under a policy on the life of a judgment debtor after the latter's demise can be attached, or whether payment of such monies to a nominee can be restrained in a suit for recovery of money. In the facts of that case, the bank had advanced certain monies to one of its constituents. After his demise, a suit was instituted. The deceased had life insurance policy issued by LIC. His widow being a nominee, bank filed an attachment for attachment of insurance policy, and the trial court granted the alternative prayer restraining the insurance corporation from paying the amount of sum assured under the policy, much like I have done in the present case. Then the suit later came to be dismissed for default. The trial court then passed a further order against so-and-so, restraining them from receiving amounts under the policy. Later, the suit was restored to the file. The bank sought an order in the alternative, directing the defendant's widow to furnish a bank guarantee for the sum claimed in the suit. That application was dismissed on the ground that amounts payable under the policy of insurance cannot be attached, and an appeal came to be filed against the said order. Section 61 KB of the code was relied upon by the appellant, and it was contended that if the money becomes payable after the death of the assured, the monies form part of the estate of the deceased and can be attached. Reliance was placed on the decision of the Allahabad High Court in so-and-so. The full bench of the Allahabad High Court held in Rajaram Mata Prasad that a policyholder continues to hold interest in the policy till the moment of his death, and if the policy matures during his lifetime, the benefit shall be his and not that of his nominees, and those monies may be seized by the decree holder for payment of his loan. This view is seen to have been approved by the Supreme Court in Sharbati Devi, which held that under Section 39 of the Insurance Act, policyholder continues to hold interest in the policy during the lifetime, and that the nominee acquires no interest during lifetime of the policyholder. On the demise of the policyholder, the amount payable under the policy becomes part of his estate, which is governed by the law of succession. In paragraph 8 of the decision in Federal Bank, this court has held that in view of the decision in Sharbati, it is no longer possible to hold the view that monies payable under an insurance policy do not form part of the estate of a deceased. But the question before the court was not whether or not the said monies would become part and parcel of the estate. The question was whether the monies are liable to be attached for payment of a decree. The court considered the policy of the legislature that caused the exemption to be laid down and opined that the legislator had exempted from attachment of the monies payable under a policy on the life of the judgment debtor in order to give some security to heirs and legal representatives. It is observed that even though the monies become part and parcel of the estate, the exemption in clause KB follows the same monies. The court concluded that monies payable under an insurance policy on the life of a judgment debtor are entirely exempted from an attachment and sale by virtue of clause KB, irrespective of whether the insurance policy matures during the lifetime of the assured or the monies become payable after his death. The court was hearing an appeal against an order of the trial judge dismissing an application for injunction filed by the appellant on the ground that since monies were payable under a life insurance and were not subject to attachment, it was not proper to restrain LIC from making payment to the beneficiaries. Thus, the court had arrived at the aforesaid reasoning and the appeal came to be dismissed. Considering all of the above, in the facts of the present case, I am clearly of the view that since the policy matures during the lifetime and once the payment of the, kindly note this, and once the payment of the maturity value is made by the insurance company and the funds are paid out of the insurance company, the funds would lose the protection under Section 61 KB of the code. The safe confines of Provident Fund, pension and compulsory deposits do not encompass amounts paid on maturity of a policy of life insurance. To that extent, I respectfully find that the explanation to Section 60, subsection 1 of the code not having been considered in the judgment, the aforesaid decision stands distinguished. Then para 36. In these circumstances, I am not inclined to vacate the order directing life insurance to retain the amount. However, since the policy has now matured and LIC is not required to retain the funds, I have considered the submissions in the affidavit which incorporate a prayer that judgment debtor number 3 be ordered and directed to instruct LIC to deposit with branch the original policy along with discharge receipt, and the judgment debtor be ordered to instruct LIC to remit maturity proceeds to the account of the applicant mentioned in para 8. In my view, it would not be appropriate that the amount that is owing from LIC to judgment be directed to be paid to the applicant plaintiff. Considering the state of the facts, I pass the following order. Life insurance is directed to deposit maturity proceeds of policy in the name of so-and-so with the Proto-Notary and Senior Master High Court Bombay within a period of 1 week from service of certified copy, etc. Then upon receipt of funds, Proto-Notary Senior shall invest the same in a short-term deposit initially for a period of 3 months, so and so. And defendant judgment debtor is upon deposit, hand over the policy, etc. So, my lord, should not remain with insurance company. My lord, should come in here. And, my lord, it should be, my lord, deposited in the custody of the court because it loses this protection, my lord, momentarily. And this is apparent, my lord, from, my lord, the explanation itself.
Yes.
KB, my lord, has been left out, and, my lord, this, my lord, is, my lord, the case. Now, my lord, my learned friend has cited, my lord, a decision on, my lord, non-vigilance. My lord, this is, my lord, 2018, 11 Supreme Court cases, page 1.
Yes.
Oh, sorry, my lord, one more case I need to distinguish. One more case, my lord, I'm sorry. My lord, which was, my lord, cited. My lord, Radhesham.
Radhesham, yes.
Yes, my lord, this is, my lord.
Pension, gratuity and not.
Yes, my lord. Now, my lord, this is, my lord, the case of gratuity. Now, kindly have a look, my lord, at, my lord, explanation 1. My lord, first, my lord, have a look at, my lord, G. Provided that following particulars, that the following particulars shall not be liable to such attachment or sale, namely, kindly come to G, my lord.
Where you are reading?
My lord, CPC, my lord.
Yes. Yes.
Kindly see G. Stipends and gratuities allowed to pensioners of the government or of a local authority or of another employer or payable out of any service family pension. So, my lord, it is stipends and gratuities allowed to pensioners of the government or of a local authority or of any other employer or payable out of any service family pension fund notified in the official gazette by central government or state government in this behalf, and political pensions. Now, kindly see the explanation. My lord, G is included. Explanation 1.
Yes.
Monies payable in relation to matters mentioned in clauses G, H, I, so and so are exempt from attach whether before or after they are actually payable. And KB had been left out, and that's the distinction, my lord, which has, my lord, been, my lord, drawn. Now, my lord, I come to yes. What? Oh, yeah. My lord, the non-vigilant, my lord, litigant. Now, my lord, kindly have a look, my lord, what this case was about. My lord, kindly take paragraph 1 first.
Citation.
My lord, this, oh, sorry, 2018, 11 Supreme Court cases, page 1. Oh, sorry, 2008, 11 SCC, page 1.
Yes.
Now, my lord, kindly take, my lord, paragraph, my lord, 2 rather, my lord, at page, my lord, 3. My lord, print page, my lord, 3.
Yes.
The appellants herein are aggrieved by and dissatisfied with the judgment and order dated 6 March passed by the High Court of Karnataka, whereby and whereunder the private respondents herein were allowed to make construction on the lands in the suit, subject to decisions therein. It was furthermore directed that any alteration or creation of an interest by the defendants would be subject to the decision of the suit. My lord, this was, my lord, in issue. Now, my lord, I want to show your lordship, my lord, what the facts were. My lord, there was partitions, prior, my lord, adoption. But, my lord, the case, my lord, of, my lord, the, my lord, respondents is best summed up, which will give, my lord, the factual texture of the case. My lord, para 14. Kindly come to page 6, my lord, of the report, which is also page 6 of the print.
Yes.
Kindly see. Mr. K.K. Venugopal, Nalini Chidambaram, and Rohinton F. Nariman, learned senior counsel, appearing on behalf of the respondents, on the other hand, submitted. Now, kindly see the facts. The partition having been effected as far back as in 1924, and the principal respondents having been in possession of the suit properties from 1956 till 2003, 57 years. When they granted a lease in respect of 1/3 of the property, the impugned judgment should not be interfered with. Now, my lord, next. Even an advertisement was issued for sale of 1/3 land in the year 1985, and the deed of sale was executed on 25th July 1989. So, my lord, there was a dispute as to, my lord, a property. My lord, one set was in the respondents, who, my lord, formed part of the larger family. My lord, had been, my lord, in possession earlier. My lord, there was an adoption, my lord, so they go into another branch of the family. And there was a partition also, which had, my lord, taken place. And this property was in exclusive possession. And, my lord, lease granted, sale, and notice to the public that the sale is happening. Then, my lord, kindly come to clause 2. Admittedly, as would appear from the photographs appended to the counter affidavit, huge constructions have come up on the lands in question, and as such, there was no reason as to why the appellants had kept quiet for so long. Now, my lord, this is happening in the middle of, my lord, Bangalore. And, my lord, there is, my lord, a structure is coming up over 1,65,000 square feet. That's the figure mentioned, my lord. Your lordship will find that. And then, my lord, now, third, my lord, kindly see what is happening apropos that property. A large number of documents have been filed before the courts below, not only showing dealing with the properties, that is lease and sale, but also showing execution of deeds of lease, payment of corporation tax, income tax, capital gains tax, which clearly point out separate possession of the properties of the defendant. Now, my lord, not just that, complete dominion of the property. My lord, rent payable by tenants at the property, my lord, nobody else is collecting. Kindly see. In view of the fact that they have been collecting rent from tenants themselves, would show that the appellants have no prima facie case. These documents having been filed before the learned trial judge, it committed a serious error in not taking the same into consideration, and thus the High Court has rightly interfered therewith by reason of the impugned judgment. And then, my lord, now, my lord, kindly come to para 15. My lord, when I mentioned 1 lakh odd square feet, my lord, kindly see. The property in question is indisputably a valuable property, is situated in the heart of the commercial area of the town of Bangalore. The land in question had measures 1,70,000 square feet. In that, construction coming up.
Nobody knows.
Yes, everything. It's open and my lord, earlier notice is given. And then kindly see the question. The principal question which arises for consideration is as to whether the properties in question were the subject matter of a partition purported to have taken place in 1924 or subsequently or not. Then, my lord, kindly come to paragraph 18. My lord, placitum G. Sentence starting prima facie. Lordships have that.
Yes.
Prima facie, it appears that the respondents had been in possession of the properties in suit for a long time. The heirs of Thimaya had admittedly been dealing with the properties exclusively. The appellants never exercised any act of possession. The learned trial judge in his judgment itself observed, no doubt there is no reference to suit properties as belonging to joint family property. This may be a point in favor of defendants in support of their contention that suit property was already divided in 1924 and therefore these documents do not contain reference to suit property. Then, my lord, kindly come to para 20. My lord, placitum's, my lord, 3 lines below, my lord, placitum C. Apart therefrom, your lordship has that, my lord.
Yes.
Apart therefrom, evidently, the deed of lease was executed in the year 63 in respect of 1/3 of the suit scheduled property. It was renewed in the year 1969. The property was developed and their nature and character thereof was changed from time to time. A registered deed of lease was executed in the year 68. A deed of partition was also executed in 71. A deed of lease was executed in 77. A public notice was also issued in the year 85, whereafter a deed of sale was executed in 89. Then, my lord, now all these were out in the open. And, my lord, admittedly, this property was not in the name of the plaintiffs. This was, my lord, not even claimed as joint family property, my lord, in the documents which had been shown. My lord, they went on to say, look, there was no partition of 24. When the adoption happened, I was part of this, and therefore it all now belongs to joint family, though documents say to the contrary. In that context, when overt acts were taking place, high-rise construction coming up, lease executed, sale effected with public notice, my lord, no act of, my lord, no complaint. Next, more importantly, no act of possession. My lord, all rates, taxes, my lord, were being paid by the respondent. Plaintiffs were not doing anything.
Yes.
It was in that context where, my lord, every act was overt.
Then filed the suit.
Yes, and my lord, then, my lord, conduct is you sit by, you do nothing, you do not protest. Yeah, my lord, it is, my lord, act done, my lord, under the cloak, my lord, of secrecy, in breach of fiduciary duty, which we only come to know of after he dies.
Immediately you file the suit.
And correct. So, my lord, there is, my lord, conduct, my lord, is, my lord. And, my lord, at the end of the day, my lord, even here, my lord, there was, my lord, no restraint on construction. But, my lord, what was said, that if you sell to, my lord, anybody, any portion which you are constructing, then you have to put them on notice of this litigation and make it clear that it's subject to the ultimate decision. That's para 27. Which was really, my lord, the High Court order as well.
Carry out construction subject to the ultimate decision. Yes.
Now, my lord, next, my lord, 4 cases, my lord, have been cited, my lord, on suppression. Now, my lord, your lordships will kindly note, my lord, I have no dispute, my lord, with the propositions, my lord, in any of these cases. My lord, the first is, my lord, General Manager, Haryana Roadways.
Yes. There are 4 cases.
Yes. Now, my lord, kindly take, my lord, 2008, 4 Supreme Court cases, 1 to 7 first.
Yes.
Now, my lord, kindly take kindly see, my lord, who is the appellant. My lord, it was the state. My lord, who was, my lord, the respondent? My lord, the driver of Haryana Roadways. State was, my lord, after having entered into a settlement and implemented the award, my lord, challenged the award without disclosing that it had implemented the award. And on that basis, my lord, kindly see, my lord, paragraph, my lord, 10. My lord, my lord, kindly see, my lord, first para 8. My lord, specially petition, my lord, was entertained. Notice was issued. Kindly have a look at para 8. A notice in this matter was issued by this court on 1st November. The first respondent in his counter affidavit brought the aforementioned facts to the notice of the court. When the matter was heard on 7 December, court observed. When the matter was called out, learned counsel has produced before us a letter whereby services of respondent number 1 have been regularized as a driver with effect. Said fact has not been mentioned in the list of date. It appears that questioning the award passed by so-and-so, a writ petition was filed, which was dismissed. When the matter came up before this court not only issued notice but also issued notice on prayer for entry. Therefore, evident on the one hand, petitioner has been questioning the jurisdiction of the industrial court to direct reinstatement with full back wages. On the other hand, itself has been passing such orders. One of the ground taken is that the appointment of respondent number 1 in service was not on a sanctioned post and he had abandoned the job so-and-so. Let notice be issued to the petitioner as to why an appropriate order shall not be passed against administration in view of the fact that they're taking one stand before the court but acting otherwise on administration side. Now, my lord, this was the issue. You have come and taken a stand before the court, but what you have suppressed from the court is that you yourself are taking the stand, are taking a completely contrary stand and implementing the award which you say was without jurisdiction. Now, my lord, kindly come to para 10 now. We have noticed the specially petition by so-and-so, regularize or not. The delay occurred in filing was 720. However, it appears 47 was taken in obtaining study. We fail to understand how even in a case of this nature, where the state pretended to be so serious in obtaining a principle of law determined by the court, such a delay took place both in filing and also suppression of material fact is, kindly mark the word, my lord, material fact is viewed seriously by the superior courts exercising discretionary held. As a general rule, suppression of material fact disqualify from this rule has been evolved out of to deter, but the suppressed fact must be material, one in the sense that had it not been suppressed, it would have had an effect on the merits of the case. My lord, that is what is material. Yes. Had it not been suppressed, it would have had an effect. The said observation was quoted with approval by one and us, whether how far and to what extent suppression of fact by way of non-disclosure would affect or the court notices that so as to enable it to refuse to exercise its discretionary jurisdiction. The suppression must be of material fact. What would be a material fact? Suppression whereof would depend upon the facts and circumstances of each case. Then, my lord, it says High Court in over and above is also, it's therefore necessary when a party must place all facts without any reservation. If there is suppression of material facts on the part of the applicant or twisted facts have been placed, writ court may refuse to entertain and dismiss it. Had the aforementioned facts been brought to the notice of the court, might have been even delay in filing, etc. Then, my lord, this is, my lord, the position. So, my lord, the test is, my lord, material fact. Yes, and my lord, what, and my lord, here, my lord, what a material fact, my lord, is, it would have had an effect, my lord, on the merits of the case. This is, my lord, the issue. My lord, what they refer to, my lord, is the payment of commission. And my lord, what? My lord, what effect would that have, my lord, with the greatest of respect, my lord, on, my lord, this stealing, my lord, which has been done? Cannot condone it.
Yes.
And my lord, kindly note, my lord, what is the fact, my lord? Payment of commission, the returns don't even disclose it. The income tax returns don't even disclose this.
Yes.
Now, my lord, kindly take, my lord, 2025 SCC online SC 556.
Yes.
My lord, this related to the Auroville Trust, my lord, in Puducherry. Today it's called Puducherry, my lord. It used to be Pondicherry those days. My lord, what happened, my lord? Members, my lord, a small group, my lord, were, my lord, not interested in letting, my lord, the trust board function. They started filing litigations against each other and obtaining, my lord, several reliefs, which affected, my lord, the functioning of the trust. My lord, in one litigation, my lord, all the previous litigations and their failure in those litigations, my lord, were not disclosed. And interim orders were sought. It is in that context, my lord, that, my lord, and they would have affected the merits of the case. Kindly see para 6.
Yes.
Take instruction. You don't become the client. It appears that some disgruntled residents of Auroville, instead of cooperating the governing body of the foundation in implementation of the legally approved master plan and in carrying out the development as per head master plan envisaged by the mother, started by filing 1 hour, dragging appellant and transpiring following litigations came to be filed. My lord, there's a, my lord, full list. Then, my lord, now kindly see, my lord, para 7, analysis. My lord, about 7 lines, my lord, after that. As narrated here in, I'm sorry, my lord, paragraph 7, print page 15.
Yes.
My lord, about,
Yes,
my lord,
narrated, yes.
as narrated, one Mr. Suraya and his father filed series of petitions, one after the other. They all came to be dismissed by the High Court. Then the present respondent, Natasha Story, herself filed writ petition seeking almost the same relief as sought in the writ petition of the present proceedings challenging the office order. The earlier writ petition, having been dismissed by the High Court vide order, again she filed writ petition without disclosing the fact of her filing the earlier petition and dismissal. The appellant foundation had raised specific preliminary regarding maintenance, regarding, however, High Court, without dealing with such a entertained writ petition, so and so. Then, my lord, the doctrine of clean hands. My lord, repeated petitions by one group, one individual of that group, one writ petition, dismissed without disclosing it, files an identical writ petition.
Yes.
Then, my lord, para 19. Just kindly take para 19. As demonstrated earlier. What?
Yes.
My lord, as demonstrated earlier, some disgruntled and discontented residents kept on filing petitions one after the other, dragging the appellant foundation into unnecessary writ petition file. Was one such ill-motivated petition file to hamper development and to cause of, hence it's dismissed. Then, my lord, Justice, my lord, 2004-7 Supreme Court cases 166.
Yes.
My lord, here a suit had been filed, my lord, for an identical relief. Writ petition, my lord, was filed without disclosing it.
That is a suppression.
Court said not a suppression because there is not a material fact. Exercise of writ jurisdiction does not mean. Yes, my lord, court could still have exercised the jurisdiction. I want to show your lordship that, my lord. Paragraph 14. Kindly, my lord, take para 14. Page 174.
Yes.
It has to be a material fact. My lord, assuming that the para 14, 174, my lord, I think print page 9.
Yes, got it.
Assuming that the explanation given by the appellant that the suit had been filed by one of the directors of the company without knowledge of the director who almost simultaneously approached the High Court under 226 is unbelievable. The question still remains whether the filing of the suit can be said to be a fact material to the disposal of the writ on merits. We think not. And then, my lord, kindly come to the last 4 lines. Therefore, the fact that a suit had already been filed by the appellant was not such a fact, the suppression of which could have effected the final disposal of the writ petition.
Yes.
So, my lord, here it wasn't, my lord, dismissed, my lord, for my lord. Then, my lord, the last case which has been cited is 2013, 11 Supreme Court cases 531.
Yes.
My lord, for my lord, the proposition that, my lord, the petitioner cannot choose as to what, my lord, para 42 to 44. That all facts have to be disclosed.
Yes.
Now, my lord, what is important, my lord, is according to us, we have disclosed all the material facts. We have not chosen facts relevant for the case where there was, my lord, a breach of fiduciary duty. My lord, I have disclosed. My lord, I am not choosing, my lord. I am saying that I am choosing only this fact. What is relevant for the case has all been disclosed. And that is exactly, my lord, the prior Supreme Court, my lord, which I cited, my lord, 166, 2004 7 SCC 166. Yes. My lord, a letter, my lord, was, I believe, cited to your, shown to your lordships, my lord, of 26th of March 2025. When was that order? Affidavit? Affidavit refusal. Supplementary affidavit.
Yes.
My lord, on 11th of March, my lord, 2025, my lord, an opportunity was sought to file a rejoinder to the affidavit in reply, my lord, which had been, my lord, filed on, which had been 8th of January 2025, and my lord, orders had also been passed, my lord, on 15 January 2025. The lordship, my lord, refused, my lord, them leave to, my lord, file, my lord, an affidavit in response, my lord, to our rejoinder. Because they had it for so long. After 2 months, my lord, they came and said, we wish to file a rejoinder. That happened on 11th March 2025.
Yes.
Then, my lord, comes, my lord, this letter, which we have not, my lord, responded, because this is, my lord, according to us, really, my lord, to get rid of, my lord, your lordship's refusal to circumvent that, my lord, that this letter has come.
Okay.
Because now, my lord, it says they were in a position, my lord, to file, my lord, a rejoinder or reply to our, my lord, rejoinder when they mention the matter. Now, they, my lord, start questioning, my lord, our, my lord, balance sheet. And, my lord, documents pertaining to, my lord, persons who are not even parties to the suit. So we, my lord, thought it fit, my lord, not, my lord, to respond. The lordship can look at, my lord, the queries. I'm not going to trouble your lordship, my lord, with this. My lord, non-response, my lord, to this my lord, does not, my lord, affect the case, my lord, in any manner.
Yes.
Now, my lord, my lord, may I deal with the, my lord, I'll just deal with the request which my learned friend, my lord, has made. My lord, monthly expenditure statement, which we had disputed, was furnished, my lord, by the defendant, recording monthly expenses to be rupees. This is page 99, I think. My lord, if there affidavit in opposition, lordship will kindly look at that.
Page 99.
Yes, of the affidavit in opposition.
Yes.
Now, my lord, lordship recalls, my lord, 24 lakhs, my lord, was made available to the defendant pursuant to the order, my lord, of the division bench
Yes.
on 3rd of October 2024.
Yes.
Now, my lord, this amount, my lord, would cover, according to their calculation, 14 months. My lord, this is the order, my lord. I don't know if your lordship has that. 14 months, 18 days.
Yes.
Because, my lord, 1,64,240 is 5,475.
One lakh 64,640. This is the expenditure.
Yes, that's what she's claiming. Says that I need money, I'm suffering, I need. Now, my lord, we gave 24 lakhs.
Yes.
We agreed to that, my lord, we've come back. 24 lakhs should last her till 25th December. I've got the calculation.
So
But if my learned friend, my lord, wants something for, my lord, just for pujas, my lord, I can take instructions and come back to your lordship. Otherwise, this covers it. So we just say yes one time. Huh? My lord, I'll take the risk, my lord. My lord, without prejudice to our rights and contentions, let them have. My lord, 2 lakhs as a one time for puja. My lord,
not every
no, every time. This was, my lord, again 24 lakhs at puja. They came and asked October 24. Because then, my lord, I will show, my lord, the lifestyle, my lord, because, my lord, the lady concerned is on social media. My lord, if I'll start showing those, my lord, what is happening? There's really no need for money.
I have to deal with this judgment.
So deal with it.
Which judgment?
My learned friend cited a new judgment. I'll
Achha.
have to deal with that.
বলেছিলাম না সাইড করতে
So after
2 o'clock. I don't want to rush your lordship, but I can finish it.
but
Or
today,
on
today
Monday.
my appellate side is there.
Or on Monday for 5. I'll take about 5-10 minutes because I need to show that this is completely distinguishable on our as to our case, and the proposition cited by me are remains. It's not been overruled or anything. Or tomorrow 5 minutes or 10 minutes your lordship gives me.
कल कोई time है क्या? ठीक है.
One decision.
Time नहीं है. और appellate से वो है हमारा ना नॉन कमर्शियल है ना 2 बजे तो नॉन कमर्शियल है. How much time will take?
10 minutes.
Well, from 5 it become 10. Could become 15 also.
That's why if
My
it's that
learned
then
friend took 15 minutes today, so that is actually 45 minutes. So I'll take 10 minutes maximum.
so then come at 10 and 10:30.
Yes.
After to be mentioned,
Very
you finish it off.
Yes.
And tomorrow I will pass that order.
Very.
Counsel for the plaintiff has concluded his argument. Full stop. Counsel for the defendant prays for counsel for the defendant
My lord,
to give reply to the judgment denied by the plaintiff. In reply, let the matter appear tomorrow at 10:30.
and my lord, the interim order is till 24th, my lord.
So tomorrow mention I will
Yes, my lord, your lordship said until further orders. Today your lordship's passed an order. That's why
tomorrow I will not
Very well.
extend
But, but before your lordship rises, before your lordship rises, my lord, I had mentioned this matter in the morning for extension of their interim order. Lordship had asked me to give another notice. I've given another notice on the other side.
Which
my lord.
matter?
Flint Group, my lord, item number 43. The interim
43?
order, yes, my lord, interim order expired yesterday, my lord, we missed.
43 में record करो.
Okay.
Counsel for the plaintiff has mentioned the matter after notice to the learned counsel for the defendants, but in spite of the notice, none appears on behalf of the defendant. Counsel for the plaintiff prays for extension of the interim order. Accordingly, interim order is extended till 19th November 2025 or until further order, whichever is earlier. The matter, let the matter remain in the list.
I seek leave of your lordship to file a suit, my lord, and to expedite the scrutiny of the plaint file, because now, my lord, I am told the process is once the plaint is presented before in the department, the scrutiny happens first and then it comes up before your lordship for presentation. Earlier, it used to be the reverse. It used to come to your lordship. Lordship, if the plaint is admitted, then subject to scrutiny. But the department is saying they will take.
Change this.
But I do not know. I do not know. My advocate on record is saying that the department is saying they will take minimum of 2 days to scrutinize the plaint, and then if your lordship could ask your lordship's officer to intimate to the department there's some urgency in the suit, commercial suit, some urgency.
हाँ उनको बोल दो फाइल को होगा स्कूटी से पहले प्रेजेंटेशन में आएगा.
Grateful, man.
Yes, call the man.
And my lord, if file, my lord, I'll make that fair later. Of course, let it be fine.
I have the state respondent, lordship.
Yes. Who is for the petitioner?
Sir, I appear for the petitioner.
Yes. What is the matter?
I'm taking the point of Millard. According to me, Millard, this writ petition is become infructuous because they are challenging the tender, Millard, which has already been cancelled.
Millard, tender may be cancelled. Millard, there are certain remarks against me, Millard, in the tender evaluation sheet, Millard, which is against me and which will remain against me. Without any basis, Millard, they have made certain remarks.
So then it is to be decided on affidavit whether the remark is.
Yes,
ma'am. Then it is to be decided on affidavit.
Then, Millard, let them disclose the documents, Millard, in their affidavit, that how they have come to such a conclusion.
Let them file the affidavit. If you want that remark is to be deleted, or you are ready to delete, then I will dispose of herein now.
No, Millard, let us come back before his lordship with an affidavit. Millard, there are certain discrepancies, and that's why, Millard, they have been blacklisted.
That will better. That
is better.
The respondent says that the petition filed by the petitioner has become infructuous as the tender in question has already been cancelled by the authority. Learned counsel for the petitioner submit that the tender might have been cancelled, but the respondent authorities, while evaluating the tender document, has made some observation against the petitioner and is recorded the same in the evaluation.
Yes. Technical evaluation sheet.
Technical evaluation sheet. And he submit that observation, if that observation is not set aside, the observation will remain in the technical, remain in the record, and as such, the observation made by the authorities in the technical bit sheet is to be deleted. Learned counsel for the state submit that with regard submit that in view of the same, let affidavit press for time to file affidavit in opposition. Okay. Let affidavit in opposition file within 2 weeks after visa vacation. A reply, if any, thereto within a week thereafter. List the matter on 27th November 2020.
But your lordship may not be troubled with the papers. I'll just show your lordship the order at the end. But this arises out of not a order passed by the insurance ombudsman. Now, insurance ombudsman. There's already an earlier order of the court that he's to give a reasoned order. He hasn't. So, it's no point sending it back is possibly not the situation. So, I'll be asking for an order based on what he has written there. Now, I'll just give your lordship the background. Facts are very simple here, recorded in the order. I'm not going out of any fact which is not there in the order. So, the situation here is this. I bought a insurance policy. Now, apparently, there are two kinds of insurance policies, digital and non-digital. Not, of course, I didn't know this. Your Lordship obviously has experience with insurance policies. Now, it seems that the benefits of both types.
I have a very bad experience in the insurance.
But so have I, and so is this one also. But
I had to go to the consumers forum for recovery of my insurance policy.
But I'm myself personally stuck where I had to stop paying policy premium. Now their rule is you can't even get that back for 5 years and no interest.
Yes.
Anyway, not leaving that apart. So not there is a choice between a digital and a non-digital policy. Apparently, the benefits are exactly the same. The premium is the same. But the returns on the digital one are much higher. Now, at the point of selling it to me, they did not tell me this. But immediately after not paying the premium, I told them, look, you didn't tell me this difference. Make this from a non-digital into a digital policy. So no reply. Ultimately, legal notice goes. When the legal notice comes, it's a one-liner saying, go to HELL. So ultimately go to the grievance redressal committee, which does nothing. And then we go to the ombudsman. Now, the ombudsman does nothing for months. So we filed a writ petition and the order passed there is dispose of it and give reasons. And that's what the ombudsman rules also say. Now there is also the rules have also been interpreted to mean that lawyers are also entitled to be present, or you are entitled to be represented by a lawyer. Now what happens there is they don't give admission to my lawyer. It's an online hearing, and not initially given admission, then that is cut out. The lawyer is thrown out. Those lawyers happen to be sitting over here, but not now. It's in this background that the order is passed. It's a 1.5-page order. I'll just trouble your Lordship only with that.
Who is appearing? You?
Well, I'm appearing for respondent number.
Lord, just see how as they say, Lord, in Alice in Wonderland, curious here and curious here. Please see, Lord, what happens. Please go, Lord, to page 189. That's the order. Now it's in very small print, but
yes, 189.
Yes, Lord, your Lord. Hey, it's the other one. Lord, I'm sorry, Lord. Lord, there are two identical matters, similar. Item 2 and 4. Lord, in this case, it will be page 184.
Yes. Yes.
Same order, too. Lord, brief facts of the case, 2 lines. The complaint's grievance is that the insurance company is not acceding to her request for conversion of the policy from non-digital to digital mode, and thus depriving her of higher maturity value.
Yes.
Blood contention of the complainant is not set out over there. I'm not troubling your Lordship. I've given your Lordship the facts. Everything which I stated is over there.
Can it be decided without affidavit?
Lord, it's admitted. That's why I'm saying.
Okay.
That's all I'm saying.
Okay.
Lord, so, Lord, forget not my contentions. Then, Lord, relief sought for convert. That's all. I'm not reading that.
Yes.
Now come to contention of the respondent. Now, there, Lord, I'll just preface this with 3 sentences. Lord, the client, Bhavna Khimani, was not allowed a lawyer's presence. So she argued it on her own. A question was put to her, look, you want conversion from digital to non-digital, what's the difference? So she said, look, the returns on that are much higher. So they said, where's the proof? So she went to the Tata AIG app and showed that the returns are different. Everything else is the same. And emailed a screenshot that is recorded over here. Thereafter, hearing finished, lawyer of the insurance company is asked to react. He gave some reaction. He said that this is doubtful. This is not the language used is. He says it is doubtful. I'll take that, your Lordship. Now, just give me one moment. So I have no chance of dealing with it. Now it's his app. His app is shown to show that the returns are different. I've annexed it. I'll go to that. He says it's doubtful. I don't have a chance to react it, and the order is passed thereafter. This is the situation. Now, please see the contentions of the respondent. The above policy referred to was issued in the life of Bhavna Khimani. Insurance company has received a proposal application form from the aforesaid LA for insurance on their own life. Before the plans hereinafter shall be mentioned as insurance policy plan. Accordingly, policies have been issued on 30th March. A copy of the application form, sales illustration, acceptance email are annexed here to and marked Annexure A. Now, The policy is sourced through Bajaj Capital Insurance Broking Limited. We confirm that our official had made proper explanation in respect of the details of the terms and conditions and features and consideration of the aforesaid plan, and the LA had submitted above mentioned application form only after having been duly convinced about the details of the plan. Then Lord Para 3. This is important. The LA has confirmed that she has received and read the application form provided by the insurance policy company, and the policy application and sales illustration was authenticated. Now, my lord, please underline this. Basis of OTP received in the insurance mobile number. She had read and understood the same by sharing her OTP with the insurance company, endorsing that she has been convinced about the contents and features of the policy that he has applied for. The policy was authenticated basis OTP, and no manual signature was opted from the customer. So this is what the insurance company is saying. Now, Lord, please see the next page. Lord, that in itself makes it a digital policy. We would like to inform you that as per, this is the insurance company saying, we would like to inform you that as per our firm, digital stands as online method of enrolling policies with the help of OTP sent on your mobile, and non-digital stands as offline online method of enrolling policies with help of manual signature. Admittedly, according to them, there is no manual signature. It is OTP. Then it is a digital policy. Now, if they say that there is no difference between the two, then please make it a digital policy. Where's the problem? Now, my lord, please see the rest. Then, my lord, Para 5, insurance company denies and disputes the contents of the averments. My lord, bare denial. Then, my lord, 6, as per the record of the insurance company, the complainant insured opts for e-insurance account and insured like to receive a insurance policy, all other information related to the policy through Tata AI Life in electronic format, details of the policy are there, etc., etc. Then, my lord, from there, please come to Para 14. There's nothing else in between. Para 14. The complaint had earlier filed a complaint with the insurance ombudsman on 13 March with a complaint so-and-so. The complaint was dismissed by a letter of 18 March. Complainant also filed a writ petition being WPA so-and-so, Calcutta High Court. Honorable High Court directed Ombudsman to decide the matter independently and upon hearing all parties. He's skipping the fact that it said give reasons. He doesn't say that. A copy of the complaint is here. Now, my lord, please see what's his reason. Hence, it is established that LA has not approached this forum in clean hands, and LA failed to establish his case as mis-selling. Hence, we are unable to accept the request. In view of the above facts, we regret we are unable to accede. Under the circumstances, insurance company submits that the complaint is devoid of any substance, etc., etc. Now, please go to observation and conclusion. Complainant's grievance is that the policy under consideration was issued to her in non-digital mode, resulting in loss in maturity benefits, and a request to convert the policy to digital with resultant increased maturity benefit with effect from the date of issue was not acceded to by the respondent insurance company. In support of her contention, she, with her email of 19 December, submitted purportedly screenshots from Tata AIG app of the difference in maturity payouts of policies taken in digital and non-digital mode. Clarification was called for from the insurance company, not after that. And regarding any discount in premium or increase in maturity payouts on account of digital mode of policy, company has categorically denied any discount and has doubted the authenticity of the screenshot. Now, it's their app. Please see this. Not a lawyer who has appeared for them and I never got notice says, I doubt the authenticity. But nothing on record. And not what are the reasons? Please see the not earlier order of the High Court not asking them to give reasons. Page 146. But please take not the second page.
Yes.
But third last para, the authority shall decide the matter independently upon hearing all parties. A reasoned order shall be passed and communicated. A decision shall be taken within 2 months.
Yes.
Now, in the other matter, they were not taking a decision. So, not the other matter is identical. The item number 2. Now, there, I just tell your lordship the only difference. But there also reasoned order asked to give. Now, they didn't give an order. So I wrote to them saying, look, you're not complying with the court order. I'll file a contempt. They write back saying, we've already decided. Then we write back saying, what? Where's the decision? Nothing. So then they write to us saying, please give your consent for hearing. But that is after my wife's complaint is disposed of. So I know, Mlord, it will meet the same fate. They'll pass the same order, Mlord, copy, cut, paste. So, Mlord, the other one is before order is passed, and this is after the order is passed. Now, Mlord, I can put it in legal terms, Mlord. Mlord, first, violation of a court order. There are no reasons. Number two, Mlord, natural justice violations galore. Lawyer not permitted to be represented. Two, takes into account, Mlord, something that the representative of the insurance company has said without giving me an opportunity to deal with it. Number three, there is no proper denial of this fact. I have given them evidence from their app showing that the returns are different. And he says it's doubtful. And on that basis, Lord, the entire order is passed.
Okay.
And Lord, lastly, I'm not going back to that. There is an admission on their part, according to them, not according to me. Not according to them, this is a digital, because a digital is won by OTP. According to them, this was done by OTP. Then why are you not calling it digital? I'm not asking for any money today. All I'm saying is, if you had told me at the beginning, I would have opted for the digital mode. You did not. They say everything is explained, and that will appear from the fact that OTP was taken from you. Now, if OTP was taken as they allege, then it's a digital policy. End of the story. But this is not the kind of matter to send once more in a remand. Lord, I'll be asking for a mandamus.
Yes, sir.
Lord, just two other things. In this one, there has been a decision. Item number 2, there has been no decision. So either your lordship can state and ask him to. No order. Item number 2, there is no order.
There is no order.
No,
So
item.
what is your prayer now?
Not there, my lord. I have come up saying, look, my wife has suffered this fate. I will suffer the same fate. It'll be a cut. Yes. Lord, it's their retirement, not money. It's money for retirement that they've put in. Now, my lord, for an insurance company to play this, Lord, and Lord, for this to go, Lord, a lady is allowed to appear online. Her lawyer is cut off. She's asked, look, why do you say that the returns are different? She goes to the app, takes a screenshot and sends it. And they spend, and look at the response, Lord. The response is the strangest response I've ever seen. Doubted the authenticity. And my lord, what he's saying is contrary to his case. According to him, then this is a digital policy. It means, my lord, there is complete non-application of mind, my lord, at that time.
That screenshot is in disclosed here?
Yes.
Which page?
Page the ball, page 180.
180, 182.
Lord, it's the covering email and the annex is 182. And if your lordship sees, Lord, there are 2 illustrations given. Left side is digital, yes. Right side is digital, no. Page 182.
182.
So, my lord, this is from their app. And, my lord, if your lordship goes to, Lord, after the illustration, just not below that, digital, yes. And the other is digital, no. And if your lordship sees the total in the both the, my lord, columns, they're different. Digital is a higher return.
768.
In one crore, it's 762, and in the other, it is not lower.
738.
738. So there is a difference in return for the same policy. All other terms are the same. Difference is only between digital and non-digital.
Yes.
Now, my lord, for a couple who's retiring, Lord, this is a serious amount of money.
Okay, that's
those are my submissions. Lord, and Lord, one authority I'm handing up, Lord, the Telangana High Court has not construed the rules to say you have to allow a lawyer to be present.
And the High Court had ordered it to be governed by Rule 17, which is what is coming.
With the paragraph. Lord, your lordship goes to para. Watch it. Lord, I'm just giving a copy to my learned friend. Lord, para 4. Lord, by reason of the judgment not quoted above, this court held. Therefore, we notice that what we notice is that one stage of Rule 16 is crossed and the proceedings travel to Rule 17, which is the ombudsman. The role of the ombudsman also changes, and from being a mediator, He becomes an arbitrator and is mandated to pass an award based on pleadings and evidence brought on record. If this be the position, Section 30 of the Advocates Act would come into play. As per Section 30, every advocate whose name is entered in the roll of advocates will be entitled as of right to practice throughout the territories, etc. I'm not that set out. Therefore, in the context of the present case, what Section 32 says is that an advocate, as a matter of right, is entitled to practice before any tribunal. Then, Milord, para 40, adverting to Rule 17 of the Insurance Ombudsman Rule, it's evident that it is a forum mandated to pass an award based on pleadings and evidence, and as such, when it comes to adducing evidence, role of an advocate cannot be dispensed with. As already noted above, an award involves an adjudicatory process which is equivalent to a judgment awarding compensation. Therefore, it's evident till Rule 16 of the Ombudsman Rule, it's the mediation process when no role of an advocate is envisaged. But the moment the matter progresses to Rule 17 on failure of mediation, then an adjudicatory process is set in motion, which is to be decided on the basis of pleadings and evidence, and such a process role of the lawyer becomes inevitable. Now, this was a case of Rule 17, and the High Court order specifically says Rule 17 will apply. Well, if your Lordship goes back to page 147, our order, in the first round, yes, the Ombudsman will be governed by Rule 17 irrespective of the pleadings. Now, Lord, is this a case where, Lord, it has gone by any pleading or any evidence? The only evidence which was there was mine, and they say it is doubtful without anything.
Yes.
So, Lord, this is, Lord, I don't think, Lord, one should go beyond that. I think my learned friend, Lord, should take a fair stand over here and, Lord, give my client, Lord, what he deserves.
Yes.
Lord, it's
What is the
pointless
discussion?
filing a suit for this.
My lord, at the time of opting for the policy, good, bad, indifferent, my lord, the petitioner has never said that the policy has been missold to them. What is the case of the petitioner, or rather the grievance? The grievance is that
No, see, that's okay. I will come to on that point. Suppose today, if today it will be converted to the online policy, correct? So the benefit will be given from today onwards, not the retrospective effect. So why it is not been done?
my lord, at the time when the policy was opted for, there was no digital mode. My lord, subsequently, when it came to their knowledge that now the digital mode policies would have been applied for. What is a digital mode? What is a non-digital mode? My lord is very well aware that insurance culminates from the application which is filed either by the agent through signatures of the applicant,
Manually, yes.
and it is sent to the office and it is verified by way of a pre-insurance verification call.
Correct.
Now that is tele or digital. That does not mean that the policy automatically is in digital mode.
So that's your case.
That's their order. My lord, the verification can be in digital mode, but the application for the policy, if it is a manual policy which is admitted, they have applied for the policy, policy has been issued, and they were reaping the benefits of the policy. Now, later they come to find out that the same policy has now been converted into, or not converted rather, there is a digital mode applicable. Now, what is a digital mode? Digital mode is when you go through online marketing channels to procure that policy, then it is automatically considered as a digital mode. Now, for that, the PIVC mode does not change. It is also an OTP which is authenticated, and the veracity of the contents of the policy and the consent of the applicant is recorded by way of that OTP. So, in respect of PIVC, it remains the same. But when the application was made, it was made in respect of a non-digital policy or a regular policy. Now, my lord, if the digital mode benefit did not exist at that point of time, then how can the company go beyond their policy rules or even IRDA rules and convert it unilaterally just for monetary benefit? Secondly, my lord, this has been pointed out that firstly, that whether if it is a contested proceeding, then obviously a lawyer should have been present as per the judgment. My lord, but both the parties were not represented by the lawyers, but the company was represented by their authorized representative, and so was the complainant, my lord. My lord, after going through the grievance, if it appears by way of a reasoned award, even if it might be a one-line award, that there existed no cogent grounds for conversion of the digital policy at a later stage, Either you apply for a digital mode through online marketing challenge, or you don't apply, you apply through the normal physical mode and you have been given the policy, you are enjoying the benefits of it. Now, if your request is turned down, whether that forms the ground for filing a writ petition under 226 before the High Court or not, that is also the maintainability of the writ petition is also writ at large. My lord, there exists alternative remedies. My lord, if they are not satisfied with the award of the ombudsman, they can obviously approach the consumer forum or the civil court for their redressal by way of a declaration. My lord, it is not necessary that what is the fundamental right that has been infringed. My lord, no fundamental right has been infringed. They are enjoying the policy. It is not that the policy has been rescinded. No benefits has been given. It is only their grievance whether their non-digital policy, they have not made a case out that they have applied for a digital mode and they have been given a non-digital mode. Their grievance is that my non-digital policy has not been converted into a digital policy upon their request. Now that request has been turned down. My lord, now the ombudsman also declared that this.
So the request of the applicant has been turned down. Who will decide this? Whether it is a correct turn down or whether it is rightly or wrongly?
My lord, they have approached the ombudsman.
That's why ombudsman has passed an order. After the order of the ombudsman, what is the
in the first stage there was a mediation where the mediation failed.
After the order of the ombudsman, so what is the further authority?
One consumer forum.
Oh,
consumer forum. Consumer forum, because if it is based on facts, whether at that point of time they had applied for a non-digital policy and thereof subsequently a year down the line there has been the same policy is available in digital mode, and whether there is a difference in maturity benefits, then it cannot retrospectively apply to somebody who is already availing the benefits under a non-digital mode policy.
So that's
Now
why
the
that's why
decision is
that
upon the insurance company whether they'll accede to the request or not.
so that's
Because the
see,
actuarial calculation change over a period of 1 year.
where is your decision of the insurance company decision? Where is the insurance company decision?
Well, it is not attached to the petition.
Huh?
We have communicated that it cannot be converted.
That's why where is your insurance company decision? It cannot be converted.
Nothing.
You. Where is the because the ombudsman order does not say what you have submitted.
My lord, it does say that we have replied. Even they admit that they have received a reply. That reply is not on record.
No, you're wrong. We have said it's noted in the order. We gave a notice. You did not reply. No reply.
My lord. Lord, let it be on affidavits. We will produce.
Why affidavit? It's a small matter. Only it is whether if the insurance company has not taken a decision, then it approach the ombudsman. Ombudsman has passed an order initially that was without any reason. Then again the court has remanded the matter back to the ombudsman. Ombudsman passed an order. Now you have taken three plea. One is with regard to this is OTP. Is not with regard to the digital way.
Digital mode. It is a standard verification.
This is not the digital. It is through the agency. Agency has submitted the manual form to the insurance company during the verification, and OTP has asked for the verification. This is your first one. Second contention with regard to the petitioner has applied for not applied for the digital, and it is applied for the manual. Now in the mid it cannot be changed. This is second. Now third, with regard to he cannot challenge the order before this court. This is the three. These are three ground you have taken.
Alternate remedy. If there is an alternate remedy,
show me that. Where is the alternative remedy? Show me which is the alternative remedy.
But can this court direct by way of a mandamus to convert a policy from?
So that's why if this court finds, if a person has requested and you have denied his request arbitrarily, whether the court, writ court cannot pass an order.
It's a private entity, my lord.
Maybe.
It's a private entity. It is not the state. It is not a state-sponsored insurance policy which is there. My lord,
so the last on the last occasion, why you had admitted the case of the petitioner and the complied with the order passed by this court?
It was only on the basis of remand.
Whatever it may be, remand or the writ petition was allowed. Writ petition was entertained. Now you cannot turn down.
My lord,
turn around that it is not maintainable. Once you have admitted here and you have acted upon the order passed by the High Court,
my lord, but
how you can turn around that?
my lord, but at the inception of it, can there be any mandamus for conversion of a commercial policy?
Commercial.
Not commercial policy in respect of the commercial value.
What is
attributed to the
your policy? What is if suppose the petitioner has applied for the manual, okay, it was manual, you have registered that, and now the petitioner intend to change. There is no there is any restriction. Show me the law. That is only clear. Show me your insurance law whether if it is a digital, it is not a digital, it cannot be converted in the mid of the policy.
My lord, we'll file by way of an affidavit.
Not affidavit. You show me. I am fixing next week. You show me only this law.
My lord, let it be fixed.
And
within the policy.
how you authority, kindly come to the page 85 last line. How your authority say it is the doubtful if you're denying with regard to the electronic document of your
My lord,
company?
we are not doubting the electronic document. It is the comparison which was placed by the complainant.
No, 182 and the ombudsman telling that you have stated that it is a doubtful. Kindly see the last line. The company has categorically denied any discount on and has doubted the authenticity of the screenshot. Can you deny your screenshot?
My lord,
This
is
is
not
not
our
your website.
screenshot. It is not our screenshot.
This is not your website.
My lord, this
You
website.
you put in affidavit. This is not my website before the High Court. You put in affidavit. I am fixing tomorrow on next week.
My lord, kindly fix it next week. We are not putting by way of an affidavit, but we will clarify whether that screenshot is applicable to the policy which has already been availed by the complainant or not. That for
See, only the complainant has placed this screenshot to show the ombudsman. Yes, what is the difference between the digital and what is the difference in the manual mode? So if it is a manual mode, your subscription or benefit will be less, and in the digital mode, the benefit will be higher. That is the case made out by the applicant. And this digital mode also showing the same thing. Yes, if manual, it is a 762. If it is a digital, 762 is a digital, and manual is the 738.
Whether a conversion in the middle of the policy is possible or not,
That is
has to be seen.
Correct.
My lord, may keep it. We'll provide the policy of
Correct. Correct. You show the condition. You cannot change the policy. You cannot change the manual to digital. Suppose suppose the petitioner, when he has applied for, it was not in digital. Digital was not applicable at that point of time. In the meantime, the digital has come, and the petitioner wanted to shift to the digital. What will happen?
My lord, then it is changing the maturity value.
That's why I'm telling what the first question what the court has put to you today. What is the maturity value that will remain? From tomorrow, once it has been come to the digital, then it has to go to the digital way.
Actuarial calculation does not work like that.
Then that's I know.
It does not work like that, my lord. Correct, my lord. My lord, if the policy is discontinued, then the surrender value will accrue as per the non-digital mode.
So you show me with regard to where is the law that you cannot change from the manual to digital. That is the only thing.
We'll provide the policy circular. Yeah.
The respondent is
just one submission. My learned friend firstly says that there was no digital method at that time. He's saying this, but there is nothing, nowhere has the insurance company taken this stand. Entire correspondence.
What are the submission is only I want that, because whatever submission
was opted for by the petitioner.
No, his submission did not exist.
Your submission does not reflect here.
Any of this.
Whatever submission you have made, that has not been reflected. Mr. Machawadi Senior, he knows the law.
Blood, I know very little, blood. I know whatever blood is fed to me by the juniors. Nowadays, blood, I can't remember my name also.
If you have not taken the plea in your reasoned order, you cannot take the another plea in the written in the writ petition, sir.
It's not a different plea that we are taking. What we are saying is that the conversion is not possible once the policy is in force from non-digital mode to digital mode.
Okay, show the law that.
Yes.
The only question in the present writ application is whether the policy manual policy can be converted to the digital policy. The counsel for the insurance company.
My lord, respondent number 3.
respondent number 3 is directed to show the law on the next date, fix whether there is any restriction for changing of the policy from manual to digital. Let the matter appear on 25th September.
Would it be 24th if it's possible?
24th, because only Thursday.
Oh, very, very.
Thank you.
Obliged to your lordship.
2 में 2 और 3 दोनों में करो. So what is the another matter? Which is the another
Lord,
matter?
2 and 4. 2 and 4.
For the same.
Same point is in one.
4 and
In one there is a speaking order now, well, non-speaking order. In the other there is no order yet.
Yes. Yeah. रख दो, छोड़ दो, हटा. अभी केस चलने का बीच में क्यों लाते हो सब?
Three, my lord, I am appearing for the petitioner, my lord. And this is the notice I have served upon this is the affidavit of service and notice I have served upon the state of West Bengal. My lord, this is actually writ petitioner is seeking guardianship of her mentally ill child.
Guardianship, how the writ petition? Why
Lord,
why you are not going for the Guardianship Act?
I am coming to this, my lord.
Why you are not invoke the section 7, section 25 or section 12 of the Guardianship Act?
My lord, Guardianship Act would not do, my lord, because this mental...
Who is the petitioner?
Petitioner is the mother.
Mother. And who is the minor? Is minor.
Daughter is the minor.
So why the guardianship?
My lord, this is actually he is not minor. He has become major. কত বয়স হয়? বয়স হবে 22. Yes, 22 years old.
So what do you want?
Disabled, my lord. He is intellectually disabled.
Intellectually disabled, my lord.
Disabled person.
Disabled person. That is the reason, my lord.
What is the disability, sir?
My lord, that is annexure P1 at page 11.
Page 11. Page 11.
Yes,
page 11 is prayer. Page 12 is prayer. Page 12.
Right, কি করেছিস তুই? Pagination টাও ঠিক করেছিস।
After 12, then again 11 is started. After 13, again you started 11.
My copy, page 11 is in P1 is
কি করেছিস?
disabled.
How this officer accepted this? Verification also, the commissioner has put the seal also. Okay, whatever it means. Yes, page number 11. 75%.
75% is disabled.
What is the intellectual
disability?
Disability.
And my lord, this is the second time writ petition, my lord. First time there is a direction passed by the my lord Justice Amrita Sinha to put the petitioner before the mental health review board, my lord.
Where is that?
At running page 15 of my writ petition. Order is starting from page 13. Page 13, the order.
On the forward edition.
My lord, got the order of the my lord Justice Amrita Sinha?
Yes.
Yes. My lord, that is hence the Kolkata Municipal Corporation Mental Health Review Board is directed to assess the mental health of the daughter of the first petitioner.
Yes.
And learned advocate of the petitioner direct to forward the medical documents of the petitioner to the Kolkata Municipal Corporation Mental Health Review Board constituted under the Mental Health Act 2017.
Correct.
For acting in compliance of the order.
Have the medical board was held?
Yes.
Where is the certificate of the medical board?
My lord, then my lord, kindly come to the annexure P3, page 18.
18.
Yes. This is.
Yes.
The Registrar General Honorable High Court, Calcutta, order dated 7/2/2025, passed by the Honorable Court, Calcutta in WPA number 27188 of 2024. With reference as mentioned above, I am to say that despite my appointment as a chairperson of the District Mental Health Review Board of Kolkata Municipal Corporation area, the District of Hooghly, by Honorable High Court as per recommendation of the chairperson of the West Bengal State Mental Health Authority, my office has not yet received any communication. That is the communication made by the registrar through registrar. We have received the communication through the registrar, and this is the order passed by the Chief Judge being the chairperson of the Chief Judge of the City Civil Court, learned Chief Judge of the City Civil Court, being the chairperson of the Mental Health Review Board of the Kolkata.
No, my office has not yet received any communication from the government of West Bengal regarding completion of constitution of the board, appointing other members of the board of KMC area with make it functional.
But I have also annexed the notification that it starts
Now,
from
notification might be, but
Yes.
the
Oh,
officer
my
officer should be appointed by the state government.
This is an urgent situation.
Okay, yes, you tell me, where is the notification?
That is notification at page 15.
Page 15.
Yes. Status of the District Mental Health Review Board, West Bengal, my lord, got it? Page 15. Page number.
Arjikar Hospital falls in connection with reference and director report related to present district mental and attach here with the statement.
And next
This
page.
is February 2025.
Yes.
February 2020, and then they have stated the constitution of the District Mental Health Review Board
And
for
below-
KMC area is progress to be functional soon as required. Yes.
This is the next, Miller, next page. The board has been constituted. That is, they have given the notice.
As per recommendation, chairperson principal informing and appointing honorable district judge of the district given below as the chairperson of the respective district of KMC area, Hooghly district. Yes.
And
But where are the members? Where is the notification of district? This committee consisting of how many members? Who will be the members? Or district judge will be the chairman.
Yes.
But when the psychiatrist is required to
As
be, if
because
it
in
is
last
a
occasion, they have said the board and everything has been constituted, so the petitioner will be going there. Now, my lord, the prayer of this writ petition is the appointment of the guardian of the particular petitioner number 1, as because the daughter is the petitioner's daughter, being the petitioner's daughter. My lord, under the doctrine of parent party, this honorable court has the jurisdiction to appoint the mother as a guardian for the well-being of the petitioner, my lord. My lord, this is the crux of the matter, my lord, and on the basis of this, my lord, I am relying on the judgment, my lord, that is 2025 SCC Online, Bombay 1303, and my lord, SCC Online, Bombay 1303. Acha. My lord, that is considering such plea, my lord, I'm considering such plea as urged on behalf of the petitioners by an order dated 19th March 2025 passed on the present proceedings. This court requested the dean of, my lord, this is the mental assessment, then the, my lord, thereafter the formal medical history, and thereafter, my lord, the court exercised the jurisdiction, my lord, that is paragraph number 4. The court have exercised the jurisdiction under Article 226 of the Constitution by appointing a legal guardian in respect of the disabled persons, applying the doctrine of parent party. The principle that the interest of the person with a disability being required to be addressed in duly recognized in legal jurisprudence. The principle invoking such doctrine failed for consideration of the court in Moyukesh Dipan Nadkarni versus Union of India, to which.
That's correct, sir. Prior to that, you come to the paragraph 3, the medical background.
Yes.
That's why the report is required from the medical board. Then if the medical board recommends
Lord,
that,
there is a prolonged
court
history.
can invoke the provisions and pass appropriate order. First, the medical board has to be constituted, and your client.
It has not been constituted, but
you are appearing for whom?
I'm appearing for state of West Bengal.
Instead of where is the committee has been appointed, constituted?
I have no
Medical board has been constituted.
There's no
I
instruction.
have no
It's saying.
instruction
So?
until now. My common represent with the instruction or not?
You receive the writ petition.
Filed.
So is the old one, my lord.
Then?
But it will assign before my lord.
And the last occasion when the earlier previous writ petition was taken, you have stated that it has been constituted.
It is actually, my lord, this is the interference of the delivery of
The
justice
point of
system.
time, my lord, someone is appearing for this.
Who is the authority? Who is the authority to appoint the committees to be constituted? Who is the authority?
There's a chairperson's.
Chairperson cannot be. You have stated the chairperson will be the district judge. How the district judge will know who is the psychiatrist, who is the dermatologist, who is the orthopedic?
Yes. There is this.
Common appraisal lordship. This may come on the next week. The appraisal.
For what you will come? What you will do in the meantime? What homework you will do?
My lord, chief secretary, principal secretary of the
Principal secretary of health department is directed to furnish the report.
by next date.
Committee was constituted or not, my lord?
Not on if not constituted, let it be constituted by 24 by 23rd. Let the matter appear on 24th.
May come in appraisal will lordship.
Kindly see the condition of the disabled person.
Because if I am to move to the my lord outside,
He cannot take the benefit of any of the scheme unless the guardian is appointed.
I come next year.
Mentally ill persons, unless the guardian is not appointed, he will not be able to get any benefit of the scheme, sir. Though he sees the mother.
But the child is now major, become
This
major.
is major. And she is major and she is a mentally ill, the disabled person, then the requirement of the law is different, something different.
Lord's welcome.
This is the second round of litigation. Initially, the petitioner has filed a writ application before this court, being WP number WPA 27188 of 2024, within bracket Nazrana Bibi and another versus the state of West Bengal. At the time of hearing of the previous writ application, a report was forwarded by the Additional Director of Health Services within bracket Mental Health Department of Health and Family Welfare, Government of West Bengal, dated 4th February 2025.
Sir, kindly interject, my kindly present this judgment. Kindly want to look this judgment.
What? What?
Constitution of committee, my lord.
That is 1977 judgment, but law has changed.
97 two Supreme Court cases.
So what you want?
But when this committee is not constituted, my lord, as far as the judgment is concerned, my lord, court cannot compel to constitute this one.
Court cannot compel
Constitution
to constitute a committee. Where is show me? Where is show me which paragraph? The court cannot direct to constitute a committee.
Paragraph 5, my lord, 1961 rules were repealed and repealed by the another of the rules called by the Karnataka General Services Revenue Subordinate.
This is on the dependent.
That is a recruitment rule.
Rule 4(5) of
That is a recruitment rule. Kindly come to the page 5. Recruitment to the cadre of the village accountant shall be made a direct recruitment. This is a recruitment rule.
If sufficient numbers of persons are not available under the above categories, no person other than the persons referred to the categories and subcategories shall not be eligible for appointment on those rules.
This is a recruitment rule. Mental health, bracket close, bracket close, mental health, bracket close, comma. Wherein it appears that the Kolkata Municipal Corporation Mental Health Review Board is functional within the municipal Kolkata Municipal Corporation area. Police. Considering the said report, comma, the coordinate bench of this court disposed of the said writ application. Dispose of the said writ application, directing the petitioner to forward all medical documents of the patient to the Kolkata Municipal Corporation
Mental Health Review Board constituted under the Mental Health Care Act, 2017 for acting in compliance of the order passed by the Honorable Court. Full stop. By the coordinate bench. Full stop. The order was duly communicated to the authorities and on 4th of February 2025, the Additional Director Health Services.
Yes.
Additional Director Health Services within bracket Mental Health, Department of Health and Family Welfare has sent a letter to the Senior State Advocate under the heading, under the subject, Status of District Mental Health Review Board, West Bengal, by referring the previous writ petition, wherein it is mentioned that the jurisdiction of RG Kar Medical College and Hospital, Kolkata, falls under KMC area. Number 2, Constitution of the District Mental Health Review Board for KMC area is in progress and is to be functional as soon as required member posts of Mental Health Care Act 2017 are filled up. Okay? Are filled. Full stop. It is informed by the petitioner. No, full stop. The petitioner has relied upon another letter dated 9th April 2025 issued by the Chief Judge City Civil Court, Calcutta, to the Registrar General of this court, informing that the Office of the Chief Judge City Civil Court at Calcutta has not received any communication from the Government of West Bengal regarding completion of constitution of board, appointing other members of the board for KMC area to make it functional, due to which the compliance of the order passed by this court in WPA number 27188 of 2024 is not feasible. It is informed by the petitioner that till date the board has not been constituted by the state, due to which the victim is suffering very badly, as the mother of the victim is not in a position to take the benefit of the scheme of the mental ill persons. Full stop. Considering the above, this court find that considering the above, this court is of the view that before passing any further order, the principal secretary
Principal Secretary of AD, Addition
no, that is the AD, he will not do anything. The Secretary of Health Department of Government of West Bengal is directed to ascertain whether the board has been constituted or not. If the board is not constituted, the reason for not constitution of the board be assigned by 24th of September 2024, and also to inform this court as soon as when the board should be constituted. Let the matter appear on 24th of September 2025 for filing report
on the same position.
25th, not 24th.
On the same position, my lord.
हाँ?
On the same.
25th. ठीक है जी.
under filing report by the Secretary Health, State of West Bengal. The petition is directed to communicate this order to the Secretary, Health, State of West Bengal for compliance.
Yes. My lord, let this matter be in the same position.
Let the matter be remain in the same position. कर इधर वही कर देखो मुझे नहीं बन देख ले
5, I am for the petitioner, my lord. I am praying for an order of service, my lord. There has been some miscommunication with the client. my lord.
when the application was filed, madam?
Lord, in 2025 only. my lord.
2022 you filed. Till date service has not been affected. What is your application for?
It is for enhancement of compensation of an acid attack victim, my lord.
Enhancement of
Compensation of an acid attack victim, my lord.
POXO?
No, my lord. For acid attack
okay,
victim, my lord. Lord, kindly.
When
I will service, my lord.
the
Service, my lord.
petitioner is directed to serve notice upon the respondents within a week from date. List the matter on 6th November 2025. On the returnable date, the petition is directed to file affidavit of service.
My lord, 5 to 9 are the similar matters, my lord. All I am praying for the same direction.
All are the same.
All, my lord.
Compensation.
Yes, my lord.
Fine. Notice not served.
Notice not served.
Same order.
5 to 9, my lord.
5 to 9 same order. दे दो उन लोग का रिस्क है ना 9 तक हो गया 10 6 all 10 nobody is appearing. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter go out of the list. Next. None appears on.
Lord, I am appearing on behalf of the petition.
Which matter?
Lord, item number 11.
11. Yes.
Lord, this is the affidavit of service, Lord.
Anything remains? 10 days over. What remains?
Lord, that is absolutely illegal. Lord, kindly takes me, Lord, paragraph 5 once, my Lord. Kindly comes to paragraph 5 once, my Lord.
Ah.
My Lord, respondent number 3 cancel my
cancel the bid of the petition on the ground the petition is
on
not
the count
satisfied
of,
in
Lord,
it.
ITV clause serial 2, 22 and 3. And my Lord, I have complied with.
What complied with?
Lord, I produce all the documents. My Lord, kindly comes to page 17 once.
Have you served the copy?
Lord, I serve. Lord, I am challenging the illegality, my Lord. My Lord, the bottom portions, my Lord, 2 is the, my Lord, the GST registration certificate. 3 is, my Lord,
where is the tender document, tender form?
My lord,
Where is the tender form?
it starts from, my lord.
13, page number 13.
My lord.
Which work you had applied for?
Lord, I applied.
There are so many works, na?
My lord.
38 work.
Yes.
So you are applied for which work?
Lord, I am applied for. Lord, 14.
Huh? 14.
14. Serial number 14.
Construction of road from
Construction of road from
Kuranjuna Canal.
Orjuna Canal, Canal part to Bhavani Nagar Masjid.
Yes. Then what are the condition?
Lord,
What are the
come to
documents are
page
required?
17.
Page 17.
Page 17.
Eligibility criteria.
My lord.
Yes.
Lord, I am not complied with 2. That is, my lord, the GST registration certificate. 3, my lord, the PAN card. And, my lord, the serial number
Where
20.
is 2 and 3? Where is 2 and 3? Which 2 and 3 you are talking about? Page number?
My lord, page number 17.
Page number 17.
My lord, the bottom.
Document downloaded, bottom.
Instructions to bidders. ITB.
Yes.
Lord, I have not complied with, my lord, the serial number 2. That is, my lord, the GST registration certificate.
Okay.
3 is, my lord, the PAN card. And, my lord, the serial number 22. That is affidavit regarding non-employment of any government officials.
22. Affidavit regarding non-employment of government officer under the deployment of machinery technical. Yes. These are not complied with.
That is the versions of the, my lord, the respondent authorities. And now, my lord, kindly
Where is the cancellation order?
my lord, I annexed all the documents, my lord.
Where is the order for cancellation? Your rejection of your application tender.
My lord, that is page 35.
Page 35.
My lord. Annexure P3.
Yes.
My lord, serial number 3, MS Farooq Constructions. My lord, in remark column,
Not satisfied as per the
NIT
NIT.
clause, ITB 8, serial number 2, 22 and 3.
Serial number?
My lord, that is the PAN card, GST.
Serial number 2,
22 and 3.
3 and 22, yes.
And my lord, now kindly comes to page.
Yes.
Page 27.
Page 27.
My lord, annexure P2.
Yes.
My lord, that is the GST registration certificate I produce.
GST registration 2017.
Thereafter, my lord, kindly comes to page 33 once.
Period of validity up to what to up? 17 you applied for. Where is the validity? Date of
page
issue certificate?
27 onwards, my lord.
2018 it was issued. So
thereafter, my lord, page 30.
No, it is page 30. What is?
My lord, that is the continuation of.
That's a GST. 2025.
Mal.
GST at 30B.
Thereafter, my lord, kindly comes to page 33.
Yes.
Now that is my PAN card. And thereafter, my lord, very next page, my lord, page 34 is my affidavit.
Yes.
My lord, I have complied. And my lord, the respondent authority, my lord, illegally cancel my bid.
Tender passed. Work order issued.
Work order issued.
Then what will do?
Work order issued in favor of the private respondent, my lord. I made party to the private respondent, my lord. I am challenging the illegality of this tender. My lord, I have complied with all the formalities.
The petitioner has challenged the order dated. What is the date of the order?
My lord,
order
dated page 35, my lord.
35, what is the date? What you made the prayer?
Lord,
13th November 2024.
my lord.
It is a 24.
Right.
क्या बोला? Challenge the order issued by the Technical Evaluation Committee.
My lord, in bottom, my lord, date is, my lord, 6/3/2025.
Evaluation Committee dated 6th March 2025, wherein the tender document of the petitioner was rejected on the ground that the petitioner has not satisfied as per NIT clause dash I capital T capital B within bracket capital A, comma, serial number 2, 3 and 22. That is GST registration, PAN card within bracket IT and affidavit. The petitioner has drawn the attention of this court, and the petitioner submit that the petitioner has submitted all the required document, but the respondents have arbitrarily rejected the tender document of the petitioner, though the petitioner has submitted all the document. The petitioner has drawn the attention of this court to the GST registration certificate appearing at page number 27 to 32, comma, PAN card at page number 33 and affidavit at page number 34 of the instant writ application. 4 of the present writ application. Considering the above, who is the authority?
Lord, it has been issued, my lord.
Executive engineer.
Assistant engineer, my lord.
The executive engineer, comma, West Bengal State Rural Development Agency, Murshidabad Division, Kharbala Road, Behrampur, being the respondent number 2, is directed to submit the report as to why the tender document of the petitioner is rejected, although the petitioner has submitted all the required documents. Let the report be filed on 25th of September 2025. Please the matter on 25th of September. Affidavit in spite of service of notice, none appears on behalf of the respondent. इसको ऊपर कर देना. Let the affidavit of service be kept with the record. The petitioner is directed to communicate this order to the respondents for compliance. None appears on behalf of the petitioner. None appears on behalf of either of the parties. No accommodation is sought for. WPA number 7062 of 2025 is dismissed for default.
Lordship, I am appearing for the state respondent led by Mr. Amit Gupta.
Respondent was served. I am filing the complaint of illegal construction over PWD land, my lord. Page 16 is my representation, my lord.
Page
16. Annexure P3. That is my representation, my lord. And upon receiving my representation, page 41 and except P4, the chairperson MKDA, Midnapur Kharagpur Development Authority, my lord.
Page 41, page
41, my lord.
41.
Yes.
Complaint received so and so against so and so is enclosed for causing inquiry.
Officer is requested, my lord, to inquiry. And
No inquiry is conducted.
Everything is stopped here, my lord. Authority, my lord, the land belongs to PWD, executive engineer, PWD, respondent number 9.
Who are you?
I'm petitioner, my lord.
No, petitioner, how you are affected?
Yes, my lord. The illegal construction, my lord, blocked my ingress and egress to the main road. And as stated, my lord, in my petition. Lord, kindly see page 5, my lord. Page 5, paragraph 3 to 5 and 6, my lord, my allegations. The land is just front of my property and illegal construction blocked my ingress to my property, my lord.
Where is the affidavit? Service, affidavit of service? Yes.
And
What is your instruction?
One thing, my lord, may submit during pendency of this application, civil suit filed by the private respondents, but those are not part to this petition, my lord.
Lordship, I am yet to receive any instruction in this matter, Lordship.
What I am disposing of, consider. If the complaint has been forwarded to the authority, authority has to inquire into matter. If it is found it is illegal occupation, take steps. If it is not, you communicate this.
Communicate the order to the petitioner, Lordship.
Recorded. The main grievance of the petitioner in the present writ application that the private respondent has illegally occupied the land of the PWD, due to which the petitioner is facing difficulties for ingress and egress of the house of the residential of the petitioner. The petitioner has made a written complaint to the, where is the written complaint? To all the authorities on 20th January 2025. And on receipt of the said complaint, the executive engineer, Midnapur Kharagpur Development Authority,
Executive officer, my lord.
the executive
ATF,
officer, the executive officer, Midnapur Kharagpur Development Authority, by a letter dated 22nd of January 2025, forwarded the complaint to the executive officer, to the subdivisional officer, Kharagpur, for inquiring into the matter, to inquire into the matter, and for taking suitable action. Concept for the petitioner submit that in spite of the receipt of the complaint and the complaint forwarded by the executive officer to the subdivisional officer, till date, no action has been taken, and the private respondent is still in illegal occupation of the PWD land, due to which the petitioner is facing difficulties. This court find that no purpose should be served by keeping the writ petition pending. Accordingly, without calling for the affidavits at the motion stage, the WPA number so and so is disposed of by directing the, who is subdivisional officer?
Subdivision officer, upon report filed by the assistant engineer PWD, my lord.
The subdivisional officer, the district magistrate as well as the subdivision magistrate are directed to
District magistrate is,
the subdivision magistrate is directed to, subdivisional officer is directed to dispose of the representation / complaint filed by the petitioner dated 20th January 2025, which was also forwarded by the executive officer MKDA to the subdivisional officer dated 22nd of January 2025. Within a period of 6 weeks, within a period of 6 weeks, after giving an opportunity of personal hearing to the petitioner.
And only one thing, my lord, on a report filed by the assistant engineer, respondent number 9.
Already recorded. The it is made clear if during the inquiry, if it is found that the private respondent is in illegal occupation of any of the landed property, comma, the sub-divisional officer shall take appropriate steps for eviction of the private respondent over the illegal occupation and to communicate the order to the petitioner within a week thereafter. WPA number soon disposed of. No order has to post. Next.
I beg to appear. I beg to appear for the petition. But in this petition, my lord, petitioner complains an inaction of the concerned authority that a illegal poultry farm has been, my lord.
Illegally poultry farm.
Poultry farm.
Poultry farm.
Poultry farm, yes. Is operating, my lord.
Good. You will get the chicken.
Poultry chicken are not good. Cockerel is better.
Okay.
So, my lord, complaints have been made that serious nuisance is being, my lord, occurred, and the not only that, when, my lord, the petitioner complained, the private respondent, my lord, not even escaped the most senior citizen of his mother, 80 years old. She has been, my lord, booked in a criminal case for modesty. This is apart. These things are going on in the locality.
So why you not initiated 133 before the sub-divisional magistrate?
My lord.
Nuisance.
My lord has power, my lord. We have made representation to the district magistrates and, my lord, taking necessary because, my lord, the poultry farm also requires some.
Correct. That's why that is a public nuisance 133.
My lord.
Go to now. What is the change? I don't know.
My lord, I have a report from the police authorities, my lord, that they are respondent number 15, that is the private respondent, is operating the poultry farm under the name of his wife, and the trade license is annexed at the next page, my lord, of the report.
Trade license is also given.
Yes, my lord.
So he is complying with our conditions.
No.
I mean, there is no condition in the license.
Grant of this license certificate shall not absolve the applicant from requiring or
24 to 27. Trade certificate issued for the period 24 to 27.
Yes.
Correct. Grant of certificate not absolve the applicant from requirement of producing or procuring all statutory clearance to obtain from the appropriate authority before actual commencement. What are the requirement?
My lord,
my lord knows
my
better than
instructions
me,
are that the
First time I have seen this type of the certificate. Unless and
given by
until
the
you submit
contract.
all the document, all no objection certificate, all the document, the certificate can't be issued. You issue the certificate subject to give. So then who will check whether he has obtained the certificates or not?
My lord, this I find has been electronically generated.
Correct. Electronic generated, but grant of certificate shall not absolve the applicant from requirement of procuring
my
all
lord,
the
that is-
statutory.
that
What are the statutory requirement?
My lord, that whether he has
So how you will control? How you will control this license?
whether he is complying with the statutory requirements or not, that has to be investigated, my lord.
May I get a copy of the, my lord, whatever they have submitted?
Where is your complaint?
My lord, it is in Bengali, I believe, my lord. Page 17, 18.
You know this code is taken.
My lord, when it was filed, my lord, the contents are written in paragraph 6 and 7.
I don't know what is written there. Hindi it is called one kahavat.
Google,
अक्षर भैंस बराबर.
Google Translate. Open my lord's mobile and let it be translated. My lord, that complaint says, my lord, with regards to, my lord, illegal, my lord, operation of the.
Where is the averment?
My lord, in para 7, 6, 7. Everywhere, my lord. Para 4.
I am disposing of.
Yes, sir. Directing the district magistrate, Purba Medinipur.
The grievance of the petitioner is that one, and that the private respondent, namely Santanu Das, who is the neighbor of the petitioner, has started the business of poultry farm without obtaining valid license and clearance from the competent authority in front of the dwelling house of the petitioner, due to which the petitioner is facing great difficulties, as the mother of the petitioner, who is about 80 years, and the other family members 80 years and suffering from cardiac disease, and due to the bad smell of the faulty business of the private respondent, the family of the petitioner is facing difficulties. The petitioner has made a written complaint to the authorities on
My lord, 28 November 2024.
28th of November 2024. But till date, none of the authority have considered the complaint made by the petitioner. Accordingly, he prays for a direction upon the authorities to consider the complaint made by the petitioner against the private respondent, and for stopping of the faulty business of the private respondent.
Respondent 4.
Private respondent.
Yes.
Full stop. The learned counsel appearing for the state.
Yes, my lord.
You are appearing for the state.
Yes, my lord. I appear for the
State of West Bengal.
The report is by the police.
Has submitted the report of OC Chandipur PS Purva Midnipur, along with the certificate, trade certificate. Who has issued the trade certificate?
This is usually done by the panchayat authority.
Electronically generated.
Who has issued trade certificate? He submitted that as per the report. The petition
will find at the bottom of the certificate, my lord.
As per the report, the private respondent is running the business of the poultry farm as per the trade certificate issued by the panchayat. This court has considered the certificate relied by the state, wherein it reveals that though the panchayat had issued the trade certificate valid for the year 2024 to 2027, but in the said certificate it is mentioned that grant of this certificate shall not absolve the applicant from the requirement of procuring all the statutory clearance to be obtained from the appropriate authority before actual commencement of the trade. Full stop. If any violation or default is noted later, the certificate shall be liable to be cancelled and the trade/business shall be closed down with immediate effect. Inverted comma close. This court did not find any what are the requirement for running the poultry farm, and who are the authorities to provide the certificate for running the poultry farm by the private owner. Without obtaining any report from any of the concerned authority, panchayat has issued the trade certificate, and now the private respondent is running the business of poultry farm. The authorities has not considered the complaint made by the petitioner. Considering the above, this court disposed of the present writ application, directing the
Respondent 4, district magistrate.
The district magistrate, respondent district magistrate, Purva Medinipur. Respondent number 4 herein shall consider shall dispose of the complaint made by the petitioner dated
28 November 2024.
28th of November 2024, after giving an opportunity of hearing to the petitioner and to pass a reasoned and speaking order within 6 weeks from the date of receipt of this order. the reason order shall be communicated to the petitioner within a week thereof.
Or service be kept on record.
Police, the
Yeah, since
affidavit
the
of
Lordship has not gone into the merits of the matter and no affidavit exists, not
Police,
can
this it is made clear that this court has disposed of the writ application on the motion stage without calling for the affidavits, and this court has not gone into the merit of the matter.
Grateful.
Grateful. Grateful.
Item number 15. Nobody is there. Remove the Pakka building construction. None appears on behalf of either of the parties. None appears on behalf of either. You are appearing?
Appearing for the respondent.
Who is for the petitioner?
I'm in item number 16, not 15.
The state respondent.
None appears on behalf of the petitioner. No accommodation is called for. No accommodation is sought for. WPA number 7158/2025 dismissed for default.
My lord, I am waiting for the state respondents. It is basically, my lord, a matter pertaining to payment of EMI. We have been made parties for reasons based.
Who are you?
I am the state police authority, and we have got hardly any role to play. On the contrary, my lord, if your lordship kindly comes to page.
So you are recovering the EMI on behalf of the bank or the.
No, allegations are that in spite of receiving complaints of threats, we haven't taken any steps. But the fact is that not even a single complaint is annexed in the writ application. Moreover, my lord, if your lordship kindly comes to page 10 of my report, my lord, there is a specific declaration in Bengali by the petitioner that the person concerned are coming to his place for recovery of the loan, but they have never attempted any force. May I read the relevant part, my lord?
Okay, I am dismissing it. Okay. Dismiss for nobody is there.
My lord.
None appears. So appearing for the state respondent and filed report. Let the same be kept with the record. None appears on behalf of the petitioner. No accommodation is sought for. WPA number dismissed for default.
Grateful, my
lord. My lord, I am appearing for the state respondents, my lord. My lord, kindly see page 3, my lord. That is written that the respondent number 1 took loan from the respondent number 1. My lord, I am.
Who are you?
My lord,
you are for the state.
I am for the state, my lord.
Same order.
Respondent number 1 is the state, my lord.
So appearing for the state respondent, none appears. Dismissed.
I appear for the respondent Oriental Insurance Company, my lord.
Yes.
Respondent 1 to 4.
For the 1 to 4. What is challenged here?
It's a money claim. I filed a writ petition against the insurance company claiming.
I am converting into the CS. Whether it will be a com or it will be a ordinary suit.
It's a commercial suit.
Commercial, so I am converting here. Directly to pay the court fee. You buy. Same. None so appearing. None appears. Dismissed for default.
I'm for the petitioner, my lord, in this matter, my lord. My lord, the respondent covers, my lord, that the respondent is the bank, my lord, is covered under Article 12 of the Indian Constitution, my lord. And the petitioner is the senior citizen, my lord.
What is your prayer? What is your prayer?
My lord, there's a lease agreement between the parties for 10 years, my lord, which
for?
starts from 2011 to 2021.
For what? Business?
Yes, my lord. To run the financial...
Stop allotment?
For the financial institution, my lord, the respondent is the bank. My lord, this lease agreement starts from 2011 to 2021, my lord. The lease deed is only for 10 years, my lord. After 5 years, my lord, the rent will be increased for 10%, my lord. 10 to 20% that was mentioned in the lease deed, my lord. Thereafter, my lord, the lease deed expires. My lord, the bank authority, the respondent authority is denying, my lord, their own commitment, their own letter, which they have agreed to pay rupees 48 per square foot, my lord. If my lord kindly takes up page 40 of my petition, my lord.
What is
Page
the
40.
prayer for?
My lord, for enhancement of the rent, my lord, which has been, my lord.
You are appearing for whom? You are for
Petitioner, my lord.
petitioner. Who is the petitioner?
Petitioner is the, my lord,
You are the allottee.
Yes, the owner of the
shop room.
yes, owner of the building, my lord.
Ah.
This 1861 square foot was given to the bank, the respondent bank, to run the financial institution. With my lord, 10 years of lease deed, my lord. The lease deed expires on 2021, my lord. Then thereafter in 2024, they have their, my lord, if my lord kindly takes up page 40, my lord.
Carpet area
8 November 2024, my lord.
Correct. Inform bank committee consider the
Yes, my lord. The renewal
48 rupees per square meter.
Yes, my lord.
Correct.
This commitment was not been fulfilled by my lord, by this bank
So why
authority,
the
my
writ
lord.
petition? How the writ petition?
My lord, my lord, the fundamental right, my lord, the
You all
natural
persons
justice,
have
violating of
all
natural
persons have
justice, my lord.
committed the civil citizen
My
to
lord,
the
the
writ
petitioner,
petition.
my lord, the petitioner is not for the possession of the property without this.
Correct, madam. You have let out to the bank.
Yes.
Correct. Initial for 10 years, 5 years, whatever it may be.
Yes.
As per the agreement, 10% is to be increased.
Yes.
Now the bank has given a new chart to you.
Yes.
They are agreeing for
My lord,
the
they
48%.
agreed to pay, my lord.
That's why they are
Yes.
agreed to pay the 48%.
Now, my lord, the
48.
bank is denied arbitrarily, my lord.
Correct. They are denying.
Yes,
And
my
whether
lord.
they are paying the amount to you.
No, my lord, they are
No.
not paying the amount
No.
which they've written.
After the agreement is over, whether they are paying the amount.
No, my lord.
Old
They are
rate
paying
also
in the
they are-
last what they have given for 37 rupees per square foot.
They are paying that.
Yes, my lord.
It's continuing.
Yes, my lord.
But they are not enhancing that.
No, my lord.
So you
My
go to
lord,
the civil suit, why
the
the writ
petitioner livelihood is only, my lord,
Yes,
with
what is the
regard to.
contention? You ready to pay?
We need to take instructions.
But
and file an
instruction, your
opposition.
instruction in writing, your bank is ready to pay the 48 rupees.
My lord, this matter has come up suddenly. We could not take instructions in this matter.
2024, now we are on
old
25,
matter,
1
my
year
lord.
has passed, 8
My lord,
November.
kindly allows us some time to come back
When?
with
Next
the
week?
Next week, my lord. Come back
My
with
lord.
instructions.
Come with the
And
instruction. Whether bank is ready to comply with this letter dated date 11/2024.
my lord.
If ready, then I dispose of.
My lord.
I'm grateful.
My lord, if in the meantime, my lord only pleases to direct upon them to serve us with a copy of the writ petition.
Had already been served. I'll
Give one copy. Counsel for the bank. Here for the bank.
For the bank, my lord.
Counsel for the bank. Prays for a week time to take instruction. Accordingly, case is adjourned. Let the matter appear on 24th or 25th. 25th September.
Right.
Next.
My lord, in this matter, kindly take this matter.
Number
on the-
20.
My lord, I'm for union
Why?
Lord,
What is the matter?
Shubhobhuto Datto is appearing for the
Huh?
petition. Shubhobhuto Datto.
Who?
Shubhobhuto Datto. He has not come for duty is illness, my lord.
Directly respondent take
But
effect.
in this matter on behalf of SEBI, my lord. 2 and 3.
So, what is your answer?
My lord, this matter was identical matter was before Justice Amrita Sinha, where it was dismissed on merits, my lord. My lord, identical same client. Here they are
No, my lord,
challenging.
this matter is same, not same matter.
Okay, next
Kindly
week.
make it
Not
after
today.
vacation, my lord.
After vacation?
Yes, my lord. Item number 20 and 22.
As per
20 and 20.
as per prayer made by the counsel for the petitioner,
20 and 22.
let the matter appear on 6th November.
Great.
20 and 21?
20 and 22.
22. 20 and 22. Yes, call.
Lordship, I am appearing for the petitioner, your lordship, in this matter. Lordship, petitioner is an unemployed youth, lordship, carrying a small ready-made garment seller, lordship, at his own village, Koranjoli, South 24 Parganas. My lord, he has opened an account at HDFC Bank at Diamond Harbour branch in the year 2013, lordship. On 7th February 2025, petitioner came to know that the account was blocked. And without any prior intimation or information, the account was blocked. We have made representations, and they have on 10th February 2025, through learned advocate, I have sent the notice to the bank. The bank replied, my lord, in page 16, my lord, they cannot interact or act or provide details except the order of the court. In this meantime, my lord, my business has hampered totally, my lord.
When it was stopped?
Well, it was
February.
stopped on, I have from
When your account was stopped?
7th February, my lord.
7th February?
Page 4 and 5, my lord, I have
Page?
written. My lord. Then, my lord,
7th February.
yes, my lord.
Your account was stopped.
Yes.
DR block.
Yes, my lord. DR block. My lord,
What the bank says?
my lord, on page 17, my lord, bank in another letter, bank sent to the petitioner, bank disclosed about 3 cases against that account and said that we will require revocation order from the authority or court of law for revocation and smooth functioning of the page 17, my lord, kindly. In the last line, we will require revocation order from the authority or specific. My lord has surely knows, my lord, that
There's a police case.
my lord, despite
It is recorded.
Your lordship has knows that, my lord, despite several precedents, my lord, the account cannot be blocked.
Correct. If it is in the criminal case, correct.
Yes.
This police has ceased freeze this as per the request of the investigating authority. The bank has freezed your account.
Yes, ma'am.
Correct.
Yes, ma'am.
So if it is a freezed your account, you case number is given. Investigation case number so and so so and so.
We have
So you go before the criminal court and file an application for defreezing. How the writ petition will allow maintainable here? You go to the court.
My lord, I have made party all the respondents here, my lord.
No, you can, but here is the criminal case is involved. You go to the criminal court and defreezing of your account, not by the writ court, sir.
My lord, any
Go through the 457 of the CRPC. Now I don't know what is the new one. It is police assist.
But my lord, I am nowhere connected with their.
Correct. You go to the criminal court and say you are not connected with the criminal case, but the police has seized without your information. Then you defreeze. Then the the magistrate will call the report from the police and pass appropriate order.
But in the meantime,
Then if you agree by the magistrate order, then you can file a revision application before the court. Writ petition is not maintainable, sir. Kindly see the page number 17.
Yes,
Have you
my
got
lord.
that?
Yes, yes.
So go and inquire from the criminal case which court the criminal case is pending.
My lord, the criminal case that was in the jurisdiction of Bhubaneswar and Maharashtra. My lord, I have only the block proportion, my lord.
No, the High Court cannot interfere with the investigation, sir.
But my lord, there are repeat precedents, my lord. Finally, the blocking of the account is not, my lord.
Not understanding. You have a criminal practice? No.
No, my.
That's why. If in the criminal case, if any account is freezed by the investigating agency, there is law.
Yes.
I think my order sitting in the circuit bench at Jalpaiguri, I passed an order.
Yes.
Even though the freeze, the notice is to be given, first thing. And if you want to defreeze that account, you have to approach the jurisdictional magistrate where the case is pending. Then you file an application for defreezing that. High Court cannot. If today I pass an order, then it will be interfering with the investigation. And court cannot call anything. That's why the bank is stated
My lord,
they
on
cannot
the
disclose
verbal
all the
information
things.
from the bank, we have made party to the common app, my lord, that I have annexed in page number 9.
Your client might have been not given the total instruction. Without that, how the police will?
No, my lord,
What business your client is doing?
The simple garment seller,
Garment seller.
garment
So
seller.
might be the Bhubaneswar link is there.
No, my lord. Kindly see the page number 19, my lord. In this Domon app, that is a gaming app, my lord.
Wallet balance.
Yes, my lord. There the various games like color prediction and lottery style.
Online games.
Yes, my lord. From there's 3,000 rupees has been transferred to his account. My
That's why you are involved that online game. The police. So you go and go to the magistrate court and file. I am disposing.
Kindly leave has been.
What? Yes. The petitioner has filed the presented application, praying for a direction upon the
affidavit of services
upon the respondents to allow the petitioner to operate the bank account number 26831 6 times 0 0 0 0 0 2216 of the HDFC Bank. Which branch?
Diamond Harbour branch, my lord.
Diamond Harbour branch. Diamond Harbour branch. The petitioner says that all of a sudden, and petitioner says that the petition is involved in the business of garments, business of garments, and on 7th February 2025, all of a sudden the bank has blocked the account of the petitioner. When the petitioner came to know about the blocking of the account of the petitioner, the petitioner has made representation, but the bank has not given any reply. Subsequently, the petitioner through an advocate sent a notice to the bank, and bank has sent a reply stating that the bank cannot share the secret information of the client to the third party. The petitioner also relied upon one document issued by the bank to the petitioner. Last, it has been given to you. Last annexure, page 17.
No, my lord, that is on the yes. My client
the bank has
bank has sent the letter to
the bank has also sent a letter dated 26th of February 2025, wherein it was informed that account number 26831 6 times 0 2216 is under investigation by an independent and separate law enforcement agency, that is the Bhopal Infocity Police Station.
Bhubaneswar.
Yes, Bhubaneswar Infocity Police Station, situated at Orissa, UPD, and is carrying out the investigation in case number 3240 125 000 2981, dated 24th of January 2025. It is also informed that the West Bengal Barrackpur Police Commissioner, Dakhineshwar, is also carrying out the investigation of case number 33201250002798, dated 11th January 2025. It was also informed that Maharashtra Pimpri Chinchwad Police Commissionerate, Telegaon, Dabade, is also carrying out the investigation in case number 31912240181924, dated 11 January 2025, and have issued direction to the bank on 7th of February 2025 and 8th of February 2025 to mark, hold the account, and in compliance of the direction of the investigating agency, comma, the bank has marked the account of the petitioner on hold. Police. Considering the above, the petitioner in the present writ application praying for a direction upon the bank to allow the petitioner to operate the bank account. But as per the information of the bank, it is found that four police authorities have investigating into the matter, and as per the
Three police authorities.
three police authorities have state of three police authorities, three state of the police authorities. As per the request of the police, the bank has marked the account of the petitioner on hold, and as such, this court find that it is not proper for this court to entertain the writ application filed by the petitioner. Accordingly, the writ petitioner is disposed and dismissed. However, the dismissal of the writ petitioner will not prevent the petitioner to take appropriate steps before the appropriate forum for defreezing of the account of the petitioner. WPA dismissed. Next.
Number 23. Item number 23, my lord, I'm appearing for the petitioner. This, my lord, an acid attack victim case. The petitioner is an acid attack victim.
Acid attack victim?
Yes, my lord.
Yes, so what do you prayed for here?
My lord, Prime Minister Relief National Fund 1 lakh rupees. That is a scheme that has been that is governed under the Union of India, my lord. Now, my lord, from my instructions, I have.
And when the incident was occurred?
My lord, back in 2017.
So, what you have done till date?
My lord, I have been awarded the state compensation. Thereafter, my lord, this 2019, the PM NRF scheme was enacted, and thereafter, my lord, in 2024, I have prayed, and just my lord, from the state, I have received some compensation, and for that enhancement, I have also filed a separate writ petition. But in this particular writ petition, my lord, only the Union of India is party, my lord. My lord, service has not been affected yet. They have not been.
The petitioner is directed. The petitioner is directed to serve the copy of the writ application to the respondents within a week from date.
My lord.
And to file the return and to file affidavit of service on the returnable date. Let the matter appear on 6th November.
My lord. Deeply obliged.
But we appear on behalf of the state respondents, my lord. It's a tender matter, my lord. And my lord,
I am for the proposed respondent.
Proposed.
I have already filed an additional party application.
Who is for the petitioner?
Lordship, I'm praying for not today.
My lord, tomorrow and Monday, my lord, I have some difficulty. After vacation, my lord, after vacation.
Next to the court.
Tender, anything
Tender
remains in the
matter, my
tender?
No.
Tender awarded?
I've already got
Then
tender and all. But he has been technically, my lord, disqualified. He has raised, my lord, certain queries. In terms of the, my lord, tender document, he has to raise the objection within 5 days. That he didn't, my lord. And my lord, all the technical points are, my lord, raised, my lord. Your lordship knows, according to the latest Supreme Court judgment, my lord, interference in technical matters are not permissible, my lord.
As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 6th November.
Lordship, grateful. Lord. 29 है जनक
20? Who is appearing? Nobody. None appears on behalf of either of the parties. None appears on behalf of either of the parties. No accommodation is sought for. WPA 7286 of 2025 is dismissed for default. Next. Same order. Dismiss for default. Next.
I'm praying for the adjournment for the team. Here. Item number 27 and for the petition, I'm praying for the adjournment. If my kindly keep the matter on the next monthly list. The copy has not been served.
Surfacing notices challenge under the writ petition.
That I have no instruction in this matter yet now, my lord. That's why I'm praying.
That's why you have been sent here.
So, my lord, I'll appear on the next date, my lord. And kindly keep this matter on the next
Surfacing,
month.
possession, sale, Bangya Gramin Vikas Bank. I'm dismissing.
Oh my lord, kindly keep this on the next month's list. my
As per the prayer
I
made
have
by the
quick
counsel for
instruction,
the,
my lord.
as per the prayer made by the proxy counsel of the petitioner. Case is adjourned. Let the matter appear on 6th November.
My lord, I'm appearing for this state, my lord.
Item 28, my lordship.
Yes, 27, 28, yes.
Yes, my lordship, this is writ petition seeking remission, my lordship. I am in the custody for more than 15 years, my lordship, and remission has not been considered in this case, my lordship. My only submission is the remission to be considered, my lordship. He is languishing in jail more than
What you
15
paid
years.
for?
My lordship,
Release the petition of probation on considering the remission in accordance with the years convicted.
yes, my lordship. He has been convicted. He has undergone more than 15 years, my lordship.
Section.
Under section 302 IPC, my lordship.
What is the life?
Yes, my lordship. Left in
To
life.
life or not? Life.
Only life, my lordship. Simple
My
life,
lord,
my lordship.
302, 353, 186, 34, and 201 of IPC.
Since when you are in custody?
Charges framed already.
Since when you are in custody?
I is custody since
What is the date of the what is the date of the judgment, sir?
Sir,
26/8/2013 is the delivery of judgments.
2013, my lordship.
You are not paid for the parole. For the parole.
No, my lord, never.
Sometimes he come for the parole in
Find
the
the
meantime.
probation. You go and apply for the parole.
My lordship, the issue is that Supreme Court also various judgments say that if a convict is more than undergone more than 14 years, he is a life and liberty Article 22 be considered, and under Article 2 to 6 he moved for the remission, my lordship. This is the I have quoted some judgment.
Whether the judgment, this order of conviction has been challenged by you in the High Court. You have not preferred an appeal.
No, my lord.
Also, my lordship.
No, no.
Is that his case
No appeal have been preferred.
also dismissal. Yes, appeal is also in this case, my lordship, as I received my lordship, because
Advisor client for 13 or 12 years is in custody. So prior to the conviction, whether he was on bail or he was in custody, he was under.
no, he was never on bail, my lordship. He never on the bail.
Since when he was in custody?
I'm telling you, my lordship.
Whether he was under trial prisoner. Whether he was under trial prisoner or he faced the trial when he was on bail.
No, he was never on bail, my lordship. Since the day of offense, he was under custody, my lordship.
I'm
The day of offense he was in custody.
I'm checking from the list of dates, my lordship. That incident is on 23rd 1 2010, and since then he is in custody, my lordship. Since 2010, my lordship.
Yes.
Since 2010, he is in custody, my lordship. Custody certificate may be there, my lordship, annexed also.
When he was arrested?
Arrest is made just thereafter, my lordship. On the
Which for the state? Yes,
My
madam.
lord, I'm appealing for this state, my lord. I've got strong objection in this prayer, my lord. Let me seek for the instruction, current instruction, my lord, current status, my lord.
If this petitioner is in custody since the arrest, that is in 2010. Now we
it is
are
in January 2010, my lordship. I'm custody, my lordship.
2010. Now we are
Under session trial, my lord. Section 302, 353, 186, 34,
I'm
and
not
201.
disputing, my lordship. I
Passed
have
by
been
learned
convicted. I have
additional
undergone the
session judge.
sentence more than 14 years, my lordship. And issue
And,
is that
and my lord, already Honorable High Court pleased to dismiss the appeal of petitioner bearing CRA
yes, I have submitted. Appeal is
935 of 2013, appeal the conviction and sentence imposed on the petitioner.
correct. I know, but okay, you file the affidavit. File
Yes,
affidavit.
my lord. Yes, my lord. It will be better, my lord. And my lord, one indulgence, my lord. Then after this rejection of this appeal, petitioner moved to the Honorable Supreme Court and filed SLP, being diary number 42877 of 23.
Okay,
and SLP was also dismissed, my lord.
yes, of course, dismissed, my lordship. This is the issue of
Lot
appeal.
of hide and seek.
Issue
My learned
issue
friend
of
is
only remission, my
making
lordship.
prayer and
Section
submission, my lord. My lord is not giving the actual view by the learned petitioner. Petitioner's advocate. My learned friend is giving whatever it is a wrong submission.
No, nothing is wrong. Sorry, this everything has mentioned here.
SLP also, my lord, dismissed. SLP also dismissed, my lord.
My lord, provision admission is already section.
My
Under
lord, let me
CRPC,
file affidavit. My lord, let me file affidavit and exchange. After exchange of affidavit, my lord, it will be better.
Who is for the petitioner? Nobody. Only responsibility forthwith cause through probe into.
He has asked for certain documents, my lord. Cause of action is my lord 29.
Probe into the entire matter under the reference of central agency or any finding.
Given, my lord, we don't possess those documents. Those documents belong to the my lord BDO Shampoo 2 and my lord on the BLLRO. He can approach them and get those documents.
No, he is asking for the probe by the entire matter under the reference by the central agency.
Yes, my lord, we are the nodal agency, my lord. We have constructed it, my lord. And
What? The building?
No, my lord, it's the construction of road and culvert.
Road and culvert. Nobody is here?
Yes.
You file affidavit?
I should file a report, my lord.
A report.
A report in the form of an affidavit.
The counsel for the state respondent is directed to file a report by way of an affidavit within a period of 2 weeks after puja vacation. After serving the copy to the learned counsel for the petitioner, let the matter appear on 20 November.
20th?
November.
Lordship.
20.
Lord, I am for the motion.
Yes.
Matter is very short. My father have a share, Lord, 537 share of budget paints. My father has expired. Then I applied for transmission of share from my father to me. The budget paints forwarded the same to the Lord respondent number 4, CB Management Service Private. They again forwarded the same to the deputy general manager Investor Education and Protection Fund. Now, my lord, ultimately, your lordship kindly see page, last page. Last page, your lordship. They have, we made a representation, page last, your lordship kindly see the middle portion. Current status is case closed. Then your lordship kindly see, with reference to your grievance having registration number also, dated 19th June 2024, it is to be informed that your claims are currently under process and same will be processed on FIO basis. First in, first out basis.
First
Now,
in,
Lord,
first out, yes.
Yes. Now, Lord, during the pendency of the writ application, Lord, they wrote a letter to us. Registrar and transfer agent. Yes, but they said that it was required to be resubmitted because Lord, share from 537 to now 6 something. So you have to require resubmitted within 7 days. My lord, immediately I submitted resubmitted same. But my case is not if the said company not already dispose of the matter, because
How?
it is long.
How the writ petition?
Because it is a central government. Lord.
Who is central government?
Yes, CB Investor Education and Protection Fund.
You all persons have committed the civil suit to the writ petition. You're claiming the share of their father and filed the writ application.
Transmission, nothing.
Transmission also, if
Yes,
they are not giving,
they have completed our case, but one only thing that they have to dispose of it. I want that.
So what is the latest letter you received? No, nothing.
Blood I have blood. Blood they have WhatsApp.
When you received the letter?
They have,
When you received?
blood I'm showing. Blood, recently they have done. Recently they have done. By a mail.
একটা বলেছিল রিসাবমিশনের জন্য 9 সেপ্টেম্বরের মধ্যে সাবমিশন করতে অলরেডি আমরা জানিয়ে দিয়েছি যে
9 September.
মধ্যে রিসাবমিশন
But they have stated that within 9 September, we have to resubmit this. We have already resubmitted.
Resubmitted. So you file a supplementary.
Because
What the document? Yes,
Yes.
the document is not there.
affidavit of service.
But may I file the evidence?
Affidavit of service filed by the petition be kept with the record. Counsel for the petitioner submit that after filing of the present writ application, the petitioner has received further communication from whom?
Letter.
Further communication from
None.
from the authorities, and as such he intend to bring the said documents on record by way of supplementary affidavit. In view of the submission made by the counsel for the petitioner, leave is granted to the petitioner to file
This is from respondent number 3.
to file the supplementary affidavit disclosing the additional document which was received by the petitioner after filing of the
Who will dispose of the blood?
application within a week after the puja vacation. Please the matter on 13th November 2020.
My lord, may
Within
I,
1 week after.
my lord, may I only make one submission, my lord? I beg to appear for the respondent number 5, my lord. My lord, I am
What
not
that
an Article 12, my lord. I am a I'm a public limited company, and number 2,
That's why I asked the question.
there are no, my lord, prayers sought for against me as well, my lord.
Okay, let it come. Yes, next.
For the respondent number 4, my lord, the information commission.
Who is for the petitioner?
But I am for the petition.
Yes, what is the grievance?
Lordship, the grievance is, Lordship, in terms of section 6(1) of the Right to Information Act, Lordship, I submitted application before the authority to supply some documents. Documents regarding that in my land, some third party's name has been recorded. So how this procedure, what procedure has been maintained? Because this is also my right also under the specified law, not only under the Right to Information Act. I submitted, supply me those documents, how the name of the third party has been inducted. Now, Lordship, in challenging the inaction of section 66(1), Lordship, I favored a first appeal. That is section 19(1). And 19(1), the concern, Lordship, the land revenue officer, that is the district subdivisional land reforms officer, called me in the hearing. I appeared in the hearing, produced all documents that this information is required. Lordship, nothing information has been, no order has been passed. Then subsequently, I filed a second appeal before the Information Commission under section 19(3). That is also pending. So, Lordship, today I am praying, Lordship, directing upon the block land and land reforms officer to supply the documents which I have required in terms of, Lordship, page 52, which is my initial application. And I have stated in paragraph 5, page 6. These three.
What has happened to your appeal?
Appeal is pending.
Let the dispose of. Why the court will take the jurisdiction of the appellate authority by directing here?
Now, appeal is pending. Lordship can also direct, because this is the information, the documents they are supposed to supply.
Correct.
The Lordship kindly come my page 6.
Yes.
This is the usual document, Lordship, not a confidential document, not a third-party document.
So you are not having that here. This is the revenue authorities, so
Revenue authority.
revenue authority.
Yes.
So you are not having practice to apply for the certified copy before the authority. So you will get the certified copy after payment of the required fee. There is no such provision in the state of West Bengal.
Lordship, the certified copy is, but this is the information that record of rights, everything.
Yes.
So, Lordship, I also.
So, if you apply for the record of rights under the right, you will get the record of rights. Yes. In the record of rights, you will find that your name has been deleted. Some third party name has been. If the third party name has come, then there will be a column in the right side how this has been happened by RC number, by mutation number, by.
Yes, correct.
Then you can go for the mutation number and apply for that document.
Or change of record. Whatever, Lordship, this procedure I am unable to. But Lordship, what is the order of the district land and land reforms officer? I have to prefer an appeal under section 54 because no documents has been supplied to me. Then how, Lordship? I am asking myself, Lordship, kindly come page 53. This is the letter of the block land and land reforms officer.
Why the appeal? You make an application before the block development land of
Yes.
not provided the document.
Not provided.
Then you file the appeal under the 19 right to information.
Right to Information Act, Lordship. The concerned BLRO, Lordship, suggested me to prefer an appeal under section 54, but there is no order.
Who is the PIO? Public information of who is the public information officer?
The BLRO.
BLRO.
Yes.
So where is that first application to the?
Yes, first application is page 53, page 52.
52. That's why an
And this
application.
is the Bengali language, Lordship. I have narrated it in the.
So your address is wrong. You could have been given the public information officer block within bracket block development officer. Then it will become under the RTI Act.
No, Lordship, this is kindly subject and application.
Subject, I got it. I got a subject
application under 6(1). Lordship, this is my client.
Your appeal is pending.
Appeal is pending.
I am directing.
Lordship, kindly direct the subdivisional officer because the first appeal is pending. So, subdivisional officer to take steps so that I can got the documents because he is the revenue authority.
The first appeal has nothing to do with perhaps.
So it will take some time, Lordship, kindly, because these documents is my right.
Correct, but you have.
Lordship, I'm asking myself,
That's
what
why
is
I'm telling
possible?
you are not simply applied for the document before the BLR.
Yes.
You have applied the document under the RTI Act under 6(1).
Yes.
Correct.
Yes.
BLRO has not provided that.
Yes.
Then you prepared an appeal under 19.
19(1).
The appeal is pending.
Yes.
So under if the appeal is pending under the RTI Act, whether in the writ jurisdiction by sitting in the writ jurisdiction, can I direct
No,
the
obviously, Lordship,
PIO to
no, obviously, I have also make a prayer that to directing the Information Commissioner to dispose of the appeal.
That's
Lordship,
well.
my prayer is there. But Lordship, it will take some time. He's a cultivator. Lordship, the without any having a title, a third party is enjoying his land.
Now, you could have been, if you filed an application directly without the RTI, the court could have been passed an order. But you have taken the recourse of RTI. So
Because this is the remedy, Lordship. Kindly, Lordship.
I will dispose of this only. If you
No, Lordship, kindly direct the BLR because this is, the
can't.
documents
This
is
court
my
can't.
right.
This court can't direct.
Because I am apprehending, Lordship. I am, Lordship, kindly consider this. I am apprehending that the document is not there before the BLRO. And BLRO, I want to say before this honorable court, I don't know how this record has been procured in the name of a third party. So BLRO is avoiding from giving this document.
That happens.
Lordship, kindly direct the Lordship, the BLRO to produce the document before your Lordships and Lordship with a copy of the photocopy so that I can get.
And then in that case, I will direct the authority to file the affidavit that they disclose all the
Lordship,
documents.
the authority is not before, state is not
for the
Information Commissioner.
This one number 4. Not the state one.
Lordship, this is not that disputed fact, Lordship. This affidavit is required so far my
No, if
understanding
you are
is
telling that
concerned.
the document, then automatically they will bring the
All the
document.
documents, Lordship, let them be allowed to produce documents. What are the documents available?
The petitioner has applied
So this is
for
the affidavit of service.
affidavit of service filed by the petitioner. We kept with the record. The petitioner has applied for the information under Right to Information Act before the Block Land and Land Reform Officer
Ketugram 2 block.
under section 6 within bracket 1 of the Right to Information Act 2005 by an application dated 1st of July 2024. As the Block Development and Land Reform Officer has not passed any order for supply of for providing information, for providing documents, providing information as requested by the petitioner, the petitioner has preferred an appeal before the appellate authority under section 19 within bracket 1 of the Right to Information Act on 2nd of September 2024. It is submitted by the learned counsel for the petitioner on receipt of the application, the appellate authority had issued a notice to the petitioner to appear before the appellate authority on 30th October 2024, 30 October 2024, and accordingly petitioner has appeared before the appellate authority, but till date no order has been passed either rejecting the appeal filed by the petitioner or directing the public information officer for supply of the document. Consider the submission made by the counsel for the petitioner, produce the materials of the court. This court find that the appeal preferred by the petitioner is pending before the appellate authority. That is the respondent number 4. Respondent number 4. Accordingly, writ petition number 3225 of 2025 is disposed of by directing the respondent number 4 to dispose of the appeal filed by the petitioner dated 2nd September 2024 within a period of 4 weeks after the puja vacation, after giving an opportunity of hearing to the petitioner, and to pass a reasoned and speaking order by passing a reasoned and speaking order.
Lordship, kindly mention a period, Lordship.
4 weeks after Puja vacation.
Lordship, the Information Commissioner. Yes.
Second
appeal will
second
be
appeal.
Get.
Lordship, I am for the respondent number 8, WCACDC.
Lordship, I beg to appear on behalf of the petitioner, my lord, in this matter. My affidavit of service. Very short matter, my lord. The petitioner complains of the installation of a submersible pump in contravention with the provision of Section 7 of the, my lord, Act of...
What pump? What pump?
Submersible pump for
pump,
extracting the ground level water, my lord, in contravention with the provision contained in Section 7 of the West Bengal Ground Level Water Resource Management Control and Regulation Act 2005, my lord. So, my lord, the Act clearly, my lord, provides under Section 7(1) that for sinking of ground level water with the aid of machine or with electrical equipments, my lord, my lord, it is compulsory for the person who is going to, my lord, extract the ground level water to obtain a sanction from the competent authority, my lord. May I place Section 7 of the Act, my lord, before?
Yeah, if there is no objection from the authority. What is called that authority? Ground.
Lordship, SWI.
Yes.
He has to obtain the report from them.
Yes, my lord. And here, my lord, the private
State Water Investigation Directorate.
Yes, my lord. My lord, the private respondent, my lord, are trying to extract, my lord, ground level water without obtaining the permission as required under this particular section of the Act, my lord. The petitioner has, my lord, raised her objection, filed, my lord, representation before the authority.
So you are objecting against the private respondent.
Yes, my lord.
Who is extracting the water from ground level water
And he has
without the permission.
Objection is primarily against the station manager, respondent number 8, because because he is objecting against the energization of the submersible pump to the private respondent. My lord, this matter pertains to the Electricity Act, lordship. Firstly, secondly, lordship, the zone is it is a safe zone. It was earlier it was a critical zone, semi-critical zone. Presently, as per my instruction, lordship, this is a safe zone. And there are 3 zones, lordship. For my lord's perusal, these are the safe, semi-critical, and critical zones. In critical and semi-critical zone, this SWID permission is required because there is the scarcity of groundwater, lordship. But in the safe zone, lordship, there is no such scarcity. So therefore, the 200-meter rule that no submersible pump should exist between 200 meters of each other, that rule does not exist in a safe zone. Now, Pandua, lordship, this place belongs to a safe zone, lordship. Earlier it was semi-critical zone, presently it is safe zone, designated as safe zone. His primary objection is that the WBSCDCL should not give electricity to the private respondents. But lordship, since it is a safe zone, lordship, my lord may direct, we shall grant electricity, lordship, because there is no
until my lord
file affidavit.
Yes, my lord. Yes, my lord. Let them file. Lordship, because the Section 7, my lord, doesn't speak about the critical
decided
zones.
on affidavit.
It simply says, my lord, for extracting ground level water with the aid of machine or electrical equipment, there has to be.
You are appearing for whom?
I am appearing for the station manager WBSC, respondent number 8, lordship.
What about the other? They have some.
Sir, man.
Not appearing.
Not appearing.
Affidavit of service filed by the petitioner.
Lordship, one indulgence, my lord. By that time, my lord, the respondent authorities may be, particularly the electricity department, may be restrained from extending the electrical connection, my lord, for extracting the water. Unless and until, my lord, there is a valid.
I am giving short direction. Let it come in. Be kept in the record. Yeah. This court find that this petition is to be decided after exchange of affidavit. The respondents are directed to file affidavit in opposition within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on 20th November.
20th of?
20 November.
Deeply obliged.
Grateful, my lord.
Your Lordship, item number 33, I'm for the petitioner, Your Lordship. I'm asking for a day's accommodation, Your Lordship.
What is the matter?
Lordship, it's an NDPS matter, Your Lordship. We are
NDPS?
Yes, Your Lordship.
NDPS, why the writ petition?
Your Lordship, we are challenging the cancellation of this license, Your Lordship.
Cancellation of the petitioner, cancellation of the license of the petitioner.
They were having an excise license.
the poppy seeds were found, which was found. There was a notification they cannot have those things. There's a criminal matter pending. This is basically a matter camouflage to ensure that the criminal proceedings get stuck. Now this is the camouflage. But there's nothing. There's a single bench, division bench judgment on the same issue. Very issue. This is a.
Kindly keep it on to tomorrow, Your Lordship.
Tomorrow?
Yes, sir. Or any other day, Your Lordship.
I'll not come in the bench.
As per the prayer made by the counsel for the petitioner, let the matter appear on 6th November. Next.
34, my lord, I am for the petitioner.
Yes.
This is the affidavit of service, my lord. Issue is very short, my lord. My lord, the petitioner took loan from the bank, my lord. He paid the entire money, my lord. And thereafter, my lord, bank issued NOC. But the mortgage paper has been not returned yet, my lord. The original deeds and everything.
Lordship, the difficulty in this matter is before the matter was settled between the parties, there was an OA which was filed before the DRT. Lordship, during that time, in 2015, when the OA was filed, the practice before the DRT was that at the time of evidence, the original documents had to be
exhibited.
Lordship, they are lying in the DRT. Application has been made by the bank for retrieval of those originals and handing it over. Lordship, the bank is expecting that probably within 2 weeks or 3 weeks, the original should be
I am fixing on 13th June.
Lordship, may kindly fix it 2 weeks after reopening. By then, the
fixing on 13th.
Lordship.
The grievance of the petitioner upon the grounds of the petition that in spite of payment of the total dues, the bank has not released the title documents.
NOC issued already, my lord, in
Title
2022.
documents of the petitioner. The learned counsel appearing for the bank, Punjab National Bank submits that before the settlement of the issue between the petitioner and the bank with regard to the refund of the loan amount, an original application was filed before the DRT, and the bank has submitted all the original document before the DRT. Now the bank has already made an application, made a prayer before the DRT for return back the original documents so as to enable the bank to return the said document to the bank, so as to enable the bank to return the said documents to the petitioner. In view of the above, the counsel for the petitioner prays for 2 weeks, for the bank prays for 2 weeks. In view of the submission made by the counsel for the respondent bank, let the matter appear on 13th November.
I am for the petitioner, Lordship, conducting advocate of this case is not present. Kindly 1 day accommodation.
Why not present? What is the prayer?
He is in another court, Lordship.
Freezing of the bank account company, further respond authority to take immediate steps. You are appearing for 3.
3. Bank.
So why you want to freeze the bank account or defreeze?
They are defaulter with ESIC. Now what happened? We are victimized. The amount was taken out from our Nostro account. That is the dispute. They have a
Lordship,
dispute.
kindly 1 day accommodation.
As per prayer made by the counsel for the petition, case is adjourned. Let the matter appear on 6th November.
I am praying for an adjournment of the account. My senior engaged in courtroom number 15.
Same order. 6th November. Next.
Your Lordship, I appear for the petitioner in this matter. It's a very simple, short case, Your Lordship. The petitioner represents a flat owner's.
Just brought the simple and short case.
No. I will try to make it simpler for Your Lordship. Let me try. Your Lordship, the petitioner is an association. It's a flat owners association where there are more than 102 flat owners who are residing. Now, what has happened? This construction was completed upon fulfilling of all the municipal laws in 2018. In 2025, after 7 years, the airport authority, this is situated close in the close vicinity of the airport, has issued a notice that the construction is beyond the permissible height of the 2015 rules, so you demolish the part of the upper portion.
After
So
the
before-
Air India incident?
No, not after the Air India incident, much before that. This is, Your Lordship, in January and February 2025. So what I'm seeking today, I'm not asking Your Lordship to hear out the matter totally. Only an injunction order that no coercive action should be taken just before the pujas. Before the vacation, no coercive action should be taken.
Airport authority, we had
That is the only humble prayer.
we do not have the power to take any coercive action. It is the DGCA, that is the Directorate of Civil Aviation, can act on the basis of a show cause notice which has been given to them. Your Lordship, insofar as the no objection is concerned, we will reply to it. There are certain anomalies in the no objection itself because they had sought for the no objection certificate for a particular plot, and actually where the construction has taken place is 350 meters away from that site, which is much closer to the airport. As a result, the top elevation which is permissible has come down drastically. Your Lordship, this NOC is also valid for a period of 5 years. That 5-year period has come to an end in 2000. Long back. They have not sought for renewal of that, and the construction has taken place during that 5-year period, and thereafter the construction has been completed.
No, so renewal is not required. Construction completed. The completion certificate has been issued by the municipality. More than 102 flat owners have been residing in the property from 2018. Now, the fact is that the airport authority has issued this show cause notice that if you don't take steps, we'll demolish. Those notices are annexed. I am only saying that no coercive action. No coercive action.
I'll come back with the report after.
Let them file the report, Mr. Banerjee.
Yes, let them file a report. I have no objection. I am saying kindly consider prayer age. This will not prejudice anyone's right. This will not prejudice anyone's right because, Your Lordship, I tell you, Your Lordship, what has happened. The construction was made under the 2010 rules of the airport authority rules. Yes. Now we have sought for NOC from the airport authority. The airport authority has granted us the NOC, saying that this is the permissible limit. Thereafter, we have completed the construction. The report says that we are within the permissible limit. Now, in the meantime, after the construction, the 2015 rules has come into force. Now they are saying under this rule, you have crossed the permissible limit, so you have to demolish a part. Now, I have relied upon the 2015 rules, where there is a saving clause saying that anything done under the earlier rules that will prevail, that will not become null and void. So whatever the permissible height is under 2015 rules will not be applicable under the 2010 rules. Kindly take page 96 once. Page 96. It's very, very clear to you, Lord.
Yes.
Kindly take by page 96, clause 16. Nothing in these rules shall affect the height clearances assessed and duly issued under the notification issued by the Government of India in the Ministry of Civil Aviation by notification number validity period of 8 years. 12 years for travel as with the applicants have completed this structure. Now the validity period is 8 years, so we have completed it within 8 years. Now kindly see the NOC given by the airport authority themselves. Kindly take the NOC at page 156. This is issued by them.
Yes.
It's very clear. Kindly see NOC. The NOC is issued by Airport Authority of India in pursuance of the responsibility conferred under the Government Ministry of Civil Aviation Rules of 14 January 2010 for sale regulation of aircraft operation. This is the same rule which has been referred in the saving clause. Now kindly see the permissible limit. It has been given the site elevation 6 meters, permissible height above the ground level 29.5092 meters, permissible top elevation top 35.5093 meters. Now, it is not their case that we have violated this NOC or the permissible height under the 2010 rules. Now, kindly take the completion certificate, page 200.
200.
Page 200.
Yes.
Kindly see the completion certificate given by Bidhannagar Municipal Corporation, 27th November 2019. This is with reference to your notice of completion dated 20th June 2018 I hereby certify that the building, as per the plot description number such and such, in respect of which plan was sanctioned on 2nd April 2015, dated 26 May 2014, has been inspected with reference to the provisions of the building rules under the West Bengal Municipal Corporation on the basis and strength of the structural certificate. Thereafter, description has been given. The fire safety certificate for the occupation of the building has also been issued. This is issued by the executive engineer. Now kindly come to the notices. This notice is not applicable to me. The rules are not applicable. Page 146.
Yes.
Excess height 20th January 2015. Excess height of Lohaduka greens. Now kindly take the next page.
146.
146.
Yes, 146. The notice starts. Kindly take page 147.
Yes.
Second paragraph. This is also for your kind information that the site at which the structure building has been constructed is 57 meters away from the location of the site as per the NOC of 3rd March 2014, which was issued rendering the aforesaid NOC invalid. So this NOC have been issued by airport authority themselves. Now they are saying it is invalid in 2025. It is intimated that the Government of India wide notification, which is in terms of Ministry of Civil Aviation height restriction for safeguarding of aircraft operation rules, 2015, has notified about the restriction on construction and erections of structures for safe aircraft operation. Government of India by notification has entrusted airport authority for verification, monitoring and controlling of obstruction around the airport up to 20 kilometers and its vicinity for the aerodrome safeguarding. Airport Authority of India has identified structure top of the building, which is penetrating the obstacle limitation surface, obstacle-free zone, and is violating the norms of Ministry Civil Aviation height rules of 2015 and is a potential hazard for safe aircraft operation. Next one, it is hereby advised that the notice to reduce the obstacle height constructed in the building structure on the top of the building of 10.651 meters, 11.169 meters, and 6.85 meters in block B respectively. You are also advised to submit your response within 60 days. Now kindly come to the next notice at page 151.
Yes.
It is intimated that during the inspection of the surrounding area of airport, Kolkata by Aerodrome Safeguarding Team, it is found that your building named Lohaduka Green Residency exists in violation of the general standard regulations notified by the Ministry of Civil Aviation of Rules 2015 and are protruding the obstacle limit surfaces for safe operation of aircraft. In view of the above, the undersigned to hereby serve you a notice of the copy of the notification under sub-rule 1 as amended by the amended rules for your perusal and adherence. Now, the fact is that I have shown that the 2015 rules which they are relying upon clearly says that whatever has been done under the 2010 rules, this will not be affected. The height clearances which has already been granted. And I have shown the NOC granted by the airport authority themselves on 3rd March 2014 at page 156, where they say that the height clearance is under this rule. And this NOC was valid for 8 years. And we have completed the construction within 4 years. So we have already completed the construction. More than 102 flat owners are staying therein. Now, this 2015 rules does not have a retrospective effect. It clearly has a prospective effect. And the saving clause is there. So under these rules, they cannot take steps against me, but demolition of the building. They are saying that you reduce the top height of the building. If we do that, then 3 stories will already get demolished. The people who are staying at the top of the building, they will not have any place to stay.
What is the stage of the proceeding now?
Lordship, may kindly see page 156 once.
Yes.
156, your Lordship, is the copy of the NOC
Yes.
granted on 3rd of March 2014. The first condition at the bottom, Lordship, this NOC is subject to the terms and conditions as given below. The site elevation and site coordinates provided by the applicant are taken for calculation of the permissible top elevation for the proposed structure. If, however, at any stage it is established that the actual data is different from the one provided by the applicant, this NOC will be invalid. Lordship, later it was found that this NOC, the coordinates for which it was taken, is 350 meters from the site where the construction took place.
No, this is not their case, Your Lordship.
This is absolutely
This is
my
not their case. His case is that my height of the building is beyond the permissible
File
limit.
report. How soon you file report?
Lordship, within 2 weeks.
And I have also given photographs, Your Lordship will see.
Banerjee, let the matter come on 6th. I will see to that. Let that they file the report.
6th of
November.
Lordship, in the meantime, kindly consider prayer is not to take any coercive action.
No.
It's only that before the pujas, if any proceedings are initiated, they will be called, Your Lordship, not to take any coercive action.
The respondent
Status quo may be maintained. Status quo. I'm only praying for that.
report by way of an affidavit on 6th of November 2024 after serving the copy to the learned counsel for the petitioner. Let the matter appear on 6th November 2024.
Lordship, only status quo may be maintained, nothing else. Whatever the status is, that may be maintained.
6th, I will say let the report be
On an affidavit of service.
affidavit of service be kept in the report.
May I have your lordship's leave to mention one matter? Your lordship, in this matter regarding pertaining to excise, your lordship has passed an order where your lordship has given direction upon the superintendent of excise, your lordship, to grant the license. Lordship, the superintendent of excise is not the authority which grants the license.
He has rejected, that's why.
He has rejected, your lordship. But
no authority to grant, how he can reject?
Lordship.
Okay, who is the authority to grant?
Collector is concerned. Collector is the authority, your lordship.
So how he can reject?
On behalf.
What happened when at time the collectors are not the judges powers, that delegation is there. But the consent officer.
You are appearing for whom? Respondent?
The respondent state. Excise department.
However, the superintendent of excise, instead of superintendent of excise, collector. Collector of?
Concerned collector.
Record an order. The matter is listed as to be, and the matter is mentioned by the learned advocate appearing for the state for correction in the order dated 11 September 2025 and submits that in at page number 3, paragraph 1, line number 3, instead of the superintendent of excise, it should be the concerned collector. In view of the submission made by the counsel for the state respondent in the order dated 11 September 2025 at page number 3, paragraph 1, line number 3, instead of superintendent of excise, that shall be read as the concerned collector. This order may be read along with the order dated 11th line 2020.
May I be permitted to, with your lordship's permission, my lord,
Unlisted.
But may I mention serial number?
Mention is unlisted, boss.
And your lordship
for correction of the order.
Your lordship's permission, may I mention serial number 21 of the commercial list, my lord, the entry model?
Any no-affiliate side matter? Over? Okay, yes.
But may I? But may I pray for extension of entry model? The entry model is
which number?
My lord, serial number 21.
My officers all taken all the things here, nothing of the original side. Now I am in affiliate side. Yes.
But the last order.
Where any कोई है? कोई नहीं है. It is till today. Till 21st.
21st, my lord, that order, the printout is not there. It's expiring today. I have it in my lord, my device. Lord, 18th of. I apologize, my lord. I should have had the hard copy of the order.
18 September. कोई नहीं है क्या? इसको बोल दो. Extended.
वो लिख पे ना तो
extended till 13th November कर दो. इसमें लिख दो extended till 13th November. Matter remain in the list.
May I be permitted to mention?
Item number
21.
Item number 21.
Will it be my lord's pleasure to 21?
21 commercial, huh?
of the commercial.
Yes.
Lord, may I be permitted to mention a matter? Lord, the department is in some confusion whether I can file a execution petition without a drawn up decree. Lord, I have two judgments, one recent Supreme Court and one old. Lord,
Leave of the court.
Lord, even yes, Lord. Lord, I was seeking
But
Lord,
decree not drawn.
decree not drawn up. We have also already applied for. Lord, but the
So
judgment.
what is the urgency?
Lord, the assets, Lord, they will Lord, dispose of the assets, Lord. Lord, even Lord, Lord, there is no.
Leave. With the leave that you will file the decree in the
Yes,
meantime.
Lord, I have already Lord, prayed for that.
Oh, so
Lord,
that, well,
and without the certified
leave is
copy.
granted. Leave.
Ordinance.
Leave is granted. Leave is granted to file the execution petition without the certified copy of the decree.
Or the drawn up decree.
Without the certified copy and order of the decree. Order of decree subject to filing of the same in the meantime at the time of hearing.
Next matter, all parties are here. Item number 38 in the appellate side, the next matter. All parties are here. My lord's pleasure. Take up the matter. Thank you.
Today? Come on, 24. 25. 25. Come on, 25.